that we have remedy outside the code, and they agree we have remedy outside the code, and we tell you which codes you need to do to get back into your realm. That's why we use it. It's nothing more than common law, and it's listed in the code under color of law so that you can't figure it out. That's why they call it a code. I start out by telling you that I'm a Supreme Court Justice in Justice Township. I'm also a Supreme Court Marshal. I don't have my badge on today. I usually don't wear it unless I got one of them shirts with the sliding deal. I'm a Elizor in Justice Township, a Conservator of the Peace. I'm a Justice of Peace. I'm a Justice of the Peace. We are the titles of nobility in America. We're the kings. We're the King's Bench. This is a Supreme Court hearing. It's an ex parte hearing. One side only. We will teach you how to prosecute. If you're not prosecuting, you're defending. If you're defending in their courts, you've got a double strike against you. You will lose. We teach you the separation of the courts. It's what's known in the codes as peculiar jurisdiction. The word peculiar there meaning separate. Our law has always been separate. It's in the Old Testament. In Amos, you can read a quote there, and I use it for our friend quite a bit. It's an easy one to understand. It's pretty much correct. Amos 5:14 and 15. And it says in there, hate evil and love the good. Establish justice in your law courts. Perhaps the Lord of hosts will be merciful to the fragments of Joseph. Somewhere in the Bible it says that you're supposed to settle your differences quickly, otherwise you will be dragged into their courts. This is the church. This is the court. We do not have separation of church and state. We are the church and we are the state. This fact that I'm going to get into here at the start, it tells you what a tithing is. And I used to ask the people what a tithing meant to them. I don't ask them anymore because there's too many tapes out, and most of the people know by now. But we'll get into that a little bit. It's a hard concept for the people to understand that we are the Court of Quarter Sessions. That's nothing more than the 4 biblical months of the year where we were commanded to hold the day assembly. It's strange that even in the code books, that's these black code books down here, Montana Codes, that's 1991 version, I believe. It talks about 2 election processes in there. One of them's for the aliens, and one of them's for you. The aliens hold their primary in May or June on even-numbered years, and we hold our elections on odd-numbered years, and our primary starts in September. The people that wrote those codes knew the Bible better than you did. They understand full well what the battle's about. Statutes are for aliens. Statutes are for corporations. That's why they have to state the name person. That's who's liable to a statute. Person, not people. But see, there's a concept that people have forgotten. In America, and you can look in the National Constitution and find this, it says, we have a lot of people yelling about Article 3 courts, but they don't quite understand what Article 3 means. Article 3 is the judicial power. It says in there should be one Supreme Court and such other inferior courts. That one Supreme Court, in the original mode, is the County Commissioners meeting. That's how it was run 200 years before we had the Constitution. That's how it's run today. It's in the codes. I don't have time to show you all the codes where it's there, but for those of you that doubt this, then look in the codes and find out that county commissioners can issue subpoena dues to take them, subpoenas, summonses, warrants, and the sheriff must attend. The county commissioners of today, all they do is pay the bills and argue about subdivisions and a few assorted things. They do not understand law. They are the 3 or 12 justices at common law. See, there are no judges at common law. Just justices. Here in Montana, over in Silver Bow County, there are 12 county commissioners listed by their own listing. Not a one of them knows that they're Supreme Court justices. Doesn't matter if you have 3, 5, or 12. 3 is a quorum, just like the Bible said, and I have 2 or 3 witnesses shall a matter be settled. These are concepts that are in the codes. If you would never find this in the codes if you didn't know the root history of the common law. You have to go way, way back to study it. We went, at least as back far as Magna Carta, to figure this out. But we used the Bible for the recipe book and then saw if the codes match the Bible. Many of them do. But we're not subject to the statutes. If you read statute real carefully, just a few days ago we were getting into it a little bit, but in Black's Law, first edition, under the definition of natural law, it says statutes are positive law, which is the law of the Jew. Anybody familiar with the book of Jude in the Bible? Page and a half long. And in there it says, certain men have crept in unnoticed amongst you, evil and wicked men, from time immemorial, with their acts of licentiousness. And you go to the modern day preacher today and he says, oh, that means sexual immorality. No, the bigger sin is commercial. See, we're the salt of the land. We're the fresh water upon the land, and the bar is the high title mark to stop the aliens from invading the nation. America is a nation. It happens to be the nation of Manasseh. That's why the founding fathers created the symbol that they did. It's on your Federal Reserve note to this day, on the $1 bill anyway. For the eagle with the cloud of Israel above it with all the signals of 13. We are the tribe of Manasseh, prophesied in the Bible. The founding fathers knew it. And if you want some history on it, it's this book here, The Christian History of the Constitution of the United States of America. There's quite a bit of this before we had a Constitution, but that's still organic law. It came from Magna Carta, and Magna Carta was the biblical truths where the people were the church broke away from the king. That's nothing more than our people having broke away from administrative law. Administrative law in America is the false king. Go ahead.
Where could we get a copy of the Magna Carta?
It's in that, right there in that cabinet in the revised codes of 1947, which are still law today. It's in Volume 1, Book 1. There's also a copy here that I use a lot. It's a code on the Magna Carta. That's this one. This one's hard to read. I got this in the bookstore, Sandy, Oregon. CPA Books, Oregon. At Sandy, Oregon, they're now in Boron, Oregon maybe, or some other, maybe you people from Oregon know. Boron? Boron. Okay, I had that wrong. But anyway, are they still there?
CPA?
Yeah. That's where I bought this one. I don't know, I haven't been out there for a while, so I couldn't say, but these kind of books, you can still find them around if you know what to look for. This is a good book. I've referenced it a little bit into this packet. This is the one that's hard to read. It's Old English. The F's and S's look the same, just like the packet that you're going to look into. This Jacob Law that we're going to get into the same way. It's hard to read, but still there's good stuff in it. This is the book where I found out what presby really means. The writ whereby no free man shall lose his court. And then I found out that in the writ of presby, there's a writ of prosedendo. Prosedendo is venue, and venue is UCC 1-105. By their language of today, I'll get more into that tomorrow. It's called Territorial Application of the Act, Parties' Power to Choose Applicable Law. See, in venue, that's the most important concept that's lost in the Patriot movement, or haven't been found, I guess. Venue has two sides to it. One is geographical, that goes out to the county line, and the better part is the product of the land, that's you. And in proper venue, you pick only people of good moral character from your veneering, from your vicinage. Venue, if you study the word, gets back to veins. Because if you read in Webster's 1828 here, then you look up venue and then you start looking up some of the others related words, you find the word venereal. And the word venereal means white. So it gets down to the right of inheritance. I talk about that a lot. If you do not give up the right of inheritance, you have an exclusive court. In matters of right of possession of private property, you bring in the inheritance. God gave you command, come out of Babylon. So he did not leave a block. Otherwise, he would have lied in the Alpha and Omega in Genesis, and he would have lied in Alpha and Omega in Revelations. He did not lie. The answers are there. All you have to do is find it. When you reclaim the birthright, you will have the power that's needed to take down the enemy. That's what we've done. We've reclaimed the birthright. It's an exclusive hearing. The titles of nobility can't come in. Dan probably told you about Article 5, Section 26 in our Constitution here. The one that says they'll make no local or special laws. That's the prohibition against titles of nobility. But what the system is counting on is that you will not make the laws. That you won't make the rules. Most of you have. How many of you know how to run a county commissioners meeting? How many know the importance of writ of quo warranto? How many know what quo warranto means? Quo warranto can be used against corporations. The Latin means by what authority or by what warrant.
Question quo warranto, looking into a book which was American English annotated cases 1916, gets in the quo warranto and venue of join your parties. And it said in there that if you attack a corporation directly, you move your case because you're admitting they exist by addressing them. So it's necessary to go after the agent actor who's outside of his authority to make him prove the standard of the corporation. Is that
That's right. Well, right now, under administrative law, they call it delegation of authority. When I used to live in Washington State, I had a goon come down from one of the agencies, and we said, "Where's your delegation of authority?" We ran him out. It incensed him, but we still beat him. See, one of the most important things to get in your head is by what authority. That's how you should start every pleading. Ask them, and then command them. Don't just ask. Go with mandamus, which says we command. You cannot be denied the writ, all the extraordinary writs. We don't get into teaching those writs and how they work. That's too lengthy. We teach you concepts here so that you can go back and do it. That causes a lot of phone calls in the future. People call back, well, what do I do now? Well, you're going to have to do some study on your own, because I do not have time to answer all the phone calls that come in. I make them very short. I'm getting a bad reputation, but that's okay. Nevertheless, I have a reputation. I'll give you a fair shot at it if you'll do a little study. When the people come back to me and they're asking questions that they've missed here in class, and I tell them you're going to go to sleep during this part, but that'll be tomorrow in the protest section. That's when they don't get much help. But we're not trying to belittle anybody. We're trying to cut some corners. I've been at this for about 20 years. The last 5 or 6 years have been total. And the last year, about 95, we found most of the answers that where we really broke through. And it's after we found the Supreme Court in the county, when I finally realized what tithing meant. We are the church, we are the state. We self-govern, you don't have to ask permission. There's one little courtesy that you should do. The elected Hardings that are out here, you give them first chance. You go in there and you say, do this. If they don't, you move them the alternative. That's called Magna Carta, Chapter 61. 61 is one of the longest chapters, but what it really says is, when we are out of the realm, we admit that all our acts are null and void, and therefore you get to move, and we can hold you harmless. That is synonymous with the National Constitution at Article 6, Clause 2. And 6, Clause 2 says, the Constitution is the supreme law of the land. The judges are bound thereby, anything to the contrary, notwithstanding. It's just like running a ranch. If you own it, you're the principal. Then you tell the agent what to do. We have forgot to tell the agent what to do because we didn't know we were the principal. When you elect someone, let's use the word commission. When you commission a county commissioner, who's the principal and who's the agent?
That's the agent.
We're the principals.
That's right. How many know how to go in there and run the meeting? Under the concept of quo warranto, you go in there, there's 3 of them, most counties have 3, take 4 men in there that are well versed in law. Those commissioners took the oath to Chapter 45 of Magna Carta whether they know it or not. And 45 says, we will not appoint such sheriffs, justiciaries, or bailiffs who are not well versed in the law and well disposed to keep it. Ignorance of the law is no excuse. And this is how we start our lien process, under that principle. Because we quote UCC 1-103, which is contractual law and admits principal over agent and the law of contract. That takes you out of the code, puts you back at common law, because the prior law was negotiable instruments law and it recognizes common law. And there's nothing wrong with the law merchant as long as you know that you own your realm in your nation. The nation I'm talking about here in America, if you read For Our Repentance Bible, means race. And I have not given up the birthright. That's why this works. You see, anything the system does to me would violate Article 1 of the National Constitution, freedom of religion. That's why it's exclusive. This here is exclusive.
Being that in the 43rd Congress, there's record of the legal relations of the District of Columbia as being a church intended for national purposes, and therefore, in their realm, the separation of church and state is a moot argument, and they're violating all our religious rights.
Okay, in line with your concept there of the District of Columbia, why do you suppose we have the 11th Amendment? The 11th Amendment blocks United States slaves from bringing an action against the state. You cannot invoke judicial power. Why? Why couldn't you? Because United States district courts are created by the Legislative Assembly. And legislative created courts are voluntary in nature because they're all appellate. There's only one binding court in America. That's the original and exclusive jurisdiction of the Supreme Court. That's the only binding court in America. All the others are voluntary. Because we have no debtor's prison in America. And I'm talking about American nationals, not slaves. See, a legislative created court can't issue process. They get around it by issuing a notice to appear, and that's a courtesy to a corporation. The word person, individual, all that is corporate only. If you think these people haven't pulled it off pretty well, then study your codes carefully and get the compiler's comments like we did, which are on the CD-ROM disk. And you'll find out that, let's say you get drug into one of their chancery, nese preas, black robe courts, and the officer says you've been charged with the offense of. What do you suppose the word offense means there? What do you think he's talking about? It means removal from office. See, there's no one that... We found the difference where it says offense, being charged with the offense, and accusation backed by affidavit are two separate things. And everybody sucks into that. Oh, well, I'm going to defend here. Well, the minute now you breathe life into the fiction. You must study and go back and follow the compiler's comments. That's where the confessions are. That's how we got this thing turned around. We got 85 pages of fraud where the compiler's comments said, well, we changed this to this to this. We changed Supreme Court from Supreme Court to Superintendent of the Banks. We changed Supreme Court to Department of Commerce. We changed the Clerk and Recorder to Supreme Court Administrator. We changed Governor to Government, or no, the other way around. We changed the word government to governor. We changed the word unlawful to lawful. Goes on and on. We put that in front of Congress, and right up few days later, Newt Gingrich was on public television, this is right after the election. He said, we are going to give the government back to the people. He said, we're going back to a bicameral form of government. We're the ones that told them, you're operating under a unicameral form of government and cease and desist. And they have. For those of you that know, you can't be questioned when you self-govern. That's why we haven't been raided, and we won't be raided. This is the Supreme Court. Original and exclusive motive. They raid us, we arrest them, and then all the truths come out. Because every one of these videos that's going on now is my habeas corpus. Just to know. Okay, let's get into the packet a little bit. This takes about 2 hours, and I don't normally talk about all those, kind of give you some concepts there, but it'll take about an hour, take a break, and then we'll finish. And I go through this fairly fast. If you have questions, go ahead, but my answers will be short, and we just keep moving right along. Okay, on that first page there, this is Giles Jacob Law Dictionary. It was given to me by a friend from Seattle, William Smith, and it's in a 1729 year. The part I underlined there was justices of peace, and that's for a reason. These justices of peace are all the good and lawful men in the realm. That's you.
What page are you on, Leila?
On the very front. Where it says justices of peace. See, it does not say justices of the peace. When you appoint one of your fellow men, he becomes the clerk. He becomes the keeper of the record. Now you've got a court of record. And then he's executive in relation to you. This is why when you appoint a justice of the peace or a constable, they can't buy into the judgments because they'd necessarily be biased and have a conflict of interest. Also, they can't take the state salary. See, our justices of the peace would have to put a bill of costs in to the action, and they get paid at the court of quarter sessions after the action's over, so they cannot become tainted. That's still in Title 28. Lots of good codes in there where they tax the cost, and the people can't understand that's Commonwealth code. They've mixed them up so you can't see it. Okay, page 2 there, the word comitatus. It says a county, and it was divided into hundreds, these again into tithings. Then that next definition, it says sometimes it's taken for a territory or a jurisdiction of a particular place. And I wrote the word precinct. In Montana, they call them precincts. But they go back to the law of Moses because they're still ordered up by census. There's about 400 people to every precinct. And there's a mandatory provision in the Constitution in Montana for 2 justices of the peace and 2 constables in every precinct. Okay, so now you're back to the law of Moses. 1 per 100, 1 officer per 100. If you read in Black's Law 1st edition, not first, no, the 5th edition, on the word precinct, you will get almost identical meaning as taken here, and it says the district of a constable. Now in Montana, in the statutes, there is no provisions for election of constables. But yet the Constitution says it's mandatory, there's 2 in every precinct. And this county here, I think, has 8 precincts. Well, if they don't have an election process, how do you get them? That's right. So, appointed. See, the Legislative Assembly can make no local or special laws respecting our courts of justice. They can't do it. They can't say this is how you do it. Another little known thing about the difference between the constable and the sheriff. The sheriff, the word came from Shire of the Reeve. He was the groundskeeper. He was the tax collector for the king. The constable was the one that wore the gun. The constable was the one that called to arms. That's why you have mandatory many more constables than you do have sheriffs. That's so we keep him in line. Okay, let's go to page 3. In the upper left there, a little bit about the court. It says a county court, a hundred court, or court baron. They were of the court of record, which is the king's court. The rolls of the superior courts of record are of such authority as no proof will be admitted against them, and they are only triable by themselves. That part, only triable by themselves, is what I'm talking about, exclusive jurisdiction. Chapter 24 of Magna Carta, in most versions. Now, Coke and the regular versions here in the book are two, the chapter numbers don't match. That doesn't matter. But chapter 24 in most Magna Cartas says, will not have any sheriffs, bailiffs, justiciaries, or any others of our hierarchies who hear matters of the crown. You see, otherwise you couldn't have separation of powers. When you appoint someone, he's executive to you. We're judicial. Even in the statutory realm, where the district court pulls up the grand jury, is it true that the grand jury can kick the district court judge out of the room while they hold their hearing? Yes. Then who's the king? The people. Isn't it true that chapter 38 of Magna Carta says will not have any bailiff on his own bare say without two credible witnesses that will move the court? Separation of powers. So then when you get an information filed against you by the executive agency, that's a nisi prius order. It's a legal fiction. Can't happen to a sovereign. Otherwise they're not in compliance with Magna Carta, and they put the agent over the principal. Okay, that's what's known as public policy. It's also known as limited liability. God didn't like limited liability. He said if you want to worship Baal, then you will sink in the Admiralty ship. For we caused a wreckage of the Admiralty ship because it's run aground on the high tidal mark. We have taken the land back. We own this land. I'm talking from the country of Montana, not the state of. That's a foreign jurisdiction. If you think the other side isn't rocking real a little bit, about 4 or 5 months ago, somebody purporting to be the comptroller of the United States called me over at the cabin. And he said, your name's Schweitzer, isn't it? I said, yeah, that's right. He says, what's your zip code? And I said, I'm in the country of Montana. We don't have a zip code. He was trying to create the prima facie evidence of silent judicial notice that I'm in their realm. Okay, this only triable by themselves that I was on page 3, that's your exclusive. If you think that it isn't true, how many know about the Ensminger case? And the Johnny Johnson case, right behind it, in Waxahachie. That's where the 10th Circuit Court ruled that the people did speak in their original exclusive jurisdiction. And in the Ensminger case, Warren Ensminger, Dennis Smith, had quoted Supreme Court rules, other jurisdiction, I'm talking Title 28, Rule 17.1. And that rule says, you can bring in the 11th Amendment, you can bring in the All Writs Act, you can bring in Article 3 judicial power, so then what else do you need? That means it's exclusive. Nothing created by the Legislative Assembly can trespass into that hearing. That's where you got to show. Remember, taxes nobility can't come into our courts? We have a very high court in statute. It's called the King's Bench on the equity side. Anybody know what the statute name for that is? And some of you that were here before, you don't get to answer. I already told some of them. Anybody know? Anybody heard of Small Claims Court? Why is it the King's Bench? Because it says right in the codes, you do not have to be a lawyer to be the hearing officer, and the hearing officer will help both the plaintiff and the defendant, and no lawyer will enter, and no corporation will enter. And the way they trick you, they say, oh, well, that's only up to about $500 or $5,000. It is, except for one exception. When the matters of right of private property are at issue, the sky is the limit. And in Montana, at the Judge's Bench book in 1982, they quoted Cashman versus Vickers And it was a case that said, when the right of private property is at issue, the sky is the limit. You do not have to follow anything that the Legislative Assembly puts out there. The reason you're following now is because you didn't put anything out there and tell them this is what you will follow. We failed to set the law. Yet I'm going to show you some codes in this book that says you must make the rules. Well, we did.
What's the legislative assembly good for then?
What are they good for? Slaves. They have little or nothing to do with the people. We need very little government if you self-govern. You have the exclusive right, so why would you have about every other body in America working for the government? If you had done it yourself, you wouldn't need them. And you darn sure couldn't be compelled to pay their wages. But you lay back and give them a half a chance, guess what they're going to do? They will rule every aspect of your life.
Buying and selling.
Let's go down to the bottom of page 3 on the left. There's a little bit about, let's read those 4 last lines. It said, if a court having no jurisdiction of a cause depending therein, do nevertheless proceed, the judgment in such court is coram non judice and void. Don't have what?
Where did you read that?
Bottom of 3 on the left side.
Some of these might be tomorrow's session.
They're out of order?
This is page 3, but we don't
Okay.
know what you're reading.
That's right.
Okay, you've got one of the older packets then. It's in, because we did change the order a little bit. I've got more packets out there. If you can read along for now anyway, for those that are taking it. If your packet doesn't match what I'm reading, you can get the other one. You can have, we've got others, so that it'll match your videos. Okay, this coram non judice means you have no jurisdiction. If you're,
What are you on now? What were you doing?
I'm still on that bottom 3 that I'm missing. But I was drug into the Mesa Creyas court for purportedly willful failure to file. And the black robe chancery priest said, how do you plead? And I said, plea in bar, coram non judice. He says, well, I'm going to enter a plea of not guilty. And I said, I object and I take exception. You're not my attorney. And that was the end of that. And about 8 months later or so, the chief federal judge that tried to persecute me put a little note in. He sent me an order and he said, Schweitzer has me sued, therefore I can't sit on the case. And he just as well have said that for everybody, all the federal judges in America, because I haven't given up the 11th Amendment. There's not a federal judge in America that can hear my case, because I won't grant the venue. I'm the state, in fact. It gets very expensive if they try to stick their nose in my business. At this point now, it's about $5 billion a whack. I used to start with $100 million.
You check that room enough for all them zeros?
I'd be proud of it. Page 4, bottom left of page 4, the word tithing. It says, in its first appointment, the number or company of 10 men with their families held together in a society, all being bound to the peaceful behavior of each other. In the Saxon times, they were for conservation of the peace, for administration of justice. Every 100 was divided into 10 districts, or tithings. The lesser causes, or the greater causes were heard in the whole 100, and the lesser causes in the tithing. That's exactly the same way in America today. The lesser causes are heard in justices' courts, and the greater causes are heard in the county, except that you'll be tricked into going into the district court. But you do not have to go into the district court. You can remove for cause into the Supreme Court in each and every county. This is where you miss it. And you do that by writ of procedendo, which is the second half of precedent. Okay, let's turn the page to 5. This is on Magna Carta. Just a little thing I pulled out of there. It says, the court baron, which consisted of the free tenants only, and met in the Lord's Hall. The word meet also signifies a law day in several of the ancient English statutes, the affairs connected with them having gradually devolved upon the quarter sessions. Now the quarter sessions is the county commissioners meeting. It was mandatory back in the earlier days, 4 times a year you would hold the King's Bench. Now they go to like weekly meetings at this time. The concept is still there because the statutes still call for the JP and the constable to turn in their salary requirements, their bill, every quarter sessions. It's still there. All the laws there. Look it up. But you got to know the history. You wouldn't know what to look for. Each county was divided into hundreds, containing 10 towns, and each of these was again separated into 10 families of freeholders, called a tithing. The heads of which reciprocally became bound and responsible for each other, so that of every 10 householders throughout the kingdom, each individual had 9 pledges or sureties for his good conduct. See, this is where we rule. Venue, Venere, is the King's Bench. You can't be denied that. They hide it in the codes under the words disqualification for cause. What it really means is change of venue. And I've got the proof in the packet here to show you that one a little bit later on. Okay, go to page 6. The word constable. It's a Saxon word, compounded of coning, example, king and staple, which signify the stay or hold of the king. It says that power was anciently so extensive that sometimes since that office hath been thought too great for any subject. See the fear of the office back then? When we first started this, practically 2 years ago, Warren Ensminger was subpoenaed in Oklahoma by the Nation Press courts, corporation courts, the aliens courts, and they said 4 or 5 times in the hearing, what is the constable going to do? The minute you want your country back, all you have to do is do it. Just start governing. We started Justice Township by co-ad hoc committee. Ad hoc, for short. That which is. It's done. The law in relation to this is done. Do we have the 10 Commandments? Do you want to enforce them? Why don't you hold a church meeting? Call the tithing, call the tension, call the precinct meeting. Just the names have been changed a little bit so you wouldn't see it. It's what's known in statute today as Special Study Commission. And it says in the statute, and when you pull up this hearing, no public hireling shall enter, and about 15 men shall hear the matter. It doesn't say men, but at common law, the men are the assembly. See, the people don't realize that the county commissioner meeting is a church meeting. Back before we had a constitution, when if somebody would blaspheme in the assembly, they'd lob his head off. That was church. Go ahead.
Or just getting to all the empty Grange halls across this country, that originally was where these were held.
Okay. That could be where they're held. I've done a little bit of study on the Grange, and it was taken over by masonry, the meetings. But that's not to say the concept wasn't there before. That's right. Everything was local, such as the election for justices of the peace were held in private homes. The provision is still there in the codes to hold it in private homes. It gets to this point. Let's say you were going to have election for justice of the peace, and you didn't want to follow their statutory forms and things. Who is going to be the election judges then, if you held it at your home, in your precinct? Who would be the judges for the election, candidates, the election? You're going to have to appoint a couple. We've got old codes here and old lawyer opinions and case opinions that say, and if the two judges that were selected that day didn't show up. The other two would swear each other in, and then they hold the election. So where does the law start? It starts with you. Right directly under God. That's where the law starts. And we hold the aliens at bay. Okay, let's go to the next page, page 7. A little bit about the arrest, how to make a citizen's arrest. That's still in the codes to this day. And beware of making a citizen's arrest if you're still in the realm of the United States slave, because then you go to prison. You better be sure that you're American national before you do it. You better be sure that the other side knows you're American national before you do it. And you better have about 10 other guys there when you do it. That's why we seized the camera. We knew what we were doing. That was seized by grand jury. And when the people went around the town and said, well, we want to complain, these people stole this property, the sheriff put it out in the paper. He had 14 better things to do that day than take their complaint.
He wrote that in the
It was in the paper. But he doesn't, the funny part about this sheriff that we got here is real low on the totem pole of thought process. But anyway, he takes orders from a county attorney. He didn't think that up. The county attorney says, don't stick your nose in that. We're already in such deep doo, we'll never get out.
You heard that part of their duty is going to be cleaning out the inside.
Okay, on that page 7, down at the bottom left, there's a little bit about nature and cause. It says if the justice sends his warrant and they hold the matter, and it's not lawful what he does, then he's liable for false imprisonment. This is what they're doing today. They're dragging you in under false warrants. But see, that's color of law warrants because they deem you to be the slave that asks for public policy and limited liability. If you can't break that presumption, you get sunk in their little admiralty ship.
There's a section 28 CFR 35.104 and a subclause under it's Disabled Rights Act, and it says you have none of the impairments listed above, but you are disabled only because of the way the public entity treats you.
That's a subtle way of saying you've waived venue. That's right. All the avenues to come out of this thing are in the codes, but you'd have a hard time showing the other side. How many people quoted as remedy Title 18? How many quoted? Oh, I'd like to charge you under 241 and 242. I used to. Title 18 is restricted to military bases. Section 451. All United States codes are for United States citizens. They only talk about the exceptions for the American nationals. Then they ain't going to tell you what the exceptions are. They let you figure that out yourself. Turn the page to page 8. We've got people teaching in America that refusal for cause, non-statutory abatement, that kind of thing. That's all well and good. That's only half the action. That's still a defensive move. After you do all that, you do it right, then you have to remove for cause into your venue. The removal for cause is done in 3 ways. It's done by certiorari, writ of habeas corpus, and writ of privilege. You can use all of them to aid the other. You've heard, those of you that study law, a little bit of says certiorari and aid of habeas. Removal for cause is change of venue. The lawyers say, well, you get 1 or 2 choices and that's it. At common law, you have 12 choices, unending, until you fill the bench. Both civil or criminal. Because in our courts, we have both civil and criminal jurisdiction at all times and it cannot be separated. Little known concept. If you want to retain both sides of the court at all times, you allege forcible detainer, unlawful detainer, libel, and slander. Those are necessary elements to uphold the birthright. Once you do that, you have both civil and criminal jurisdiction in any hearing that you're in. If you doubt that, then look in the Constitution where it says, in libel and slander cases, the jury shall hear both the law and the fact. And what have they libeled? Your status? No. They've libeled your character. God gave you the character. The word status is not even found in Webster's 1828 dictionary. The word means state of us. It was created by acts of Congress, who created, through licentiousness, a second-class citizen that they could control and extract taxes. Because before that, in Bouvet's Law Dictionary, prior to the Civil War, that's these two right here, it said, and the free white 21, the man at his own option was not subject to property taxes. You only tax slaves. Remember in Matthew 17 where Jesus was talking to Simon Peter and he says, who do we tax? The sons of Abraham or the strangers?
Yeah.
See, you can lend usury upon the stranger all you want to. That's the duties, imposts, and excises. But you don't lend usury on thy brother.
So doesn't he go on and say, therefore you're free?
Therefore you are free. The sons of Adam or Abraham are free. See what we're doing when I just tell you about our defaults tomorrow, the nihil dissect personal judgments. We're taking the sins of the stranger, getting a judgment on it, and then turning it in for special collection. That's called set-off, counterfeit. Don't they yell out in the will failure to file? The U.S. attorneys stand up there and say, looky here. He didn't pay his fair share. That means all you have to pay more of your fair share. Well, they can't say that about me anymore because I'm paying their fair share for them. They wanted so much for my fair share, we're giving them my fair share. There were two people here. One man, his wife wasn't with him. He owed, allegedly owed $15 million. She owed $5 million. We wrote him out. He got $30 million. She got $10 million. That's how much fair share the slaves got. And so now, when they go down and all their stuff hyperinflates while we collect the revenue back, we tax the strangers that much more, we buy the gold and silver with the excess, guess who runs the country? That's what we're doing.
The third means for removal of cons.
Writ of privilege. It's in this packet somewhere. This stuff's not quite in order. If I was to show you what the writs are, there's a little bit here and there.
When we use a set-off, is it to be termed, still be termed an equitable set-off because they're in equity paying?
It comes under the doctrine of estoppel. See, they have caused your demise. I'll get into the explanation of that tomorrow, but in short, what they're doing is the law does not require impossibilities. They're saying pay. And you say, I love to pay. But you're blocking me from paying. That's estoppel. This is how you win. You can call it collateral estoppel, you can call it equitable estoppel, you still win. Because all they admit in 3-103 there is no money. They also admit there are no documents of title.
I used that strategy a few months ago. Some cop came down to my basement apartment to arrest me, and I told him, I laid out for him and said, guys, I don't want to become a complicit member in a criminal act.
That's right. If you understand how they wrote that code, you got them in Catch-22. We tendered their sin back to them, say, it's like this. In the Speed Elliott case, Oklahoma, a bankruptcy case, I put $2.8 million in there as the bond. The judge saw that bond, he said, this is a good tender. He said, I'm not going to get stuck with this bill. He ordered all the property given back to Speed Elliott. What they didn't say was, the bank's already sold the property, now it's up to Speed to get it back from the bank. The judge jumped ship real quick there, because it was a hot potato. But let's say it's a traffic ticket, and I've got $1 million lien on these guys. So I tell the judge under writ of Pesky, I say, Judge, would you pay these guys? I don't want to be adversarial about this at all. I'll give them their $500 and bring me the change, because I have to buy some groceries on the way home, and I might eat $999,000 worth of groceries. See, they have moved into the position of superintendent of the bank. They're nothing more than debt collectors in there, operating for the Sadie Quay Trust, which is the bankruptcy trustees. So fine. In bankruptcy, the concept is this. If you're the debtor in bankruptcy, you can't state a claim, but the creditor can. How many of you have credit?
Oh.
Have you got it perfected?
Couple airballs.
All right, on page 8. Oh, wait a minute. I want to go down here to, on the bottom left, county court, the word county court itself. It's called Curia Comitatus. If you look in Coke on Magna Carta, this one, it says county court is explained as the comitatus. And then you look up the word comitatus and it's synonymous with retinue in Latin. And retinue, at the end of the packet I got the explanation what it really means, but it means in-law, the family, the king's family. Okay, on 8, about halfway down, it says, no sheriff is to enter in the county court any plaint in the absence of the plaintiff, nor above one plaint for one cause on pain of 40 shillings. The defendant in the county courts have lawful summons, and 2 justices of the peace are to view the streets of sheriffs before they issue them out of the county court. Here is Magna Carta, chapter 24. It says, they'll not hear matters of the crown, reserved to the people alone. Okay.
That means pain of 40.
40 shillings?
Oh, 40 shillings?
Well, that'd be the liability on him. That'd be like, in the statutes now, we got $100 for a delinquent who violates his oath, and the county attorney's supposed to get rid of him. It didn't say the county attorneys to become another delinquent, but they have. Okay, next page, page 9. About halfway down on the left, it says, the steward is the judge of this court, as the sheriff is in the term, and he hath power to elect officers as constables, tithing men, as well as punish offenders. The steward there would be known as assistants of counsel. And you can get almost the same definition. If you look in Black's Law, 5th edition, the word of counsel, they just hid the word assistants to throw you off track. How many know amicus curiae, what it means? That's the steward that they're talking about here. Did Dan tell you that under Rule 28, is 28C, where the lawyers can't take depositions? Guess who the steward is in our courts? The notary. That's right. Notaries take depositions. He's your assistant of counsel. This is how you beat the Black Robe priests in their courts. Let's say they drag you in there. And they say, well, if you don't show and so such a date, we're going to get you for contempt of court. Well, you send the notary down with your affidavit. Now you don't grant in persona. Didn't the Bible say that we had to communicate with our brethren? And if you don't know it, then we perish together?
There's a passage in the Bible that says, if you walk into the court accompanied by your adversary, pray that the judge goes easy on you.
But how about if your representative, not representative, but your assistant goes for you and says, he isn't here today, Father. See, he can break their in rem attachment there, because what he does is goes as the statutes, how they disguise it in statutes, called private interventionist or intervener. Okay, right below that it says, through such presentment may be removed into Banco Regis. BR there is Banco Regis, means King's Bench, by certiorari. Over on the right-hand side, the lowest part I've got marked about center of the page, it says the plaintiff is to declare and set forth the cause of his action, and afterwards proceed to issue and trial by a jury, according to custom of the common law courts. If the cause is considerable, is usually removed into banco regis by an habeas corpus cum causa. You cannot be denied the right to have habeas corpus heard in the original jurisdiction. In Blackstone's commentaries, that's these books right here, it says in there that writ cum causa is called habeas corpus, the great writ, ad faciendum, subjudiendum, et recipiendum. The words mean to do, to submit, and to receive. When you can compel them to do all that, you have an exclusive hearing. You have to take it to the King's Bench in the county, then it becomes exclusive. Then you get to pick the venue, 12 just us's. Guess who wins? Unless you've committed a common law crime. But you darn sure can stop administrative proceedings. This is how to get out of their realm. I have on the discs the procedure for doing this. It's called the Hague Step. The document I named it Hague Step. It's 30 pages long, 15 steps. Take you out of their realm, drag them into your realm, and they are not going to show. I'm pretty sure they're not going to show up. Now you got the King's Bench warrant out on them. Then there's only one other thing left to do. That's enforce your warrant. That's why we don't have many aliens coming to the township. They circle around the edges as a mad dog.
And in that part, the Bible said the dog had returned to his own vomit.
Right. Okay, a little note on this one where the plaintiff sets his cause. A few years ago, I pulled up a habeas corpus over in Gallant County. I used to live in Bowling. And the smart-ass judge thought he was going to trick me. Well, I had 10 questions listed for him. And I got into question number 4, and he ran out of the room. Took almost everybody with him. But the thing was, he was yelling out toward the last, and he says, "Is Leroy Schweitzer in the courtroom?" And I said, "Are you testifying or are you prosecuting?" See, the thing is, if you, under a complaint and affidavit, the executive officer can't move the court. Remember Chapter 38 of Magna Carta? Bailiff on his own bare say, he can't start the thing. The accuser has to start it. Well, no accuser, I won the habeas. The city attorney was sitting there, and he walked over to the woman doing the typing. She didn't know what the hell to do. I yelled out, "Call the sheriff, call the sheriff." And this guy goes over and says, "May I have permission to wait?" We didn't invite him. He could have left a long time before that. I wasn't going to join issue. Okay. We've been in here over an hour. We're going to take about a 10-minute break, and then we'll finish the package.
Clarify that last statement you made, Mark.
All right. Not quite everybody's here, but we'll start anyway. They can funnel in when they want to. On page 2 of the packet, the word "prosi comitatus" means the power of the county, all the men above the age of 15, and their authority is to suppress riots and keep the peace. Now, the part I want you to notice there, where that arrow on the left side, it says, "And persons refusing to assist the sheriffs," that's plural, "or justices of peace herein may be fined and imprisoned." So you've got an "or." Let's just think about it as justices of peace. Who would that be? Conservators of the peace. It says in the California Constitution that every Supreme Court justice is a conservator of the peace. Every notary public is a Supreme Court justice. Every justice of the peace is a Supreme Court justice. That's why all the exceptions in the codes that say only the justice of peace can hold more than one office. He necessarily has to hold more than one office because he's the one who does the commissioning. The law starts somewhere. Do you have the chicken before the egg? Where does law start? Who started the first oath? Who put somebody in an executive capacity? You always retain the power of the justice. You are always the justice. That's why they have justices' courts, plural, with the apostrophe on the right-hand side of the S in the old book, Black's first edition, and now in Black's fifth, they put the apostrophe between the E and the S, and they singularize the word court. They want you to think that it belongs to the Legislative Assembly. No, our courts are always plural, 12 in number. That's why they were never numbered in Magna Carta, because it was known quite well by the people how many it took to create a court. But also, a court can create one or more public officers. Let's say there's one public officer, and that's the court. Now, who would that be? The clerk. The clerk makes it a court of record. Why does it have to be a court of record? Because it ties to ownership of land. This is why when you file an action in a district court, which our legislative assembly created, which in Montana were known as probate courts until we went from a territory to a state, probate's always voluntary and it's always surrogate court. If you're in that court, there's silent judicial notice you're awarded the state and therefore they move against you. That's what's known as public policy, limited liability. If God said, if you want to follow God, do so, you can worship God or Mammon. Mammon is Baal. Baal is statute. It's based on license. License is forbidden by God. Anybody ever read about the definition of marriage license?
Oh, that was
Regulating intercourse between enemies under emergency war powers of the federal bankruptcy. House Resolution 192.
See, the license is a voluntary act. It's based upon consent. Doesn't it say that the Constitution that they can't impair the obligation of contract? Well, then did the hiring contract to you? Then can he do anything that you said he couldn't do in relation to the contract? How many of you put a lien on? Remember, in the Montana Constitution, it says the Legislative Assembly will not create any laws if creating liens. You see why they can't block us out with the UCC?
There's a clause within the ADA that says the public or private entity can do no unlawful act via contracts, licenses, or other agreements or arrangements.
Right. The license has to be voluntary. Otherwise, the whole licensing structure would be, if they compelled you to license and made it mandatory, it'd be repugnant to the Constitution.
Isn't marriage license mandatory? Isn't a marriage license mandatory?
No, it is not. Only for aliens.
Same criteria applies to all licenses?
All licenses are voluntary. You can't be compelled into contract in America. We didn't tell them they had to be a public army, but when they are, what do you think the founding fathers meant when they said bind them down with the chains of the Constitution? That's contractual. We'll show you the concepts of contract in UCC 103 tomorrow. That's how you win. Contract law. God made them both. Man's worthy of his hire. Uniform Commercial Code operates on the principle of good faith. So we're feeding them some good faith. Billions of it. Okay, on page 3, no, not 3, page 11, I got that marked. Turn the page. The writ of Procedendo there, I'll talk a little about that. It's a writ which where an action is removed out of an inferior court to a superior, as from the Chancery, the King's Bench, or Common Pleas, by habeas corpus, by certiorari, or writ of privilege. There's your way to remove, for cause. If you look on that exactly off to the right there, it says, Procedendo ad judicium lies where the judges of any court delay the party, plaintiff or defendant, and will not give judgment in the cause when they ought to do so. I thought I'd really found something a few years or so back in Montana Territory of Montana First Legislative Assembly, batting statutes they call this. And in here it says speedy trial is 3 hours. If the plaintiff delays beyond 3 hours, the defendant is set free. Well, that's also found in these black books down here. Under, I believe the code is 2735/7. Identical code. How many of you read and found out that when you get thrown in the jail, especially justice's court, just the peace court, that they can only hold you for 24 hours until the plaintiff put up the money for the motel room? Anybody found that statute? Yes, sir.
I didn't want to hold you, but that's called holding for 24 hours without cause.
That's in the, well, until somebody else puts up the hotel key. The plaintiff has to put up the room. Okay, in the statutes, why do you think under criminal jurisdiction you have to bond the action? It's a contract court. Does the United States District Court have criminal jurisdiction?
All matters start commercial, so there can be no criminal.
There is no criminal jurisdiction in legislative created courts. Criminal jurisdiction reserved to the one Supreme Court. Inferior tribunals are contract courts. How could you have criminal jurisdiction? The criminal is under admiralty because you consented to license. God said, if you want to be confused, so I follow bail.
Presumably, the code federal regulations all crimes are commercial in nature, and when the disputable presumption is broken, they in fact are the individual persons who committed the commercial crime.
That's right, so you become a joint tortfeasor by entering into the realm. Breathe life into the legal fiction will eat you up. Never traverse. Always demur. They say demur is a good polish, Rule 7C. That's for aliens. Read UCC 1103.46. It says demurs have not been abolished. Okay, now above that last part I read, let's go up there where it says procedendo. On the last part it says, this writ of procedendo is called a procedendo in loquela. And what that means, that's a portion of procedendo. This means in aid of the Crown. That's your posse comitatus, or your 12 justices of men of good character sitting on the bench. That's what that writ means. You have to find the answers on that one in Coke. On Magna Carta, you'll get a pretty good handle of what I'm talking about. You cannot be deprived venue. That was your gift from God, the gift of inheritance. You can't take it away from you. But you have to prosecute that out, because the burden of proof is on the accuser at the common law, both the equity side and the criminal side. Okay, now the next one, page 12 here. We've got some people writing articles in certain patriot newsletters around the country. And without saying the names, this one guy says that we haven't had any common law in America since the 1700s. Well, if that's true, then this little section that I'm going to show you, this is a blank page. There's no writing on it. This never happened. Here's a case, and we found this in the Law Library of Helena. It was done in Virginia City, Montana, and when we were a territory, April 29, 1868. And the system will tell you, oh, you can't bring criminal actions. The government has to bring that. How about if you're the state, in fact? Mary Helen Hanna brought the action. She borrowed the name of the state. Back then it was called Territory of Montana. And anything that was lawful back then is still lawful today. Read the case opinions. Speedy trial, still 3 hours. You can find it in Title 18. Although it's not spelled out that specifically, but it says all actions that were in the territory are still applicable today. The national law never changed. So I'm going to hit the high points here. Mary Helen Hanna filed an affidavit complaining of Scotty. He'd broken open her house and he abused her in a violent manner. She asked that a warrant for the arrest of Scotty in behalf of the territory be issued, whereupon they issued a warrant. It was placed in the hands of Joseph Barlett, Special Constable, to serve. The next day they had a hearing, and the prosecuting witness refusing to prosecute, the JP ordered Scotty released, and Mary Helen Hanna was ordered to pay the court costs of $7. That's common law. There's many, many cases that we have that are similar to this, just to show you that in common law, you don't ask permission, you just do it. It's your right, exclusive right. Page 13 there, this is a civil docket brought out of Colorado. And this one here is for one purpose only, and that's to show you what change of venue means. Here was Henry Richards at JP at precinct number 18, and the cost of, on the part underlined there, cost of venue having been paid, a motion granted. The papers were transmitted to Charles Hill, Justice of the Peace for the 18th precinct. Notice the 18th precinct didn't change. The action didn't change. Henry Richards switched places with Hill. That's all. Change of venue. Okay, let's look at the next page now. Here's a new statute explaining it. Here we got as late as 1984 in Montana, a certain statute, and it says, the party who disqualifies a district judge and who desires to change a venue must include such request in a motion filed along with the affidavit of disqualification. They just hide change of venue under disqualification clause. That's all it is. You say to the man, you won't do it. You're wearing a black robe of chancery. I won't be heard under chancery, least of all by a party of one. In common law, both civil and criminal, it's mandatory that you have 12 if you ask for it. All civil and criminal. Otherwise, Jesus didn't have 12 apostles. That's where our law of the jury, remember, came from. Okay, page 15. Now I'm going to show you some proofs here and some frauds. This is a proof. And what I'm driving at here is to show you that we have a Supreme Court in the county, and that it is a county commission meeting. You've got to kind of take some of these concepts and start putting them together. This one said, if the right of possession is put in issue, the Superior Court has exclusive jurisdiction regardless of the amount of damages claimed. Remember what I told you, the one of Cashman versus Vickers, where they said the sky is the limit? In matter of right of upholding the birthright, there are no values. They can't put any values on it. That's an exclusive right to you. You can't lose the birthright. You can't lose your venue unless you waive it. Page 16. Here's out of New York State. I'm not exactly sure the book, but the part that I'll read here, in which shall be sent to the Supreme Court for trial. All issues of fact joined in the Supreme Court shall be tried at a circuit court or sittings of the Supreme Court in the proper county. Notice I said proper county. It didn't limit the county to one in the state or the Supreme Court. People of today presume that the Supreme Court is the appellate branch. That's one part of it. But there's an original branch. We found in the old books, revised codes of 1935, where the appellate branch got $6,500 a year. But the original branch got $1,500 a year. Did Dan tell you that the statutes county commissioners have two pay scales? Okay. One's democracy, one's republic. Which side are you on?
Which one are you paying for?
Page 17 here. This is a good proof about the clerk and recorder being the Supreme Court clerk. Now, Mobier, prior to Civil War, spells it out. It's in your packet a little further on, but first I'll read this form. And this is where I found a lot of my answers. I read the old forms. You can't really lie too much on the forms. And once you start getting the concept and you look at the form, you'll see this is what they really meant. So here it says, in the state of New York and the city and county of New York, I, so-and-so, clerk of the city and county of New York, and also clerk of the Supreme Court for the said city and county, the same being a court of record. To get much plainer. Next page. And this one is messed up because of this is what it looks like. And I've copied it out of an old book with the dark pages, and the copy machine I had wouldn't lighten it up enough and black. And then further, I painted it with orange, you know, the marker pen like you got. And then I blocked out the good wording. But what it says, the Supreme, in this part here, it says the Supreme Judicial Court. And we've had lawyers say, oh, we know that New York State has a Supreme Court in every county, but that's the only one. No. Every state in the Union, every county in the state has a Supreme Court. That's the county seal.
New York's Court of Appeals.
But that's the appellate side only. That's right. The original Supreme Court is the County Commission meeting, which is the county, which is the church. Not down on 5th and Main.
Metro 1313.
Okay, let's go to page 19. Here's another one on a code pleading in bankrupts, code pleading with forms. And this one I'm just showing you that you can employ your own clerk. It says here, the plaintiff has been about to employ one's AB as a clerk. The defendant covenant with the plaintiff under his hand and seal. All I want you to realize is that you get picked the clerk. This is what happens when you appoint a justice of the peace. A becomes clerk in relation to you. All right, next section. It comes out of this book. This is Murphy on Justices of the Peace. Murphy, Justices Practice, they call it. This is an old book that, all about 1870s, but a friend of ours in Idaho bought it from an old bookstore in Buffalo, New York. That store happens to buy these old books and they resell them. This was Rebound, and this is about $250, and they got a lot of them up in the $800-900 range. We're looking for one, and if we get our funding in like we think we will, we're going to buy a bunch of these old books. But the one that I want is a King's Bench. It's about the 1780s, and it was $950. And just the other day, I had a guy call from back east, and he said they have found a book of that name. I haven't seen it yet, and he's going to send it out. This is where you find the law. Study the law before the Civil War. That's when we had one class of citizen, and you can see how easy this country was run. It's after they created the two classes of citizen where things got mixed up. Because you couldn't figure out whether you were they were talking about the king or the slave. We've got old statutes here where they call the federal government foedro. That's how it was spelled. Foedro. Federal government has always been feudal. Feudal tenure. Lord over the vassal. So if you're a second-class citizen in America, the United States slave, I'm talking citizen, then your birthright comes from acts of Congress in this nation. Otherwise, your birthright comes from God. So which would you rather have? It can't be taken away if you don't waive it. Okay, page 20 here. This is just to show you the book, the title of the book and everything. Then the origin of the office, I won't get into that, it just says it's common law. Let's go to page 21. This part I want you to take note, the ancient and modern modes of selecting. It says, in the United States, the tendency has been and still is to diminish the number of offices filled by appointment and increase those selected by popular election. This is where they're moving over toward mob rule. For they're getting away from freewife in 21, which meant that you had to be a freeholder. You had to have 50 acres paid for, or you couldn't vote. This is so you couldn't become tainted to the banker. Doesn't it say, the Bible say, the borrower servant to the lender? Once you get free and clear, and you become a banker like I am, things change. We make the rules. the authority to make your own rules. And you have the authority to stick us with the bill. Because banks are nothing more than debtors in possession. The reason they are, they don't have any dollars of money in the vaults. Okay, let's go to page, on that same page, let's look over at the county commissioner's duties. Page 21 there. The moderate justice, therefore, may be regarded as possessing all the powers granted to justices by the common law. And they say they could form a police board, superintend public buildings, roads, bridges, and ferries, disperse the taxes or the funds, control lunatics, a few other things. Okay, county commissioners still do most of those items. What they don't do so much is hear judicial matters. But they can. All you have to do is pull up the hearing. It's still in the codes. In Montana codes, it's under Title VII, which is local government. Some people call it rural societies, some people call it home rule. We call it justice. Doesn't matter, it's still on the judicial form. That's exclusive to you. Page 22, down the bottom, is section 19. Dan probably told you that a notary can be a JP and vice versa. Here it is. Consequently, an attachment issued by him is valid. We have a notary that we filed the writ of attachment, had the notary go in here to town to Joanne Stanton, that's the clerk and recorder, she's a Supreme Court clerk, doesn't even know it, and she put the county seal on the document. We have the original $50 million writ of attachment out there in the file, and if the county road grader came by today and we got to pay for the lights tomorrow, we can seize the road grader, hold a public auction, and pay for some of the court costs. We haven't done it yet. We're getting ready to seize a certain few pickups and Suburbans. Most federal alien marshals drive Suburbans. They don't come out here anymore because they know we're going to seize the out. Because we need to pay for the lights.
So you can have a class. So you can have a class.
Okay, now here's the qualifications for the justice. He must be over 21 years of age. He must have good moral character. He must be of the male sex. Page 23. Here we've got in Tennessee, where it says the justices retain the power of managing the affairs of the county by reason of their jurisdiction as members of the county court. That tribunal holds monthly sessions, which ordinary business transacted. It's presided over by a chairman who is a justice elected by his fellow justices. You start to see the county commissioners are justices. That's what they're talking about. That court is a quarterly court. It's presided over by the chairman, and then it says where the justices come from, all the other districts. And 3/5 constitute a quorum. And then it gives the same duties as what I just read to you a little bit ago. That's what's known as quarter sessions. And if you get into it a little bit deeper, you'll find out the mandatory times for the biblical months for God's people. That's why our primary is in September, the month of the birth. Page 24. I pulled this one out of Webster's 1828 just to show you some, number one, that you should get the Webster's 1828. It has really good definitions in there and a lot of biblical quotes to go along with it. The word delinquent there. One who fails to perform his duty, particularly a public officer who neglects his duty. You've heard of juvenile delinquents, and you've heard of public delinquents. That's anybody, if you're an American national, any public hearing that's out there promoting democracy is a delinquent in relation to you. But that's the way it is. See, democracy and the Republican form of government are opposed. You can't have one side by side with the other without conflict. Okay, then another definition there, the word jury. A number of freeholders selected in the manner prescribed by law. You notice it didn't say elected. See, at common law, you summon the jurymen orally so that you can go out and assess their character before they come to sit on the bench. And then it says, and to decide both the law and the fact in criminal prosecutions. Well, don't you know that forcible detainer, unlawful detainer, libel and slander are always criminal? But they're also civil? Because they attack the character? If you put up a no trespass sign on your home, and someone violates the no trespass, can you shoot him? Is that criminal? No, I mean if he trespasses, is that criminal? Yeah. Yes, it's criminal jurisdiction. Is it also civil? Can you say anyone trespassing will be charged $100 fine? See, the birthright is necessarily civil and criminal at the same time. That's what justices' courts are. You look at the old justices' courts docket books, they say civil and criminal docket, the same book.
If somebody is convicted of a criminal act and restitution was to be made is one thing, but if a civil fine is laid first, does that not initiate criminal action or just in the quasi de facto jurisdiction?
Well, if you're holding it in a common law court, Supreme Court, then the jury decides that at the time, anytime they want. Article 5, Section 26 says, the legislative assembly shall not make any local or special laws, that is to say, respecting fines and punishments. The jury gets to, the 12 justices figure that out, dependent on what they heard. You don't have to follow statutory guidelines. You can do what you want. If you say death is appropriate, that's fine. If you say put him in solitary for a month, that's fine too. It's whatever they decide. Okay, page 25. Here we got it. Now this one is fraud. I want to prove some fraud to you. Page 25 is one of them, page 26 is the other. We'll read the new statute first and the old statute second. I'll show you the differences. It's on quo warranto, meaning by what authority. This is removal for office and a few other things, questioning your franchise of a corporation. But anyway, the procedure when the action is brought in the Supreme Court must be the same as if it's in a district court. The pleadings and conduct of the trial shall be the same. They're going to draw the jury from a jury box, and I marked it singular there, and that's going to be at Lewis and Clark County. Well, in Montana, for those that know about the state, Lewis and Clark County is up in Helena, and Helena is where the appellate branch sits. Now let's go to the other statute. Here's the same statute in the revised codes of 47, which are still law today by their own admission, and look at the changes. It's quo warranto action, same statute, and they're supposed to hold the trial the same as in the district court. But they select the jury from jury boxes of the county. Notice it's plural rather than singular. And then they hold the trial at the seat of government, where it's located. Why do you suppose they put Lewis and Clark County in the newer statute?
Jurisdiction.
To get you to think that the appellate branch is the only Supreme Court that's out there. And to get you to think that Lewis and Clark County is the only place that the hearing can be heard. When in fact the opposite is true. Every county has a Supreme Court. Then why did they go to singular jury box rather than jury boxes? Anybody got the clue there?
They want to pull it from all around the state.
No. They want to pull on the singular jury box, they want to pull all taxpayers. All presumptive 14th Amendment slaves. Jury boxes would be the Lodial landowners who aren't on the registration rolls. That's why you have oral summons at common law. So the sheriff or the constable goes out and says, are you a taxpayer or are you American national? That's what voir dire really means. Not just to speak the truth, it means who is going to speak the truth. Who is venue? Okay, page page 27. Now I'm going to prove what I just said about the Supreme Court of the county, and I'll use the Montana Constitution for a guideline. If you think that this is wrong, then we just as well scrap it. But I don't think it's wrong in the study I've got that this is correct. Here's the book. It's the same thing right here. You can notice that I picked this part, this part. They're the same. That's where I got it. Okay, this was printed in 1967, before we had the 72 Constitution. This looks quite close to the original.
Give me about 30 seconds.
Okay.
So what we need to do is go back and pick up each of the constitutions since the original Constitution and do just exactly what we've done.
Trace it out so you can see that you still have the organic law. It's still there. They just recodified it to try to get, that's how they do it. They put it over here, put it over there, and nobody traces it around. Ready? Okay, I'm going to read this now. All you English professors out there, tell me if the intent is wrong when I read this. I'm not going to read it word for word, but you see if I get the intent in here. And I don't even have it all changed, the caps, where they capitalized and they did, that would make it more effective. But for now, it says, upon a change from territorial to state government, the seals in use by the Supreme Court in for the several counties respectively shall pass to and become until otherwise provided by law the seals respectively of the Supreme Court in such counties. Was the intent change? I left out parts of it.
In the term such, specifying a different capacity county.
Well, the point I'm getting at, if it's seals, plural, but Supreme Court singular, I didn't read any territorial district courts, which is plural. The Supreme Court is in every county respectively, but the word and separates two styles of courts. The district court's a surrogate court. The Supreme Court's the original exclusive. Okay, to enforce this then, a little later in the packet here, we find there statutes where they tell what the Supreme Court justices shall do about issuing warrants. So you ask yourself, when has it ever been that the appellate branch issued warrant? They can't issue process. When has it been that the appellate branch appointed a marshal? But we got codes that say they must. Supreme Court must. See, they're talking about the original Supreme Court, not the appellate. Just us. Page 28 here. Here's how you make your rules. This is by statute. This is what they admit to. Every court of record may make rules not inconsistent with the laws of this state for its own government and the government of its officers. Such rules must not impose any tax or charge upon any legal proceedings or give any allowance to any officers for services. You see why this one's in compliance with Magna Carta, Chapter 40? And Chapter 40 says, to none will we deny, delay, or sell justice or right. At common law, you don't even have to pay a filing fee. All you do is go in and get taxed the fee, and the losing party picks up the tab, or if it's criminal, the county picks up the tab. And this is what forces speedy trials, because some of the people have to get back out and finish plowing the field. See the difference? And because titles of nobility aren't in there to commit acts of embracery and barratry, the stuff is too simple for the people to see, but then I'm showing you it's still in the codes. All you have to do is look for it. You can win any court case in the country if you understand this stuff, because you'll never go into their courts again. And you can't be compelled to go in. Look at Section 4 there of that rule, that code. It says, any judge who shall fail or refuse to comply with and carry out in good faith the rules of court adopted by the Supreme Court as herein provided for, shall be guilty of a contempt of the Supreme Court. And they're not talking the Supreme Court of the state of Montana. This is the original branch. You. How many of you have published your rules? We did. Now, page 29. Here, this came out of the Revised Codes of Montana in 1935, and it's talking about if a warrant is issued by a justice of the Supreme Court, it may be directed generally to any sheriff, constable, or marshal to be delivered anywhere in the state. When has the appellate branch ever issued a warrant to a marshal to be delivered somewhere in the state? Can't do it. It's on legislative created tribunals, therefore it's voluntary, because all legislative created tribunals are appellate in nature. Only the original side issues criminal process. Okay, page 30 here. Now here's some more fraud. This is blatant fraud. But these are the kind of things, we've got 85 pages of this in front of Congress. Now they know that we know. And they've admitted it. They said, if you want to talk about the character of the party, he said, Newt Gingrich was saying this. He said, you get a hold of them boys out west. They know what's going on. I watched him say it. Public television, right after the election. Okay, so page 30, halfway down the page, let's read their local rules statute. It said, any district court and the Supreme Court may adopt rules of court governing its practice, so long as such rules are not in conflict with the rules promulgated by the Supreme Court of the state of Montana. Okay, so you got 3 different courts identified in one statute. Then jump up to the top one, top of the page. Here's the same statute as late as 1991, identical in wording. But come down to 1994, right under that. They pulled out one of the courts. Do you know why they pulled that court out? We put it out as an edict and a precept, and we said, here's your Supreme Court in the county, and don't give us any more crap. So what did they do? They pulled it out, thinking they pulled a fast one. No, they did not. Now we moved for grand jury for treason. That's why just a few days ago it came on the public news. The Code Commissioner said, our job is to compile the law, not to change the law. And the lawyers were infuriated when they found out, but they're getting along with it pretty good now. And the new codes are coming back. Dan's found a number of them on the notary. They're back in the code books. We have notified all congressmen in Montana by writ of recipe that we're pulling up a grand jury. We notified them twice. We had 100% zero response. But guess what? Grand jury's in session. There'll be a few arrests. Okay, next page, 31. This one gets a little more complicated, but I put it in here. I'm not going to spend a lot of time on it, but I want to show you that this is on courts of limited jurisdiction. And if you look in your codes, it's talking about courts of peculiar jurisdiction, meaning justices' courts. It's a Supreme Court adopted the rules. This was in 1990, and Rule 1 is scope of the rules, definitions. So then if you don't fight them, just join in a while, read their definitions. What they will tell you here is, we're telling you, you have a Supreme Court, it's called the County Commissioners Meetings, if you can figure it out. And the common law is here, if you can figure it out. But you better read the exceptions.
But those county commissioners they have sitting in them seats being contractually tied into commerce or interstate lines have a consequently infringing third degree, therefore they cannot sit there pursuant to Magna Carta.
That's correct, they couldn't. And so that's why you would set the form for that day. You would go in there and say, no, you have a conflict of interest, that would be your voir dire for the day. You bring in your characters of good, your people of good character. Okay, the word commission means the commission on courts of limited jurisdiction established by the Supreme Court. They kind of leave that hanging up there. Don't worry about it for now. governing body means, for a justice court, the Board of County Commissioners. Then it goes down lower and says judge means a justice of the peace. So all through the document they use the word judge. But if you want to get good intent there, circle the word judge and insert justice of the peace. Now read the document again, it starts to make sense. See, we're not going to fight your definitions here. We're going to listen to what they said. And when you find it, get it all figured out, it says the county commissioners are the Supreme Court for a justice's court, which is a fellow justice. That's what it's really saying. When we showed this to them, this was in the 91 books. But they do in 94. Pulled it out. But this was even written in footnote form in the old book, as if it didn't really mean much. Up here on Rule 2 it says that under the direction of the Commission, the Supreme Court Administrator shall. Well, we had already read in the compiler's comments that they changed the word clerk and recorder to Supreme Court Administrator. Knowing that, look down on Rule 7, toward the bottom there, bottom right. It says here, this is to check whether the man's going to be certified or not. It says the Commission shall send notice of the disqualification and vacancy to the clerk and recorder of the Justice of the Peace jurisdiction. Now they use the word clerk and recorder. It's constitutionally correct. It's common law correct. You have to read these things carefully in order to decipher the code. All right, let's go to page 32. Some people have asked us, how did you start your township? Our township? We did it like this. We didn't even know this code back when we did it according to principles of common law, and then we found the provisions for it in the codes later. It's right here. This is how you do it. It says, the procedures shall not require approval of a charter by a legislative body. And then it says charter provisions are superior to statutory provisions. Anytime you want to go back to the abandoned form of government, you can do so. Common law has been abandoned because they abandoned the counties and come in with corporate counties. Nature of this kind of government, it says the charter form of government shall possess self-government powers. And under section 2 there, about the center of the page, it says, the enumeration of powers in the charter shall not be construed as a limitation or prohibition on the residual or self-governing powers granted by the Constitution. And our 89 Constitution says this, in Article 3.2, which is now, I think Dan says it's 2.2, doesn't matter, they both fit. The people have a sole and exclusive right of self-governing as a free, sovereign, and independent, capital S state. In Puffendorf, old law book, it says state, capital S state, in government, means the fetus in the womb. That's Israel. Israel. He rules with God. That's what Jesus meant when he said you have the weight of the cross upon your shoulder. Cross was the government, which is the church. We are one and the same.
Or the double cross.
Pardon?
Or the double cross.
That's right. Also a double-edged sword. And this gets to be fun when you understand it's exclusive.
I tend to, since they're running under quiet weapons doctrine of quantum mathematics and such, under electrical principles, they start to understand that capacity and construence is with everything, that the law of capacity and construence is like electricity and alternating current. It's constantly switching to where it pushes.
Well, my terminology of that.
They're always there. You just got to create a direct current.
Okay, but they call that evolution of law. But see, evolution is a science. It's not God's law. It's stationary. We just got off station a bit. The common law never goes away. I believe it Blackstone was one of them that said, and this has been said by probably a lot of the people, said, well, the common law ranged from its intended grade. Well, those people knew where the common law came from.
Where does the term merely, not practicing law, but merely promoting the science of jurisprudence? Have you ever seen that?
Yes, I've seen that, and that's all well and good for surrogates and for slaves. But it's not good in the King's Bench. If you want to go and have someone represent you, and you submit to that kind of voluntary jurisdiction and that venue, so be it. You will be confused. Statutes are Baal worship. The whole premise of license is money, isn't it? I used to be in the crops division. I flew airplanes across the farmers' fields. In Montana, for many, many years, they didn't have the license. All of a sudden, one year they had the license. Did that make it a crime the year before when I did it without the license?
That's license. Yeah. Which figure that one out?
The license you found implemented for
Implied consent agreement. If you hadn't said no, see, they play equity on you. He who sleeps on his rights has none.
Yep. Not fair.
Yes, it is fair. Otherwise, Hosea, it was a lie when Hosea says his people perish for lack of knowledge. Didn't he compel you to search the Scriptures? Didn't God say he was pleased when you searched the Scriptures? And that wasn't limited to Holy Scriptures? These are Scriptures.
They're all Scripture.
And isn't it a rule of war? No diamine? And didn't God say it's a God of war?
because they in fact have an ecclesiastical nature of commercial thing.
Right.
Okay, I withdraw my objection.
All right. Page 33. I told you at the start here that I was an Elazar. Some people call it an Izor. Yeah, that may be the correct way to pronounce it. Anyway, I'm saying I'm Elazar. Here's the Montana Code that says you have authority to do so. This is how I summon the grand jury members. And the reason you do this is when the sheriff and the coroner are both parties, or either the actions against one or the other, or both of them are, or the office is vacant. Well, since the statutes and the Constitution compel them to be bonded, if they don't have the bond, then all offices are vacant. Therefore, I can apply this statute. Then it says that the process, when it's delivered to an Elazar, he must execute and return it, same manner as the sheriff is required, and the court or judge may, at any time on its own motion, appoint an Elazar. So I appointed myself. Where does the law start? Who starts the action?
The law is that which you are willing to enforce.
That's right. In this case here, I'm the court now. So I'm the court of the grand jury. Okay? I did it, Article 5, Section 26. The one where it says the legislative, that's the alternative, what they call the alternative matter. But this is the one they can't mess with any rules. It says the legislative assembly will make no local or special laws. That is to say, respecting the summoning and impaneling of grand and petit juries. See, the other method is where a district court judge brings them up. But he's going to go to the jury box of taxpayers. Ratepayers. Okay, let's turn the page to 34. This page I put in here to show some of the people that the United States court, the federal court as we know it, has two sides. This was given to us by some people in Oklahoma. The part I got underlined on the right side there, I'll just read part of it. On the ground that the suit was brought on the federal side of the court, and the citizenship of the parties was not such as to give that side of the court jurisdiction. We also have one that says when you file an action in the district and circuit court, sitting with the powers of a district circuit court, this is what Ed Smeager and them guys did. Sheriff serves the process, not the U.S. Marshal. That's common law service. And Smeager had the sheriff serve the recipe on the 10th Circuit Court justices.
At that time, is he still in the corporate capacity of county?
Not in relation to the service because it was common law recipe.
I'll probably not.
He was the defendant. Okay, next page, 35. This come out of OVA prior to Civil War, 6th or 8th edition. Here in Maine, it said on 10 there, it says, justices of the peace and notaries public shall hold their offices during 7 years if they behave themselves. They may be reappointed or others appointed. Not a word about election. Just appointment. Now I ask you, how many notaries public are elected?
None.
Then why does the Justice of the Peace have to be elected? He doesn't. It's because you forgot to appoint one. But if you appoint one, you'll be charged with impersonating a public servant. But see, a public servant is not a public officer. Okay, let's go to the bottom part of the page here. New York State. The clerks of the several counties of this state shall be clerks of the Supreme Court, with such powers and duties as shall be prescribed by law. Every clerk and recorder is a Supreme Court clerk. And if you doubt this, those of you that have studied a little bit in law, every time you file a property suit in the district court, it is a mandatory precept that the district court clerk, and I'm talking, if you file the lis pendens, the district court clerk has to certify the lis pendens over to the clerk and recorder. That's in statute. Why is that? So that you can't lose the law of the land. A court of record. Who owns the land? Friend or foe? It all relates to your character. If you're right with God and you take back the right of inheritance, you will win. Page 36. Now we'll get into this. This is out of Ovies also. The word nase, or the word nase pres. Up at the top there it says, this word is frequently used in legal proceedings to denote that something has been done, which is to be valid unless something else shall be done within a certain time to defeat it. This is where your non-statutory abatement comes in, your refusal is for cause, your demurrer. Then nase pres, it says these words signify unless before. And that's where they come up with equity, where they say, he who sleeps on his rights has none, or come here into our surrogate court and we'll give you a chance. Down at the bottom it says, where courts bearing this name exist in the United States, they're instituted by statutory provision. Ask yourself this. Does the National Constitution have a provision for statutory jurisdiction? Then is it voluntary?
No, it shall be.
It is voluntary, because Bogier, prior to the Civil War, said, and he's got it in, I don't have it in the packet, he said, and the legislature may create corporation courts, so long as both the plaintiff and defendant agree to abide by the decisions.
It's got to be voluntary.
It's voluntary court. Anytime the legislature sticks their nose, otherwise you'd have the agent rising above the principal and making rules that the principal didn't like. And I didn't happen to like some of those rules, so I made my own. And we enforced them. One of them was no trespass. And you're looking at the red tag. Page 37, another fraud. Here we got Magna Carta in the newer statute, or not Magna Carta, but a proof that they used to have it in the older statute. They took it out. Down at the bottom right, they tell you how they did it. Under 5 on the bottom right it says, we deleted a former subdivision 5A which read Magna Carta. And then they admit we substituted 72 Constitution for the 89 and 72 Constitution. Now they mess around with it, but yet if you go back and look a little bit back, you see, well, this is what they did. They pull it down a little here and a little there and think that you went away. It But you couldn't find them? You fool some of the people some of the time. You can fool the persons all the time. The persons.
Did it actually say anything there?
What do you mean?
On 37, I mean, I read this and it's a bunch of jumping around words that don't go anyplace.
No, they said they deleted certain things.
Yeah, I know. They changed this from 5G to 5J and D to 1 and...
Okay, look at my notes, what I did there. Back up where it was supposed to be, I wrote Magna Carta. That's where it had been in the old one. You've got to trace them back to find out where it was. That's what we did. And then the fact they pulled out the 89 and 72. The lawyers would have you think the 72 is all that's left. Joanne Stanton, the Supreme Court clerk here, the county clerk reporter, she says, well, I don't like it either, but we're under the 72 Constitution, therefore take it up with the legislature. She doesn't have a whiff that the 89 is in the 72. Ignorance of the law is no excuse. She's still liable. Okay, page 38 here. This is us. These are the kind of things that we sent to Congress, the frauds that we pulled out of the code books. Here we got up at the top of the page, their admission by the compiler's comment. They said, we substitute Supreme Court Administrator for Department of Commerce. And then we deleted from the time he leaves his place of residence till he returns there too. Well, we know that they had also, already before this, they had changed clerk and recorder to Supreme Court Administrator. Now, it makes sense for the clerk and recorder to leave his place of residence. Does it make sense for the Department of Commerce to leave its place of residence? You see why they had to delete it? Does that change legislative intent? Can they change legislative intent?
The legislature can't do anything regarding organic law.
I'm talking compiler comment, code commissioner. In the preface of their books, right here, it says effect of changes. This is why about 2 weeks ago the code compiler said we can't do it anymore. We had our hand in the cookie jar, we got caught. We were infuriated for a while, now we're not quite so infuriated. Here's what they say. Codification does not change the law, and the effect of each statute is the same as when originally enacted. Because the Code Commissioner has no legislative power, there can be no change in the law without legislative sanction. The function of codification is to organize law, not to change the law. They're now putting it back. They're putting it back because of the tapes that are going out. The fact we're holding ex parte hearings. And we put grand jury summonses out on every one of them. And every one of them is standing in contempt. And we have the warrants made up. Page 39, the Extradition Act. You need to read all your uniform acts in the codes. Find out what they're doing to you. And you will find that under the Uniform Extradition Acts, every one of them is based on consent. We broke the extradition statutes by telling them that we knew that government was changed to government, or government was changed to governor, and the fact that we are the asylum state. Now, it's a known fact that you can commit an act of murder and run to the church and get asylum. Ambassadors can get asylum. A notary public from the country of Montana has asylum. You're immune from prosecution by the agencies.
What about other states? Any idea?
Other states are foreign. Foreign countries have to recognize foreign countries. You're immune when you go to the church. The church is the people, but you have to know what kind of people.
You're talking about immunity from the corporation.
Right.
not from the common people.
Right.
Okay. If you commit a murder, you're going to be tried under the common people's.
There were old statutes that said as long as you were in the church, they couldn't try you for the murder while you were in the church. You had to submit and stay in the church.
But then if somebody's bond was revoked because of misconduct, the charter would effectively be revoked.
In this country today, the ambassadors can commit murder here, and they still here.
This is true.
The power of the church is tremendous, if you know what the church, because we're above government, we are the government. Everybody else is executive in relation to you, principal or agent. Okay, let's get into the definition here. They said here, the term executive authority includes the governor and any person performing the functions of governor in a state other than this state. That's kind of gobbledygook, but let's go on. The term state, referring to state other than this state, includes any other state or territory, organized or unorganized, of the United States of America. What they're saying is, the United States is not of the same state as the United States of America. The several states are not the United States. Hooven and Ellison versus Ebot case. Supreme Court ruled we have 3 jurisdictions, and we're not going to hear it again. Remember that one? We used to have it up on the wall in color.
Hooven versus Allison says the same thing.
That's the one I mentioned. Hooven and Ellison versus Ebot.
Yeah.
That's it. That's one I was.
Hoover?
Hooven.
H-O-O-V-E-N versus Allison. They kept requesting the Supreme Court judge to define United States. He says we have defined this time and time again. Listen well, this is the last time we will do it. And he defines 3 United States, and you need to know the difference.
We had it in color code here on the last one with the camera. We haven't put it back up here, but it's a good one. I'm not much for case opinion, but there are a few of these. If you know the concept there, you can pretty well figure this thing out.
Also, Black's Law's dictionary is defined as 3 separate.
Okay?
Hooven.
Okay. Now, let's go to the last page. We're about a little over 2 hours here. We'll be down there in a minute. Now, about a little over 2 hours here. We'll be down here in a minute. Now, this one here, I pulled out of a regular dictionary. I didn't go to a specific law dictionary because they tried to disguise what court really means in the law dictionaries. This is a regular Webster's dictionary. This is one out of this book. It's quite a good definition. I found others that are quite similar, and we'll read some of the items of a court here. How many have read in Black's 5th edition, page 318, I believe it is, about suit of the sovereign, or court? Means suit of the sovereign, wherever the sovereign sojourns, his regal retinue follows. Have you read that? Okay, here it says, the word court means, 1A, the residence or establishment of a sovereign or similar dignitary. Under B is a sovereign's formal assembly of his counselors and officers. Under C, the sovereign and his officers and advisors who are the governing power. Would that be Article 3, Section 3, self-governing, sole and exclusive right, self-governing, free, sovereign, independent state? That's what they're talking about.
Under their Article 1 jurisdiction is actually that in that capacity because it's voluntarily acquired a court as a place where a contract takes place.
I didn't quite follow.
A court being a place where a contract takes place.
That's right. Inferior tribunals are contractual. Their origin is contract. That's why it's appellate. D, the family and retinue of a sovereign. Obviously use the word retinue. A reception held by a sovereign. 3, 3A, an official assembly for the transaction of judicial business. B, a session of such a court. And D, a judge or judges in session. Now, that word retinue, and it's synonymous with comitatus, and comitatus is synonymous with county. County is synonymous with commonwealth, or commonweal. It's the people. And it depends who you follow. You're going to follow acts of Congress, or you're going to follow God. How simple it is. That's why we got a peculiar jurisdiction. In the Bible, we were called the peculiar treasure, the select, the elect, the battle axe, the Arians. There's about 50 definitions of his people. One of the people that came to the last class gave me a book. I had one before, and I didn't have it memorized, all those names, but there are many, many names that they call us. Now, for proof, back when I was younger, I'll say that a man was chasing a woman in the dating. It could have been called, he went courting. How many have heard of that? Why did they use the word court? Because, listening to this definition and knowing what court means, it means in-law. If that got serious and he married the woman, would she become in-law to him and his family? Would he become in-law to her family? That's the retinue of a sovereign, the family and retinue of a sovereign. In-law is not at-law. In-law is the real thing, where no titles of nobility come in. Lawyers are at-law, beside the law.
They're outlawed.
That's right, they are. You say, no, you don't come in. This is our exclusive.
When did the term attorney start to become taken from the Latin word attorney, I believe, to twist?
I don't know when that became common. I know that there is a difference because some people ask me, are you a lawyer? And I says, common law lawyer. I don't have to hang out a shingle. I can be assistant of counsel to anybody I want. I can be a amicus curiae. I can be a private interventionist. Doesn't matter. I don't have to justify. We have a lot of people in Patriot Move and say, they put out a little booklet or something. They say, do not take this paper and construe it as legal advice. If I were to write a paper, I'd say, take this paper and consider it as lawful advice. I have nothing to do with legal. Everything we do is lawful. We don't go through that step. Okay, that's the end of the presentment. We'll start at 8 o'clock in the morning.
Can I digress from someone from this?
Go ahead.
In here, you brought, like, you put before the Congress, all of the changes. My pet peeve is all of the executive orders that are being signed. What can we do to stop those?
The executive orders don't reach into Justice Township.
They reach into where I'm from. So do I need to get out of where I'm from?
You have to go back to, the executive is only for executive. We're judicial. Go back and form the judicial and then tell the executive, you don't touch us. Separation of powers. It gets down this simple. Have you committed a common law crime or not? If not, administrative law has nothing to do in your life. None. He brought that up. I think just a little extra time here. How many know the right to privacy? What it really means. The so-called Fourth Amendment Bill of Rights.
Stay out of your right to be secure.
How many know the remedy? Here's a book, Territory, Montana, published in 1879. Talks about unlawful interference. An act to prevent unlawful interference with private rights and private property. The trick is to get you to talking real estate and personal property. And they capitalize that. Well, that seemed to be public property. I'm going to read part of this. Every person who by force or fraud or by threats or intimidation either by words, or writing, or actions, or exhibition of force, shall prevent, or interfere with, or hinder, or delay any contractor, mechanic, laborer, workman, or employee in the performance of any lawful contract, work, labor, or employment for any person or company, or upon any terms or at any price which they may have agreed, for which he may desire to work, or labor, or contract, shall be deemed guilty of felony, and 3 years in the territorial prison. There are 3 stages of felony, 2 stages of misdemeanor for anybody messing with your privacy, such as a building inspector that comes out and says, I would like to tag your pole out there because you didn't comply with our Baal worship licensing. We don't comply anymore.
In Idaho, they actually have an office of sheetrock nail inspectors in one area.
Well, when Rod did this to the electrical inspector over at the cabin, in the Bull Mountains over there, he brought the sheriff's deputy out the next time. Rod put $100 million lien on both of them. Neither one came back on that issue, and the guy that was the building inspector, he had told the barber down there, he says, I'm not going back out to Skerdals again. And he did. It wasn't worth $100 million. But there's certain concepts there that we've forgotten. We've been so used to allow so-called administrative law to come in and rule your life. You're not subject to it, but you will be subject until you turn around and say, I'm going to govern, and here's my buddies that are going to help me govern. This is how we'll do it. That's what we're starting to do. We're making it stick, and we do run the country from right out of Justice Township. We're going to continue to run the country from here. Okay, about tomorrow a little bit. We're going to try to start it on time at 8 o'clock. The program tomorrow is Dale starts with about an hour to present it. Then I'll follow, and mine is about 2.5 hours. Then Dan and Rod are going to give some more. And in the afternoon, I try to get done by noon. In the afternoon, I do private matters out in the other room. And we go around from the back to the front. The private matters consist of you people with distress problems, such as IRS bills, property tax bills, farm foreclosure bills, any kind of bills that the banks have been messing around with you. Not private bills, but banks or institutions. We limit that to 5 bills apiece. Anything over that, we charge $100 per check. We'll write as many checks you want if you need that. The idea is to get you to be able to teach you so you can write your own. Some of the people that have come here are doing that now. The quickest way you'll have immunity is learn how to write your own checks. But we'll take care of some of the stuff for you. When you come out there, I don't need to know the story, all of that, just a little bit of the proofs. Have your bills already doubled so that I don't have to go and do the figuring, and we get through it in a fairly good manner. It usually takes till about 5 in the afternoon to get it all done. Okay, that's it.
My name, for the new cameras that are here, my name is Dale Jacoby, J-A-C-O-B-I. Yeah, that a little bit further on the side. Thank you.
I've got a proof packet. I've got plenty of the instruction sheets. The instruction sheets look like this, but we recorded the others. For now, if there's husband and wife teams here, would you share and then pass that proof packet to someone that doesn't have it? Who doesn't have this packet? This is the proof. The first was on top of your file. Who doesn't have this? So I got one extra up here. Every one of these seats, the 24 seats, here has one because I counted them out 6 per. That's it. Okay, who doesn't have this? Do you have an instruction sheet? Okay. Now, how many are we short? Who doesn't have those 2 packets? All right, I guess we're all covered then. This takes about 2 hours, or 2.5 hours to go through this. This is what I call the remedy. It's the Uniform Commercial Code remedy. It's a common law remedy. We'll take about an hour and then take a break. Then we'll go for about another hour. If I'm not done, we'll finish up after lunch. But I try to get done by lunchtime, even if we run a little past the 12. The proof packet, we'll go through that real fast. Not too much in depth right now, but you'll have plenty of time to study that. This is not all the proofs, this is just a few. We get probably one or so a week coming in here. We got a real good one the other day. The guy did a real good job of writing the affidavit and all the proofs, laid it out, how everything happened, how he came to the class, what he learned, how he applied it, and the refund. That one was, I don't have it in this packet. It'll be in the future packets, along with some more. We're waiting for a few more affidavits. We have over 40 of these proofs, but not all of them are in affidavit form. So we just grabbed a few of the certain ones that are pretty easy to follow. That's what we got here. Now, when you go through it, you'll also notice I numbered that first page there, 1 through 11. We go through the packet backwards. We go from her to back. And what I've done is numbered the bottom of the page, like I call it HERDA number 1, HERDA number 2, like that, so you kind of follow along here. I wrote this affidavit, kind of like a cover page for the proofs. We did have one guy picked up about a year ago by the system, and they charged him a forgery. And I wrote the check. He could not have forged the check. I wrote it. I signed it. I sign all the checks. I make them all two-party checks. That way you'll not have to defend anything. That is not to say they may not pick you up. They might pick you up. This system is rocking and reeling with the truth that we've had. I've wrote over 2,500 checks. So far, I've yet to have anybody come to me and say, I've got insufficient funds. I wrote to Norwest Bank where I got my account, where I first put the account, and I said, do you people have any idea how much money is in that account? And they refused to answer. What really got this thing started about better than a year ago, I bought 2 rolls of postage stamps from Bruzette down here at the little post office. We were living over at Roundup at the time, and I ordered them through a Supreme Court order out of here, out of our Supreme Court. We called it Justice Township back then. And I said, use due diligence, check the account out, and then send me 2 rolls of postage stamps. They did. 6 days later, we had the stamps. We seized the stamps as evidence because they sent it to MT. We never opened the envelope. We've got many, many people that have seen the envelope. We used to have it pinned on the wall. We've seized it as evidence. The interesting part, the stamps came from the Claims and Inquiry Division, Great Falls, Montana. That is the GAO, General Accounting Office. That's the branch. Every post office is a GAO in relation to the comptroller of the currency. So we had our immunity. The account's good. I don't care how many lies they tell you. We've had Bruce Parker say over the phone to a man that was my assistant counsel for the day, who was quizzing him over the phone. Bruce Parker is the president of Norwest Bank, or purports to be in Butte. And they said, what did you do with that account? He said, we transferred that to the Office of the Comptroller. Dora Lou Sevener, who is the court clerk at Butte, Montana, United States District Court, she told us over a year ago, she said, the account has been transferred to the Treasury, unclaimed account. I put $77 million in the account after I got it opened up. I opened it up with a $100 bill. I didn't open it up. Panama Paul the Trader opened it up. That's our chief federal judge here in Montana. Used to be. So, after he had a court order to open that account with Norwest Bank, I put his $77 million default in there and started drawing on it. And then I appointed Rod and Dan as Special United States Magistrate to handle the account. And so that we wouldn't be overdrawn, I had them both put some of their funds in there. So they put about $600 million apiece in there. And we have quite a few $100 million and a few billion to put in that account in case we ever get overdrawn. That's why I asked them how much is left. And they didn't say, so evidently they're not too worried about the audit. We put a mandamus out on them that they will audit that account. Since they didn't do it and they only have 30 days to get the job done, now we get to write checks, drafts, warrants, whatever you call it, until we deplete the account. And we have numerous new customers every day. Many, many customers. Every time that, let's say I write you a draft, a warrant, and you take it down and do what we tell you to do, and a smart-ass postal service employee says this is no good, then I have a new customer and you have a new customer. And I'm getting them $5 billion apiece for credit slander at this time. Okay, let's go through the packet a bit. On the flip your page, it's HERDA number 1. This is where he writes a little letter saying what happened. Then you'll see our check on HERDA number 2, $3,200. And with his little cover letter telling the people what to do. Then some more correspondence back and forth. I won't get into that too much. Turn to HERDA number 6, and you'll see the check they wrote to him. $1,800 and something. That was on a credit card payoff. Next one, we get into Yancey, Ronald Yancey. He's out of all around the Dallas area, Texas. It took him about 2 months to get his refund, and you'll see his affidavit of fact, what he did. Then his tender with his little note telling him what to do. The $57,000 that we sent out was an old style check that we used to write. That's when we had Norwest Bank written on the check, face of the check. Quite a bit of correspondence back and forth. We'll get on a page through it a little bit here. Page Yancey number 9. And it's another affidavit. I told him, send me an affidavit to prove to the people that you did cash the refund checks, which is real short and to the point. And then you see the refund checks on Yancey number 10. And I enhanced the figures there on that one on the top. See where it says 1496.07? I drew in the 4, 9, and 6 a little bit better because they were pretty dim on our copy. I didn't change anything on the lower one, that 12,300. That's the only change that I made on those checks, just so you know it, because you could see somebody wrote on it. All right, the next page is Anklin, number 1. And these people did not want me to show this to anybody else. They said, so far as we're not publicizing the check, except to tell people, but not giving out copies of the paperwork, you are an exception. Here's the exception. I wrote the check. They don't have any authority to tell me what to do with my check. So I'm showing the check to you. I'm doing it for a reason. These people had quite a large bill, and they were kind of about halfway in and halfway out. They got the check. They're so damn worried they got the refund check. They know what the hell to do. If you're that wishy-washy, don't do it. Anyway, they got $451 back. It isn't a whole lot, but still true. You can see the picture of our check there on Anklin number 5, certified money order. Back at that time, they were giving us a little static about our check, so we just went ahead and had the notary certify the check right on the check itself. Start knocking them for a loop. Okay, next one. Let's go to Cofield, number 1. I wrote an affidavit of what happened there. Cofield, number 2, he wrote here's his demand letter to them. A little more correspondence. You'll see our check to him was for $13,900. That's on Cofield number, 4? And on number 5, Cofield sent us a donation, you might say. And then, let's see, I forgot which one showed that he, okay, Cofield number 3 was the debit adjustment, $5,300. You'll see that. Then let's go to, that capital. Let me see if this is the check. Your total new balance on Cofield number 4, right under our check, it shows his new balance on the refund. Okay, now let's go to ARCA number 1. And this was, we had asked this man to send us another copy because this was a fax copy. It didn't come through real clear. And we didn't get an affidavit from him, but we put it in here anyway. And it's a $1,881 check, and you can see the check we wrote to him was for $3,700. All right, let's go to Leffler, number 1. This one, I wrote the affidavit. This was a guy that had to pay his child support in Minnesota State, and he sent us the check. He didn't know what to do with it, or else was a little nervous about cashing it. You can see our $13,000 check to him on Leffler number 3. A letter back to us on number 4. The check, refund check that he was paid by, you'll notice, Norwest Bank out of Minneapolis. This check, what's interesting about this, it originated at Norwest Bank. That's where my account was. We paid to him, it went through Norwest Bank. Then when he sent us the check, he sent us this whole check for $5,700. We took it down, put it in Norwest Bank here. We waited to 72 hours, like they said we had to wait. It all cleared, we cashed it out. And then the jerks, dum-dums, pulled the account. They says, we're going to close the account. Well, there's another $5 billion customer. And I just wrote the lien up on that one about 2 days ago. So we got a little bit more interest in Norwest Bank now. Thorn, number 1. This was credit card payoff. You can see our little different style check there on the next page. Thorn number 2. We paid him about $9,200. Anyway, he cleared out his credit, and he had a refund. And I've had one attempted nasty phone call over it. Some woman called up for some collection agency, and she said, about this check for Thorn that you wrote. She says, why did you put his name on there and our name too? And I said, oh, that's private. And she asked me another question. I said, well, that's private. They can't handle that. She says, I'm going to turn this over to the fraud department. I said, I wish you would. That's where we turned it in. They want you to defend. They don't have to defend. They're the ones with criminal conversion, not you. We had one guy, he called back and he said the Secret Service or the KGB or Mossad, some agents came to see him. Anyway, they were trying to intimidate him. He wouldn't intimidate him. He says, you're some sort of a cool dude. He said, aren't you scared? He said, why should I be? You're the ones going to prison. See, you defend. That's what they're waiting for. They're hoping like hell you'll defend something. If you don't know what else to do, keep your mouth shut. Just say, that's private. I'm surprised that you invade my privacy. I think I'll arrest you. Okay, the next one's on Pierce. It was come out of California. He was a postal worker. And it took him about 30 days to get everything done. You see our check to him for $22,700. Then you follow it through and you'll see a release of levy. And release of property from levy. And you keep going in there and you see his check, Pierce number 8. They paid him $14,267. Pierce sent us 3 postal money orders. It's on Pierce number 9. And then on number 10, he wrote an affidavit of what happened. Then, the Goon Squad, to try to quash the whole thing, they put out this little notice, Pierce number 11. And it says here, a no-bid check. They say, notice of dishonored check for more than one tax form. And then you look down here. The bank did not pay the imposed check for the following reason. No reason given. It's just a watered down, make it look like, oh, we didn't really mean it. But what's funny, look at the check down there, right below that. Notice in the lower right-hand corner of that check where it says 00022700000. Look up at the amount that we wrote. $22,700. Whenever they stamped that down in the lower right corner, it cleared. It just went through. That's what they're saying it didn't. No wonder they said no reason given. Then you look at the other numbers, up here at the upper right. Those big numbers and little numbers, I didn't put them on there. There's 3 sets of those up at the top of that page. I didn't put them on there. And if you look at these carefully, I'm not sure I got a picture of the back of that one, but a lot of them you've seen a copy of them on the back that says pay any bank. And some of them get so blatant, they take it and put a red stamp on it and say endorsement canceled. We didn't authorize them to cancel endorsement. Now we got them for aiding and abetting and criminal conversion. UCC 3419. It's real hard for them to get around their own book. Uniform Commercial Code sinks ships. That's what these ships run aground.
He who lives by the UCC thrives by the UCC.
That's a good quote.
Did you finally get to the point where it was okay?
I think it's okay. Janae gave us $1,500 of it.
Well, what I mean is, have they
Finally cleared,
finally cleared it? Did they clear the...
It cleared the minute that he cashed the check. That's the clearance. I cleared the check when I wrote it in. I'm the clearinghouse. These are not quite like you think. Warrants are a one-sided deal. It doesn't have to clear anywhere. Pay-to instruments don't have to clear. They're already cleared when you write them. Remember, postal money orders are pay-to. They're not paid to the order. Okay. Then it's a bearer instrument. See, I got a postal money order on our booking fiasco that we've got going here. I got a postal money order in there. Nobody wrote anything on there. Their name isn't on there. My name isn't on there. But we can cash it. It's a one-way trip.
But what I'm saying is, did they finally admit that their balance was paid?
No, you're not going to get a crook to admit. Well, maybe.
They sent you a refund check,
And you get it
That's
cash.
the admission.
then it's,
That's the admission.
the transaction's cleared.
That's right. The next guy, Nicholas Tadero. They tried to intimidate him. Nick didn't intimidate. He said, you guys are playing games. But he got his check cashed out, $12,000 that we paid him. There's some letters back and forth. And as we get into this, you'll find the check that he wrote us a cashier's check for $6,500, but they had paid him $7,200 and something. I forget exactly where the check is there. Let me see if I can, somewhere in that packet. 7251. I'll put it's Tadero number 4, and you'll see the check on the upper side of that. That's how much they paid him back. And they tried to give him a bad time, but he said, no, you guys have problems.
On all of these overpayments, I know the biblical duality principle, you stick with that, is always double.
That's right. That's why we do it. We pay double. Comes out of Revelations. For one place, anyway. But see, replevin, another way to look at this. Have you had your liberty stolen? Replevin is for stolen property. So we're just turning around, bonding the action for double. Just like you do in replevin. See, the concept's this. We know the banks aren't dealing with gold and silver. Common knowledge. But accounts receivable are an asset to a bank. Every time you get one of these perfected and you file down with the clerk recorder, it's an account receivable. They just didn't like collecting their own accounts. Still good. And if they don't collect on them, then the bank says we're insolvent. Now you own that much to the bank. This thing is so simple that people don't see it.
I hope this is not a stupid question, but how does this affect people like TRW and Stepper that may have a credit reporting file on you?
Very good if you're the delinquent, because it fries all credit.
No, but I mean, will I be able to gain credit in the future?
You can get as much credit as you want. It's the one you put the lien on that has no more credit. That's the idea. That's the recording idea. Those people come and check with all the clerks and recorders, and that's what's going on behind the circle. This stuff gets funneled down to those agencies. It hits Dun and Bradstreet and all the good reporting places. See, that's why they're blocking us from public filing. This is devastating. These are common law liens. We had a woman down here in an IRS trial about 4 or 5 years ago in Billings. She was the expert. She was pulled in out of Helena. And she says, the UCC 1 form is a common law lien. You can't get that court file anymore. But computer aided. They don't like this evidence out, especially when they're proud of themselves. And toward the last hearing, the purported U.S. attorney, but Your Honor, these are collectible. That's right, they are collectible. We've collected a number of them. All right, the next one's kind of interesting. This police officer down in Kansas. Now he's a peace officer in our side. He quit their side, joined ours. He came up here, stood in front of the class, and said, this is what I did. The bank got playing hardball with me, and they said, your instrument isn't good enough. So he leaned him up. About 5 days later, they said, we didn't want to play that hard. If you will give us the release the lien, we'll give you your deed. So they did.
In his joining over to the right side of things, even though before in his capacity he was acting upon, there was treasonous acts, he was pardoned in those.
But the Bible allows you to repent.
It does not to make to the court to put yourself under God's judgment.
He jumped on this side. He said he didn't feel real good about a lot of the rest he made. You go talk to him. He seems to be on the right track. He gave us some pretty good proof. He's the one that's in the American Bulletin, and he's got his picture in the American Bulletin with the gun.
How would you feel about tendering payment in person rather than through the mail just to eliminate that?
It'd be just fine in person if our people, if you're talking to me, I would have to have about 25 of my marshals right alongside with me. And they'd all have to be packing. We're not going to go out and play games with these bastards. Right now you can use the mail. They want to allege mail fraud. Then every IRS agent that ever mailed you a 1040 form is guilty of mail fraud. Real mail fraud, not pretend. This only relates to you if you're American national. If you're a U.S. slave, then you don't have this argument. You have other arguments based on the 14th Amendment. This is a different amendment. This is 5th Amendment due process, not 14th Amendment due process. Okay, that's Riccomini. I'm not going to go through it too much. I just told you. You can look it up yourselves. It's quite lengthy. A lot of paperwork there. Let's see, the next one, Henderson, number 1. It's just 2 pages, I believe. His affidavit of what happened and a picture of our check. Then Henderson's payoff check on the back. That's the packet of proofs as we have it now. We've got many more, and we'll be upgrading this, probably pulling some of the papers out of here that we feel aren't quite that necessary, and try to keep it down to less than 100 pages.
Are you going to send out news to people who've been here or not?
No, we try not to send out anything or do anything extra here. We're operating on a kind of a shoestring. We had tried to operate on totally on donations. We still consider this that we're operating on donations. We went to a booking fee to try to keep people from abusing what we're trying to do here. When we had 9 people short and 7 people short, 2 classes in a row, and these people give me their word over the phone, but they're not good to their word, then we thought, well, we'll correct that. And there's some glitches in it, as you can all see, and we're going to get it corrected. We're going to make it to work. I have no quarrel with telling you we leave the burden on you to get here. Totally. Because there's nowhere in America you're going to get this kind of remedy for this price. Nowhere. I've been at this for 20 years. I know what I'm doing, and the system knows too. We're taking the country back.
Have you been giving warrants out for 20 years?
No. No. We've been writing the checks for about 2.5 years, probably. No, last year was our biggest year for breakthrough. This year we take it down. It's over. We're winning. We've already won the war. All you have to do is get truth out there. Truth stands. It needs no defense. This thing's exploding. It'll go as fast as you do.
It is because of all the prime-time 2020s that you see, and they're interviewing all the people, sovereign people,
right.
And they're scared of them, and they're telling us on those programs that they're illegal.
So we don't care what they say. The fact is, that's why we won't interview. We let the lies get bigger and bigger so more and more people see. In Proverbs, it's, I forget the psalm number, but it's, or not the psalm, but maybe it's in Psalms. Some of you probably know the verse, but it's the part where it says, the pit, they look at them all pregnant with sin, the pit they dug for you, they fall in themselves. You know the one? That's why we won't talk to them. Let them sink in their own mire. It's working. We don't have to justify our side. We won't justify our side. The king can do no wrong. Just put truth out there and watch what happens in this cesspool of activity. They're striking themselves to death. We're just mixing the pot.
Evil perpetually destroy themselves.
Okay, we get into the instructions. In that border part, this is what the paper looks like, what we're working on here. Anybody that's short and doesn't have one of these, I've got lots of these up here, instructions. Need one? Anybody else that doesn't have that? I got 2 or 3 extras here. Okay, the reason I ordered that, those 3 papers that we deal with, that's how simple this thing gets. You only have to know 3 different pieces of paper. If you understand the intent of these 3 pieces of paper, you take them down. You can own a bank in 45 days using this method. This is all common law. It's in the UCC, and it's disguised as color of law. But if you know your realm and you know your character, then this works for you at common law, because UCC 1103 says it does. It says you have all kinds of common law if you know how to pull it out. All we're using their code for is say, here, you agree. And besides that, isn't the UCC based on good faith? They said it is. I know there isn't a banker out here that commit a crime. And all public hirelings are honest. Alright, so we get into the 3 forms. The UCC 1 form, which we call the warrant of attachment, or the writ of attachment. The UCC 4 form, which we call the true bill, the pleading or complaint, sometimes we call it the confession sheet. Because we write them up where they're standing on the witness stand saying, this is what I did to you. We pry it out of them. Because they're playing in equity. In equity, he who sleeps on his rights has none. So if you present this stuff and get it out there public and he doesn't deny, guess what? You haven't said no, it means you said yes. We just turned around the lawyer's greatest ploy and handed it back to him and watch him regurgitate. Because they do. There's no lawyer in the country to beat this. The UCC 3 assignment form, we call that the writ of execution. If you understand those common law on the right, that 1, 2, 3 on the right, if you understand common law process, you'll see why this works. Because at common law, you can't be denied your court. And if you bond the action, then no judge can come in and, otherwise you could charge him a criminal trespass on the case.
If somebody is on a $1 million bond and it's stage ready to go, they would have to come up with, what, $46 million in Federal Reserve notes to bond in action?
You can set the par value if you want to, yeah, that's right. We're not even worried about that at this time. We write it on the UCC, on our 4 form of pleading, the complaint form, that it's redeemable in gold and silver. We put that on there because we know that will create the estoppel. Whether they pay off for that value is up to you. You get the discount if you want.
And send them a bill and a 1099,
Right.
433.
There are many, many remedies here. Okay, let's go through these things real quick and then we'll get into the ingredients of the packet. Number 1, you type or handwrite the UCC-1 form pursuant to the sample form included, marking your form at the top non-standard, non-negotiable, since it's private, not subject to public policy. What I'm getting at there is we're coming from the foreign countries, like the country of Idaho, the country of Utah, the country of New York, not the state of. So that there's no, see, we're all foreign countries in relation to the District of Columbia. And the UCC is District of Columbia rules through lawyers. Number 2, for the debtor's tax ID number or Social Security number, use the certified mailing number if you do not know the debtor's Social Security number or TIN number. This is not so important. You don't even have to have a number on him. What's important that you pick a number and you stick with your number, just so that you can identify it. This is my case. This is my lien.
Could you use an APA number?
What?
An APA?
What is it?
A bank? The bank number that's on it?
That's what I did. I used the prepaid account number. When we get into it, I'll show it to you. My account is 85207999406. That's my prepaid account number. That's my special account now with the comptroller. I don't care what vault they put it in. I handle that account. That's mine. And nobody's objected yet. All they do is saying, oh, it's bogus and it's fraudulent. Where was the hearing?
When the gold was stolen years ago, was it transferred out of this country or did it actually stay here?
I have no proof where the gold went. I just know it's not in circulation. That's all I need to know, and I can force it to put it back in circulation, because when I get my refund, my revenue coming back to me, if I was making $10 million a week or $100 million a week on some of these roll programs, don't you think that I would be able to buy some gold mines?
Oh, yeah.
There's one up here at just north of here. I'll bet you we could go up there and say, whatever you paid for the gold, if we give you 2.5 times as much, will you deliver it down here? It's only about 100 miles. Zortner. There's a good mine up there. Maybe we'll own that. Okay, so now let's go to number 3. Your initial presentment should consist of the following: A and B. The UCC-4 form, what we call the true bills or confessions, and the UCC-1, the non-standard, non-negotiable form. The UCC-1 is your financing statement, or your bit of attachment. It's the one that says, this is the property I'm going to seize from you. You list the assets. You keep the originals and send true and correct copies to the debtor. Now, remember this. You're working on the equity side of the court here, and so you keep the record. See, if it's criminal side of the court, you got to go make the records public, like clerk and recorder. Here, you keep the records at home. You'll still make this public, but what you're going to make public is the default. And if they don't answer up to the default, and you get it into the position of res judicata, these are saleable across the world. Because the UCC is recognized worldwide at this time. Lawyers Little Cartel will go ahead with their rules because they didn't realize that these rules would turn around and bite. They were having a heyday, see you in review. Now we're replevening with the same rules. Number 4 is an option. You place a sticky note on the 1 form and the 4 form. You instruct the debtor to sign by your marked red X, which is in the lower left-hand corner of the 1 form, and at the attestation line on the 4 form, where you're asking him, would you attest to this document, this is true, correct? If he doesn't, then he's agreed, because you're going to sign right underneath that by acknowledgement. And acknowledgement means confession of judgment. Rule 55B, entry by the clerk. Summary judgment. Okay, number 5, instruct the debtor to return the form signed within 10 days, the 10-day courtesy time limit that you're giving them. Make sure to keep a copy of the green card so you can prove they received the service of the forms. Just make sure that you've got good process, that you can prove, I did send to so-and-so, and here's my process. You have to keep that record. Mark the date the debtor received his private presentment, then give him 10 days plus the 3 days grace period before you enter his default on the public record in your county. Don't press the time limits too much. You've got plenty of time. This is the quickest way to get a default in this kind of perfected security that I know of. It's approximately 45 days, and you can have just about anybody under default.
Is it recommendable to go to a 21-day period under ecclesiastical law?
No, because the UCC common usage is 10 days. And since they love common usage, let's feed it to them.
Work days or just 10 days?
No, plus the 3. Give them the 3 days grace. So 10.
Working days?
Well, no, the 3 days grace takes care of the weekend days. 10 plus 3.
They're working day following Saturday. Is there a magic to this 13 to steer them?
Could be. Number 7, if the debtor fails to sign the forms within the above time limit, you then sign for him by accommodation, surety, guarantor, signature through the use of UCC section 3415. It makes you the bonding agent in fact for the delinquent. See, they don't have fidelity bonds now. Last one I found in Montana was 17 years ago in Gallatin County, and the fidelity bond that I had is that this bond is good when the agent or the officer is acting without the scope of his authority. They don't have that now. This is why you can step in as the private interventionist, the king, the surety, and say, well, I don't think that guy's going to be a delinquent. He's too good for that. He's not going to perjure his oath of office. He just looks better than that. Good faith, remember?
In our state, they do have bonds. The White Sea Hartford claims we're not part of the contract, although the code is full of things that say an agreed party can move the bond.
But those bonds are limited liability for, like, hit and run. Let's say the cop car hits a parked car. It's a limited liability bond. It's not fidelity on the oath. It's a corporation bond for property.
So they're not bonded?
They're not bonded at all, fidelity. No, there's no bonds carried. If you look at the old fidelity bonds, it said, while acting without the scope of his authority. They're missing that now. So I stepped in and bonded these perverts. Pays off, too. Every time they surprise me and become a willful perjurer, I have about $5 billion more to put into my little fund. Nobody's bitching, nobody's saying no. They only squeal when you try to collect it. We don't care about that. These aren't collectible. We had the U.S. Attorney yell that out and said they are. Okay, number 8. You should print the debtor's name with his wife or husband name. You sign your name as a secured party at the bottom right-hand corner of the 1 form, and at the bottom of the UCC 4 form where it says acknowledgement. After they default, you sign your name for them at the bottom left-hand corner of the 1 form. Don't sign the bottom left-hand corner where debtor's signature for them before they default, otherwise you go to jail. Because you violate the notice time. There was a guy from Florida, he called, his friend came up, and he said this guy put $1.2 million lien on the IRS, he published the default, and served him the same day. 2 days later he was in jail. He did it wrong. That's not common law. Don't do it that way. you're worried about it, don't sign for them at all. The reason I started signing for them, they said, oh, well, this is no good, the debtor didn't sign. Well, we looked a little bit harder in their book, and it said, many times the debtor is hostile, and you will have to sign for them. Aren't they the agent? UCC 1103, principal over agent.
You wait 13 days if they don't sign and then publish it?
Then you start running the default. That's correct. Okay, where were we at now?
9.
We're on 9. You should sign the UCC 1 form without recourse and sent by accommodation, surety, guarantor, signature, of necessity, without prejudice, UCC 1207. You don't have to quote the codes if you don't want to.
Do you have to put in without recourse on there?
You can if you want. Use your own imagination. I signed some with prejudice because I know that they're not going to, I mean, by the time I signed for them, I put with prejudice. I already prejudged it. He didn't say no. Number 10, after you make the default public on the 1 form and the 4 form, you then move on to the UCC 3 form, the full assignment or partial assignment, by public filing for record in your county. Now, I'm working with a banker down in Arizona, and he says their R3 form here is their 2 form down there. So these are a little bit mixed up. It's supposed to be uniform, but it's far from it. This is the Uniform Commercial Code and Related Procedures Guide. It comes out of Anoka, Minnesota. You should get this book because it shows every state in the Union, plus the Recorder of Deeds, Washington, D.C. It tells how much to send in for a standard form, for a non-standard form, all the material you need at the locations to mail it.
What is the name of it?
Uniform Commercial Code and Related Procedures Guide. These cost about $20. And I'll leave it out so that you can copy the address there and get a book like that.
Who wrote that? Related Procedures Guide?
I don't know. I haven't really got into that. Let's see. It's put out by the Registry Incorporated. It says 514 Pierce Street, Box 218, Anoka, Minnesota. You can look at it afterwards and figure it out. But we've got 2 of them here in the place, and I'll give you all their procedures.
The Attorney General of Idaho has ordered all county recorders not to record these liens. What is our procedure now?
The procedure goes like this. Go down to the clerk and recorder, and since my average one used to be 100 million, I go down to the clerk and recorder, and I can do this by mail. I send a mandamus down there, a recipe, and I say, you will file this lien pursuant to your own rules and pursuant to the common law, or I will hold you for treble damage amount of the suit. And if you can't multiply, that means 300 million for you. And so she doesn't do it. Then the next day you mail 3 copies out to the county commissioners. And you say, since the clerk and recorder didn't do her job, now I'm going to have you do it for her. And then you remove her from office. And so you'll be charged 300 million apiece for treble damages. Now you're up to your first billion. Then you turn it around to the county attorney, you say, you prosecute all the people. Now you got $1.3 billion. Then you take it to the sheriff, and you say, Sheriff, would you arrest them? And if you don't, I'm going to charge you 300 million. Now you got $1.6 billion. Then you take it to the post office and say, post this on the bulletin board, and they don't do it. Now you got the post office for 300 million. That's 2 billion. You're into 2, aren't you? About that time, you're about 2 billion. By that time, you should be just about ready to buy yourself a van and a tape recorder. You go downtown and you play the recording so you don't get nervous. You say, hear ye, hear ye, hear ye, the old public notice. The clerk and recorder standing in default for 300 million. The 3 county commissioners standing in default for 300 million apiece. The county attorney standing in default for. I now have a $2 billion default, and I will be back next week and the week after. That's common law. You really don't care what they do. It's what you do. This is all ex parte. They're in it so deep they can't answer. Didn't Article 5, Section 26 yesterday that I was telling you about say, the legislative assembly shall pass no local or special laws, that is to say, respecting the pairing of liens?
That's in the Iowa Constitution.
Then are you worried about what the Attorney General does or does not do?
I just wanted to know how
That's an extra
to get the quickest.
That's an extra $5 billion.
Maybe we'll report him for a vacation in Washington, D.C.
This is real easy. Just plow forward with prosecution. Always attack, never defend. I declared war on the perverts about 5 years ago. I published it in the United States District Court via Montana. They blanked out the news in Montana, but Paul Harvey had it nationwide. My friends in Oregon told me about it. They never heard it on the news here. They were a little bit nervous.
Was that a notice of a mixed war?
No, it was not. It was a solemn declaration of war. I don't believe in mixed war because I don't recognize them as a sovereignty. Mixed war, you have to recognize them as they're not sovereign over me under my special character. Okay, where were we at? 11. You publish your default on the 1 and the 4 form one time a week for 3 consecutive weeks. That satisfies the common law judgment, what's called nihil dissent in the Latin means. Nihil means no or nothing. He failed to plead, he didn't say anything. And that gives you a personal judgment. Number 12, after the 3-week publication, you get a true and correct certified copy of the affidavit of publication from the newspaper publisher, and you file for public record said publication at the county clerk and recorder in your respective county. That gives you a summary judgment in the King's Bench. Number 12A, this is where you get into res judicata. After the entry of default for the 3-week publication, you publish a notice and opportunity to contest entry of judgment. One time only, you give the delinquent 72 hours to answer, creates res judicata upon the matter. That's a step we were leaving out. Go ahead.
On the 3 week, does that mean every day for 3 weeks or just one time a week?
One time a week, 3 separate weeks. But then when you do this, you're just saying to them, since the clerk entered the judgment, we're going to give you a chance to rebut the entry of judgment, that's all. Not that the judgment was wrong, it's the entry of it. Did I give you a good chance to rebut? Yeah.
On number 12, you publish it in the publication. What exactly do you publish?
Your default that you put in, the default that you put in the newspaper. We do have samples on the discs, not any samples in here necessarily. A short sample of what it looks like. I've got one in here, but it's not the ones we've done.
Is it a copy of what you actually send to Lloyd Benson or others?
No, just the default that we put publicly in. Just the default. Don't worry about the pleading. That's all over with. If they didn't answer, fine. Now we're only talking about judgment. How much? Who owes how much? Okay, 13. You keep original copy of all your instruments in your private possession. You attach all certified mailing receipts for proof if needed at a later time. Just keep good records. 14. After your publication, public filing for records complete, you tender your perfected securities to any bank or broker as collateral for special private collections. This is another area with many options, and instructions much too lengthy for this sample. This is the area we're into now. We do have a few limited amounts of requests so far. Not a lot. We've been looking into those, what some people call roll programs and all that kind of thing. But the players, a lot of them don't understand our paper. But a bigger problem is that there's a lawyer cartel out here that the perverts that they have in power today will shoot to kill when they find out that you know and that you're fighting the system. One of the best things that we've seen is selling our liens to other countries that are being pressured by the corporations. That looks like the best avenue. And we're working on a few of those. We're also working on a deal now. Supposedly there's a car dealer that got stuck with some of these and bought the cars and took them off the lot. He he is suing the car dealer, and the car dealer had indicated that it might be in his best interest to come to our side because he could make quite a bit, sell a lot of cars. I told him, I said, you get that pushed through court, I'll tell you what the papers to file, I'll tell you a little bit how to do it. And the guy was listening. How far that is, I don't know. But if we get that through, I was just telling you, it's a standing order for 100 cars and trucks at all times. Then if you want a car, you come here and you get we'll have an auction once a week.
What state is he in?
That's private.
You got a car. He's already got a car.
No, but I know the system. See, when we first got doing this, they had a little old FBI pervert named Tom Kennedy down in Billings. And he was stealing my checks. I tried to buy some computers on Micron Incorporated in Nampa, Idaho. But he stole my checks. And so one day I tried to find out, well, what are you guys doing with my order? It was a $175,000 order. I ordered about 7 machines at $14,000 a piece. Best thing they had advertised in the computer shopper. And this one woman, she finally says, well, we're working with the FBI. I says, great. We're working with the banks. They want you to defend something. I haven't leaned up Micron yet. But they're a very large company.
Sure, that's cool.
They make about $7 million a day.
In other words, if you stock at Micron, you want to get it out now?
No, you get this company negotiating with the new owner. See, unlike Bill Gates, I don't know all the computer lingo. I need somebody to tell me, what does this mean? I don't understand all those GUIs and all that stuff. So I need some help.
You need to go after Bill Gates.
Okay, let's get into the confession sheet. 4-page document here. You can make these as short or as long as you want. We usually run 4 to 5 pages. Some of them, our newer ones, are 7, 8 pages. As we go along here, we're hitting them with more and more UCC codes and more out of the Banker's Handbook, just driving a nail in the coffin. Because if they drug me into court today, I have done at least 400 of these. The discs are out all across America, and all I'd have to do is subpoena in the people that won. That's why they dropped the charges on Steve Gehring down there in Arizona. They charged him with forgery, and we sent the proof packet down. And the judge recused himself, and the new judge says, and I dismiss all charges. You're getting pretty hot. But they'll still pick up a few people to try to intimidate and spread some fear. They have to keep the slaves slaves, especially since some of the slaves found out that's what they are. Some of them don't want to be a slave any longer. Okay, on this now, the top of this form, this UCC 4 form, and there is no such real UCC 4 form. All their form talked about here was a security agreement. So we just modified what we thought was a good security agreement. We've kind of stuck with this form. The matter doesn't matter. It's non-standard, whatever you want to do. At the top there, we call it State of the Forum Common Law, UCC/MCA 30-1-105. The MCA stands for Montana Code Annotated, and our Title 30 here would be Uniform Commercial Code. If you don't know your state's codes, just go with UCC 1105. That still wouldn't be wrong. The NIL there stands for Negotiable Instruments Law. That 1105 is venue. NIL also, since it's under Negotiable Instruments Law, it recognizes private international law. Private international law means Idaho, Texas, Kentucky, Maine, Georgia, Florida. Does not mean across the water. Private international law also means conflicts of law and choice of law. And we're all foreign nations in relation, or foreign countries in relation to the District of Columbia, as well as to the other sovereign states, or organic states. Doesn't the Constitution say something about no state will enter into compact with another state? Did they? democracy people have. The aliens, corporations, they're all one. Isn't it true that a corporation can be reduced to a private party in a suit? So now we're suing the United States as a private citizen.
Because he who comes into equity with maritime contracts loses his sovereign immunity.
That's right, and equity also has a clean hands doctrine, which is called good faith in the UCC. That's why your paper is working and that you're showing to them. That's good faith presentment. How are they going to get around it? Okay. UCC 4 private security agreement, non-negotiable true bill. Then underneath that we say it means bargain of the parties in fact. That's their definition of the word agreement. We just threw it in there. And then we got Craig versus Missouri. I don't like case opinion. I don't use them very much, but I put that one in there to remind these suckers that they didn't want the money issued in the courtroom. And this case happens to be where banks in the countries, in the organic states, can't emit bills of credit. It's a felony. So what we're saying is stop the check cutting in relation to me. When you prove up, then I'll prove. I'll be able to perform. That's what you're saying. You're creating a stop.
I found something getting into researching counterfeit securities, and when they apply it by fraudulent conveyance, the regulation literally goes all over the place. But in that, in their own fine, the $100,000 fine for fraudulent securities, or counterfeit securities, but when the act is committed by a person against an individual, even by their own law, it's 10 times the amount.
Okay. Well, there's good remedy if you know where to find it. See, people have asked us, how come you can come up with $100 million? How do you justify that? And I say, well, if I get up that morning and I'm feeling poorly, then it's $1 billion. There's no limit to your liberty. I don't have to justify any price. All right, let's go through this first paragraph. You don't want to, or sentence. You don't want to change too much on here. Just make it fit for you, because these concepts that are in here, they can't get around it, and it comes right out of their book. So Lloyd Bentsen is starting to confess. He says, individually and as Secretary for the Department of Treasury within the United States, jointly and severally, he attests to these facts in this true bill. Under the principle of ignorance of the law is no excuse. And through presentment under 3, 504, 505, that's all that means is a good formal presentment that you gave them notice. Through principles of UCC 103 of undue influence, principal and agent, fraud, misrepresentation, coercion, mistake, duress, estoppel, all those things. Circle the word estoppel there because that's the concept that we're using to force the other side to realize that they've boxed you in, but their portion of the proceedings has caused your demise, not yours. See, they're saying, pay this bill. And you're saying, I'd love to, as soon as you create the medium that you're bound to have. It'd be like this. Let's say this is the vault over here. You go over to the bank vault and look in there and say, suspicions confirmed. There is no gold and silver in your vault. Therefore, I can't pay. That's why it says when you make proper presentment payable at a bank, not through a bank, with a pay-to instrument, and there's no gold and silver in the vault, you've got to stop them. So they have to give you like for like. If they can't produce that gold and silver by midnight of the bank a day, they're stuck for the full face amount of the instrument. That's UCC 3419 in the Banker's Handbook. It's also Section 2140. And we've got that proof in the packet later on. Okay, so we're going to hit them with contractual law in the state of the forum, common law, under UCC Section 1105, the conflicts of law, the choice of law. And so Lloyd agrees with the sovereign Leroy Schweitzer in his country of Montana as follows. After that, you start telling the diary of events. The who, what, when, where, and how. If you understand those concepts, who did it to you? What did they do to damage you? Where did they do it? When did they do it? And how did they do it? Those are all the concepts you need to get a good pleading. So we write this up as if he's saying, I, Lloyd Benson, did this to someone at a certain time, and I did it over here, and this is how much I damaged. Just say it like you're prying it out of it. They like agreements, don't they? Give them one they can't refuse. You don't care if he signs it. You don't care if he doesn't sign it. Either way, you win. If he signs it, you say, I'm guilty. If he doesn't sign it, and you take default, he's guilty. Remember, in equity, the burden of proof shifts to the party tender too. You're guilty in equity until you prove your innocence. And the reason this works is because you got prima facie evidence he works for you. He took the writ of covenant, didn't he? You got evidence he took the oath. Well then, why not make him uphold the oath right there in front of God and everybody? See, what we're pulling out of them is specific performance. But they can't perform. Guess who's been damaged? Now you've stated a claim upon which relief must be granted, and since they're in bankruptcy, and they admit they're in bankruptcy, and have been since the 30s, in bankruptcy the debtor can't state a claim. And this is why they trained the subculture to say, when you challenge these people, you write your first affirmative defense is so-and-so failed to state a claim upon which relief shall be granted. That's a catch-all, because most people don't know how to state a claim. But how about if you got one of these? And they drag you into a criminal proceeding. And you say, bailiff, would you take that man into custody? I have prima facie evidence he committed perjury. And besides that, this judge here, I bonded him. I pledged this security into the judge to collect the $100 million that's owed. And I'm sure since this contract court, the judge wouldn't violate his oath. See why they wouldn't want you in the court? It's guaranteed immunity.
Close that door, I can hear some people talking.
Well, but we'll have to ask them to quiet down because there's other people that are sitting in the hall that didn't get in the room. Either that or some of the people can come in and sit in this area if they'd rather. One of the other.
The talking is disturbing.
Okay. Maybe they quieted down. All right. Let's go on a little bit. Let's read the third one into the record just to get it on the tapes. I'm on page 1 of the true bill. It's a 4-page document. So Lloyd's confessing here. He says, I, Lloyd Benson, freely admit our IRS statute, as contained within the United States Code Title 26, must have supporting implementation to enforce the regulations in attempts to collect an assessment for a tax, or make a levy, or enter a lien into the foreign country of Montana as it relates to the sovereign Leroy M. Schweitzer. You can go on and on and on with these. If you got yourself some books like Vultures and Eagles Clothing, or IRS Humbug, or Which One Are You, or Goodbye April 15th, and how many others are out there. Many, many good books on the IRS scam. Well, pick out some good points, list them down there, and have Lloyd talk to you about it, or Ruben and all. The good way to start is, I, Lloyd Benson, either knew or should have known, in relation to the sovereign character in his other jurisdiction, that I was committing a fraud. And here's how I did it. It's real easy. Just confess for them. Because this is going to get made public. Once you make it public, it's a Supreme Court hearing.
This could work for any lower level agent also, couldn't it?
Pardon?
Any lower level official in the IRS.
Anybody that's, even if they're working for the administrative deal and don't formally take the oath, those that do it that way are still under delegation of authority. No way out from under the oath. That's the bond. See, isn't the Secretary of Treasury supposed to be good over all the IRS agents? Go for broke. And then take down every agent underneath him. I've even wrote these up against computer number 73. Remember those computer readouts? We designed them and answered the computer readout. I That's a quick way to pick up $1 billion. They usually don't answer. They love presumptions. Okay, let's go to the bottom of page 3 for the revenue. I'll read this one into the record. Lloyd's telling how much he owes. For my willful knowing participation in this conversion of private property concerning the sovereign, Leroy Schweitzer, I, Lloyd Benson, now know I must answer this courtesy presented within 10 days of this service upon me. For through my continued ignorance in law, coupled with the pressures my willful knowing criminal accomplices, I, Lloyd Benson, will become liable for the sum certain amount of damages occurring to the sovereign Schweitzer in this private matter for $100 million of lawful money of account, especially under our own rules, also known as Uniform Commercial Code, which was adopted by my criminal advisor accomplices themselves, purportedly learned in law. So now he's confessing up for himself and all the shysters. That's about all you have to say. Sometimes we say it 2 or 3 times in the document, how much they owe. Doesn't matter. If he doesn't contest this, that's the great part about their little presumption plan and agreement. Tender him a goodwill offering and see what he does with it. Most of them run to a lawyer. And the lawyer says, that's not worth anything. Put her in file 13. Now you've got a real good judgment. Then when you find out the lawyer that falsely advised him, you have a new customer. When we first started doing this, the lawyers were writing back and said, they told Dan, Dan, stop this suing this or I'll see you in court. And Dan said, what do I do? And I said, hit him with another one, double the amount. We have very few lawyers trying to answer these anymore.
It's amazing.
All he needs is a signature. Remember what I read yesterday, a right of privacy? Besides that, lawyers can't answer these. They're title nobility, remember? They can't enter our court. Okay, next little part here is the telling them a little bit why you have the right for enforcement. This comes out of their book. Let's just read parts of it. About halfway through that it says, this certified banker's check drawn without recourse by the sovereign, free inhabitant, your name, in your country of, without prejudice to the sovereign in his common law venue, stated before, under the Uniform Enforcement of Foreign Judgments Act. They admit to this. They have to recognize foreign countries. They have to recognize the gold and silver clause. If it's properly presented in relation to your character through a privately bonded notary public, that's what Dan was telling me, why you should be notaries or no one. Under protest, as in Rule 9E, Rule of Evidence 44.1, that's judicial notice of foreign law. Rule of Evidence 902.3A, B8, 9, that's nothing more than your common law notary from your foreign country. Enforceable under UCC 9501, and that one says, after personal judgment, any process that you deem fit, such as self-help requirement. If a fish and game warden came out here today and inadvertently parked his car out here in the lot, guess who's going to own that car before he leaves? We got a writ of attachment on it. It's lawful because we bonded the writ for double the amount. Who else can play this high-stakes poker?
How about an IRS agent if it comes onto private property?
Same thing. He sees everything that he...
So when it was closed.
Right, so when we were told some Portage sheriff was running around out here spying, perhaps he was literally running around, yeah?
It came out in other people that have come to the class, they said in other newspapers around, he said, every time he comes out now, 2 pickups chase him. That's true. 2 or more. The last time he came out, we didn't scramble quick enough. We had 2 people come to class here about 4 or 5 times ago, and they got rowdy, and they went into town, and they come back and told us what they'd done. Anyhow, the deputy sheriff there that night could have taken them into custody, had every reason under the normal procedures book. They didn't. All they said was, how many guns do they have out there? What do they have? They said, if these guys get their hands on us, they're going to lynch us. They're paranoid. They should be paranoid. We're going to stop the thievery. Okay, this is some of the things that we write up in these documents so that you get a good judgment on these people. You put truth in the document. You made it look like he said it. And if he doesn't rebut it, he agrees. It's real easy to do. If you don't know how to write these things, take our discs home. We have one disc, nothing but UCC samples, and then learn how to cut and paste. We've got them on every kind of an agent that's out there. Bankers, lawyers, sheriffs, judges, every office that's out there.
Corporations.
Right. Anything. There's something to fit there. And there are some people that have come to the class, and they send me back some of the ones that they're doing very well in their documents. Real craftily worded things that they're putting in there. They got the concept. You can use as much sarcasm, as much wit as you want. It doesn't hurt a thing. The other side knows. It's a double-edged sword. Truth prevails.
There's no way to fight the battle.
Well, this is one way to win. That's called remedy. Remedy means enforcement of a right. Okay, now the next, let's see, we've been going at least an hour. Let's take a break, about 10-minute break, and I doubt we'll get finished. We may, but if we don't, we'll finish after lunch. There's going to be about 20 minutes after 12. That's when we'll break. Okay, the part that we're into now is the UCC 1 form, and immediately behind that is the UCC 3 form. This is the warrant, what I call a warrant of attachment, writ of attachment, followed by the writ of execution. We made a few changes on this form. It's on our computer, and if you get our disk, you'll see this on the computer. Montana is one of the states that calls them an FS form. Kansas calls them an FS form, and I'm not sure how many other states do. Most of them call them UCC 1. What matter you could call it the UCC 1?
Is this what the IRS is supposed to fill out and send to the state when you file a lien on the person in the state?
I don't know. I don't really pay too much attention to the IRS anymore after I found out that they have nothing to do with me. And I sure don't have much to do with them except bill them. Okay, notice up there, right at the top of the line portion, it says non-centered, non-negotiable. And then we put that in there, and then down in the asset box, that's this area right in here, we wrote in non-standard, non-negotiable, non-federal form. We said it twice. You don't have to. We wanted them to be sure that we knew what we were doing. So they wouldn't misconstrue this that you were some sort of United States slave complaining about your debts or your limited liability that you asked them.
On your computer disk, are these forms blank?
Some of them are. We do have some, I believe, that are just on there blank, but I'm not sure that I gave you any totally blank ones on the disk. I have to check that disk out.
I see.
It wouldn't be real hard just to wipe out the language and create your own blank one.
Yeah.
It'd be real easy to do if you wanted to. Okay, on the upper left box there, the debtor, we put Lloyd Benson and wife, and then in care of the department, wherever they're at, in the city of Washington. And then we put comptroller of the currency as the co-debtor. The thought being that You know that the comptroller of the currency is a non-political office. That's in the old books. He can't become tainted in any manner. Lloyd Bentsen was supposed to be over the IRS and all that. He was liable for him, and he takes the oath, the public oath. So the comptroller has to keep the banks straight. So then the comptroller would be over Lloyd Bentsen if Lloyd Bentsen should have to slip a little bit in first of his oath of office. You know, you can look to the comptroller for the surety because the NA banks are covered by the comptroller. And Norwest Bank happened to be an NA bank, National Association. So next box there is the secured party. You put your name, your mailing location, and then I put my prepaid account number under there, the 85207 number. That was my United States District Court escrow, we might call it. I put the wager of law, the $100 in there, and they opened up the account. Well, we've read some more out of this. Let me see if I can find the book. Yeah, this book right here. This is a grand jury subpoenaed book from the system. And this has all the United States codes in 1934 in one book. We have found in here where you can open up, anyone over the age of 10 can open up a savings account at the post office for deposit and withdrawal at any time. The post office is the national bank.
Well, Leroy, I was telling Leroy here yesterday that I've been checking out the address on the Postmaster General, and the post office sent me a history of the post office from 1775 to 1995, which I'm going to get Leroy. It talks about postal savings accounts. You can go to a post office and open up a savings account. And most people aren't aware of that.
Right.
Just like what you're saying.
It is a bank. Why is it a bank? Anybody got that clue? That's correct. Back when they had gold miners and they were digging the gold dust and they needed some groceries and they couldn't mint their own coin, they took it down and traded it for a bill of exchange. So they could immediately have commerce. This is why you have in Title 28 at this day, even in the newest Title 28, Section 1743 says demand on postmaster. And when the postmaster dishonors a protest, then you move to Title 28, Section 2710, which says put a writ of attachment on the post office, seize all commerce until they honor your bill. That's the enforcement that we're looking for. We haven't done it yet, but we will, and we're going to do it in a roundabout manner. We're going to let greedy banks do it for us. And there are greedy bankers.
How are you going to do that?
How? The easiest scenario that I see is one of these countries that's under the gun to the United States corporation. And the United States says, you will pay this much or else. How about Mexico? Do you think Mexico would like to bail out real cheap? All they have to know is our paper. We've had traders look at our paper and they said, this is virgin paper. This is not encumbered in any manner. This is more valuable. We just haven't found all the players to move it.
When you mentioned the banks having an NA behind their name, in Florida, Sun Bank used to be an NA, but most recently converted to Sun Trust. Will that limit my ability to go against them with this paper?
No, it wouldn't limit it because if you live in a foreign country, they're still bound by Article 1, Section 10, Clause 1. You just have to bring forth the fact that they're in violation of the Constitution. Then you also have Article 4, Section 1, full faith and credit. So you get a common law judgment in a justice's court or a Supreme Court in the county, which is nothing more than publication in the newspaper. Then all courts in America have to honor the judgment. That's what full faith and credit means. And this thing is getting closer and closer because we got some people that, Dan has some relatives that were down there in Salt Lake area, and they sent us a picture of the dual seal on some of the banks down there. We've heard about it from other people. That's the first time we got a colored picture of it. They've got a gold seal in the certain banks, and that one's based on the full faith and credit. We understand they're pulling the gold back in. It's probably back in there. We've heard the National Guard's been pulling the gold back. I don't have proofs of that, But what we do, the little bit of feedback we get on the inside, there's a massive turnaround. In fact, this, whether it happens or doesn't happen, we've heard time limits. Supposedly the bank switch will be the 16th of this month. We don't know yet.
Does this also apply to credit unions?
Yes, it does. There's a little bit different twist with the credit unions. They're even more vulnerable than the banks because they have to accept anybody that comes through the door.
But typically, they're all working through the Federal Reserve System. They all have liability. There are no private banks.
Okay, let's go over to the next box on the right, Montana Secretary of State Filing Officer or Notary, and that's how their form was, and then we put the words or Notary Public in the country of Montana. That's because they started to refuse to file the papers. So we moved the alternative. You have authority. A Notary Public is the deputy registrar in the county, if you can find it in the codes. Dan might have told you the code to look it up, but we...
What page are you on?
I'm still on the UC1 form.
Okay.
Upper right block there.
Okay.
Come down right below that, and you'll see the assignee form there, the box, and I assigned this over to ROS Trust, and made the comptroller of the currency, and the General Accounting Office at the Office of Postmaster in Bruzette, Montana as the co-assignee.
What is the ROS Trust?
It's a private trust. A friend happens to be Replevin, our Savior, and a lot of people think it means Rodney Owen Skirdoff. He's out the other way. All right, the next box underneath that is the record owner. You don't have to put anything in that one. We just did because these were witnesses in the speech. That was our 3 first commissioners here. That's all. Just witness. Then in the asset box now, we've changed our newer forms. We say all personal judgments, $100 million of lawful money. We put the value there now because when the brokers come to the house and say, well, where's the value? Instead of having to go look up the UCC 4 that had the explained amount, now you got it right there on the attachment, spelled out. This is what the judgment cost. Then the rest of it's rather generic. You just kind of name everything that the guy thought he could have owned or any of his partners could have owned. It covers just about everything. If you want to be more specific and you know that he has a red car and a black house and where it's located, you can put it down real specific, but you don't have to. Then we've also put that security. We tried to go a little bit like the commercial lien process, and the reason we did that, we were putting these in for public recording with that outfit in Boonville, Indiana. We tried it a little bit. It was, I wouldn't say good, bad, or indifferent. Then we went to totally filing by ourselves here. We have had quite a number of these filed in Washington, D.C. That's the ones we're relying on the most at this point. I just tendered one to a banker the other day in the tune of about, well, the total value on them is $2.1 billion and 20 or 30 liens, I guess. They're all in the, I don't know exactly how that figures out, but it's quite a bit on each one. Those are duly recorded in Washington, D.C. with a recorded deed number on it. They were done 2 years ago, before the system found out what we were really into. We've got enough to keep the country running for quite a while on the stuff that's already in there. We don't have to worry so much about whether they do or don't file ours anymore. Rod happens to have one lien for $922 trillion on the United States.
Back in the 30s, they looted the Social Security Interdegos Trust, not the trust fund, but the individual fund purported to be $588 trillion. So there's a lot more trillions in that deck.
Well, it doesn't really matter the value when you understand the credit game. Credit has to be performed in the future. That's all that's out here, since there is no money. So all we did was signed all the credit to us. We can't cover the gross national product. In instead of them running to the Federal Reserve and say, hey, we'd like to borrow it from you for 9%, they can come to us probably for 1%. See, we're not held to minimums. Pretty good competitor in town, and they know it.
We could be a Federal Reserve.
Okay, on this next one, let's go down a little bit where it says number of additional sheets presented. I didn't mark that since this is a sample. This is not exactly how ours was filled out. But let's say you had the 4-page UCC 4 True Bill. You'd name 4 additional sheets. Let's say that you had Lloyd's copy of Lloyd's oath of office. That'd be 5. Let's say some IRS agent had sent you a bill and you had his good signature on it. That'd be page 6. These are your attachments, your exhibits. They cost you about $2 a page. That's not that much to spend when it's secured by $100 million. Small investment.
Where do you receive it from? Both the office and the IRS.
Well, Benson is supposed to be on file with the Secretary of State in D.C., and most of the others are on with the Secretary of State in the states, and if not, they're with the clerk and recorder in the counties. That's where the oaths are supposed to be kept.
But now they'll have to make one change because Lloyd Benson's not in there. But Robert Rubin.
Right. This is just an older sample. Benson stepped down about a month after this happened, but it wasn't because of this lien. It's because he has a little grand jury problem. Someone found some arbitrage funds that total in the trillions, and they stuck their hand in the pile and got caught.
What's an arbitrage?
Arbitrage? It's a trust fund. It's just a special savings.
This was
Go ahead.
this was Benson's trust?
It belonged to a private party.
On the box, the number of additional sheets presented. Just above that, it says counties. Over to the left, all 56, and that's for Montana only.
Right. Yeah, we have.
Whatever your state is, the number of counties
Right.
are.
Yeah, we're just listing them all just in case. We don't know where they hid their property, but we're going for it. All right, now the next line is already subject to a security interest in the country of Montana. On their form, it says state of. And just to get around that argument, small s state or large s state or corporation state, we call it the country of Montana. Now there's no argument. And further, if you study into that, when you bring it into one state from another state, what you're saying is your jurisdiction has to recognize our jurisdiction. If they don't, file a letter rogatory on it, and under the full faith and credit, you've got comity of the courts. That's what letter rogatory is all about. Next one, you go, the small print there, set by UCC 3415 by accommodation. I put without recourse and with prejudice. He didn't answer, so I didn't have any other remedies available, so I did with prejudice, saying he didn't answer. I've got a good judgment, and now he's liable. And see, whenever you sign by accommodation, and you sign it over to an assignee, now you break away from him one step further, and he can't come after the assignee because he's forever barred from bringing suit. See, he would be impairing the obligation of a contract. Just like the sheriff's immune when he files a writ of, or does a writ of execution. But see, the sheriff has to bond. But the bond between myself and ROS Trust is private. If you understand privacy, you win. They lose because they took an oath that they couldn't break your privacy. Okay, then on the lower left, I did not sign for Lloyd Benson. Don't ever sign their name. Sign by you. And I signed for him after he defaulted, not before. I signed the lower right on that when I initially sent it out. Okay, let's go to the next. One more comment there. I signed it off. Teste me absent. The wording there, the Latin words, means signed by the king himself.
You put under there USSEC gracious flag?
Yes.
Exactly what does that mean?
Well, on the commercial liens, they were U.S. Securities and Exchange Commission tracer flag. That's what they're into that. I didn't find that was necessary or unnecessary. We just did it for a while. We didn't do this on all of ours. I've dropped that particular style of filing. It's not necessary the way we're doing it. We've got a good protected security. We've had enough traders look at it. We've had bankers look at it. We've had lawyers look at it. And there's not a thing wrong with the way we file. What we have here, CanTrade, which happens to be a Swiss bank who is going to be leaned up heavily, took some of our paper and ran with it. They were going to sue the feds for us. But when they saw our paper, they said, you have T-bills. Why? You know the comptroller of the currency isn't going to perjure his oath of office. And you know that every general accounting office, postmaster, who are all notaries, aren't going to perjure their oath of office. I'm just betting on the full faith and credit of the United States of America. Why do you think they have a writ of attachment on the post office? Can you imagine how quick they'd pay your bill if you went down and seized the Fort Worth post office and all the people on Social Security would go down and hang the congressman because they weren't honoring your bill? See how quick it comes to a head? They can't impede commerce.
Can this be used against foreign corporations operating in America?
Can be used against anyone who violates a contractual right.
Can we go after their property, say in Mexico or...
Anybody that violates a contractual right, you can go worldwide if you need to. Common law didn't restrict you. God's law is all over. Go anywhere.
I have not to mention any particular name, but I happen to know a big lien that was against Boise Cascade, and they moved their head of operations to Mexico, and now in Idaho it says, on television it says regional operations. But they can't get away.
Okay, let's go to the 3 form. This is what we call the writ of execution. It's quite similar to the way we doctored up the form, if you want to call it that, and we have authority to write non-standard across all of this if you believe their code, because Article 9 says you can do it. In fact, if you read that carefully, it says anything in the following format will do, or anything similar to this. You don't have to have the lines. You just have to say who's the debtor, who's the secured party, and what did you attach. Just a little bit of pertinent details. You don't have to be fancy about your forms. So we got Lloyd Benson Wife as the debtor, comptroller is the co-debtor. Everything there is about the same. Now the next line down, this statement refers to the original financing statement, file number so-and-so, 0025 Garfield County. Tie that number into your 1 form so that the 2 become 1. Always have the same number there, the same public number, so that the writ of execution ties into the writ of attachment. That's all. Just keep that number. That's your main number. Then we sign partial assignment rather than full assignment. In this respect, I've got Sheridan Trust trying to collect the $100 million, but let's say a broker came and he wanted $75 million. I would tell Dan, I could tell him privately, I'd say, well, that broker took $75 million of that collateral, and so I just want you to go ahead and collect on the 25, and you don't have to make it public. That part you can keep quiet. So this gives you a whole bunch of variance. You can move any way you want with that. You're still looking for the full value, but you got 2 collectors. Now the next slide, this is not how we did ours, but to show you as a sample, if you don't know how to open a bank account, do it this way. Write your bill of exchange right on the UCC form. We paid off Rod's house over in the Bull Mountains, what they call the cabin. The IRS wanted his house for $200 minimum bid. They tried twice. They published it. Rod was in jail on a traffic bogus deal. So I got their forms, and I said, pay to the United States Bureau of Internal Revenue $2.65 million, drawn from the IRS agent who was in default for $100 million. We took the IRS agent's default and paid the house off. 5 days later, the house was off the market. It's never been put on the market again. I don't care how many lies the newspaper puts out there. And what was really funny is Rod kept getting the property tax statement for 2 years after that. They said that the U.S. had bought it. Somebody lied. Okay. Here again, I signed for Benson on the lower left after he defaulted. But you don't file these threes until you publish your default anyway. So let's say that you got a good default on the 1 and the 4, and you file at 11:01 in the morning. At 11:02, you can file the 3. Just don't try collecting on the 3 until the perfection of the default on the 1 is complete. That saves you about 3 weeks publication time. See how that works? Then the minute the 1 is perfected on the default, then the 3 is ready for sale. Now here's a kind of a catch-22. A lot of people don't get this concept. Once you get the 3 form done, all perfected and done, you can take it down to a banker, and either across the face or open it up on the back like this. You can, let's say this is blank, you'd write special deposit, restricted accommodation endorsement, paid to First National Bank. You can write on this, special deposit, restricted accommodation endorsement, paid to First National Bank. Hand it to the banker. Restricted accommodation endorsement. If he doesn't put it in your account and credit you the $100 million by midnight of the banking day, you can write checks on that bank for $100 million. Right after the protest. That's in their book. See, non-acceptance of putting money into the bank is just as bad as non-payment after it's out of there. Because isn't it true, all they are is transfer agents for bills of exchange because there is no money? Otherwise they'd be impeding commerce and violation of the corporate franchise. It's in their book.
Do you remember the reference in their book?
UCC 3419, and it'll be in this packet. We'll get to it in a minute. Criminal conversion. Their only defense is forgery. Non-acceptance is acceptance in the code. Protests are deemed waived in the UCC except for foreign countries. Remember the second article of the 14th Amendment? The U.S. slaves can't challenge the validity of the public debt, but American nationals must. If you want your country back, start the protest.
Yeah, they say it shall not be questioned for the controlling of insurgencies, blah, blah, blah. Pursuant to Schaefer versus Huckner, they recognize us as members of a band of insurgents who are stateless and have special protection and immunity under international law known to the United States Corporation as Americans.
Yep, name calling doesn't matter at all. And in my realm, it's quite costly when they libel my character. They call me an insurgent. I call them infidels. But it comes with a price. Usually $100 million. Okay, we have a little handout here. I'm going to give it out now because this ties in to the, once you do this might be a little premature to, you did hand out, didn't you? On the thing about it, this will tie into our protest, and that's the part I'm getting into now. I haven't had this in my presenter. It was given to me. Looks like it's good information that will help you to understand why you have the authority to tell the bank you are stuck. Banks don't like it when you know. They're going to bluff. They'll tell you that we can't take non-negotiable instruments. The code says something different. So anyway, if you make these tenders, and you take this piece of paper, this will get you started in your study program, and the banker is going to be under a liability because he had notice. This is like private clearinghouse rules.
Can I tell a quick story?
Go ahead.
Last Wednesday in Salt Lake City, a mortgage banker, one of the people who have been up here working with Leroy, went to a bank with his mortgage banker to pay off his mortgage. It was a very sizable check. And the clerk says, "I'm sorry, we can't accept that." And the mortgage banker hands to her. She said, "I think that you better read this." She went down on this. She said, "Excuse me," was gone for 15 to 30 minutes, and you know the scenario, all the way up. She came back 15 to 30 minutes later and says, we will accept this and make the payment. Now, he called me up here the other night and the bank had not notified him. They have about 3 days to notify him by midnight. And if they don't, it doesn't matter whether they accept it or not. Like Leroy says, non-acceptance is acceptance. They knew if they did not accept that tender, the bank itself was liable for about $800,000.
That's right.
But the mortgage banker also said, I don't believe if we had not had this, that they would have accepted it. Because what they're finding out, they look down at the quotes on this thing and find out that we know what we're talking about.
Are you talking about this piece of paper?
Yes. Now, there will have to be a couple of changes because Leroy has changed the check that he's bringing out. Down on this, you'll see comptroller warrant, cashier's certified banker's check. He's now changed the title on it, so if any of you elect to use it, just change the verbiage on the check that you received from Leroy to match up what's on this.
The new one.
Step 2.
Oh, comptroller wants to steer.
Yeah, you can, the comptroller warrant's fine, but he's
I know what I'll
taken
do.
off
Certified banker's check,
certified banker's check and is using check lien.
that's in step 2.
It's called lien draft,
Lien draft,
That's
okay.
rather than certified bank check.
So that's all you'll have to change.
Okay, the next portion now that we're getting into is the protest. And I'm not going to make fun of the people that are here, but I'm going to say it this way. Don't take offense. This is the part that people don't get. So I start out by saying, this is the time to wake up and remember what I'm saying here, because you're going to call me up on the phone. You can say, the bank said it's non-negotiable and it isn't good enough. They're going to keep it, but you still owe the debt. Now what do I do? And I said, you slept during the class. This is the part of protest. And so if you don't know what to do when the bank sends you back any kind of a nasty note, you protest. You protest, and you protest. A notary public does the protest. I can't emphasize that enough. That's all our phone calls coming back. Now what do we do? I say, what did we tell you in the class? They don't know why they should protest. That's the concept that's missing here. I can't tell you in one little short hearing here why it's so important to protest. But that is a formal recognition that you came from a foreign country and you have a right to protest, and it's your duty in order to collect and keep them under the gold and silver clause. If you don't, the presumption is that you're 14th Amendment. And then you come under acts of Congress, which gave you your birthright instead of your birthright coming from God.
Can a protest be made against anything, any kind of movement that the corporate court is taking?
That's right.
At any point in
That's right.
anything?
That's right. You have a right. What's Article 9 of the National Constitution say? Enumeration of certain rights shall not be construed to deny or disparage others retained by the people. Anytime you've been wronged, you have a right to state a claim. In any manner that you want to.
And you put the value on it.
You do.
That's why I said you put the value
Yeah,
on it.
that's right. Okay, on this protest now, what we've got is, in this packet, we've got 3 forms. This one came out of the Oklahoma book. It's quite simple, and it gives you an idea who is one sent to who, and another one sent to somebody else, another one to someone else. Pretty good form. I don't use that one so much. This next form, page 155, it came out of this little book, right here, Burgess on Commercial Law, page 155, that's where I copied it. This come out of garage sale. Doesn't matter, it's true, it all matches up with Anderson. This is Anderson's study here, some of the code books on the UCC. This is good study for you so that you'll know exactly what we're doing. I've got quite a bit of that at the back end of the packet. This form, the reason I like it, it tells you what to do. If you understand this page, then you won't have to call me up and say, what do I do now? Because this says this is what you should do now. When the bank dishonors or refuses your check or gives you some sort of a phony excuse, do this. Do number 1, then do number 2. See, there's the instructions. And then there's the sample when you complete the instructions. This is a good teaching thing here. If you will read this and study your packet, if nothing else, when you leave here today, tear this sheet out and keep it close to you so you can find it. So you don't have to dig all back through and go all through. Remember what this page said. Then you're getting close to home. Maybe that'll help. So you would tell them the time of presentment, the place, the fact of, the fact that payment was demanded, the fact of the dishonor or the non-acceptance, the name of the party to whom you presented, the name of the party by whom presented, and the copy of the instrument that you presented should be attached. Or if they keep it, the trick is, they keep it and say, well, you still owe the debt. Not that easy. If they keep it, you're discharged. See, if people want to defend that, all you'd have to do is write back, thank you for the acceptance. I noticed that you kept the check. You see why they have to keep them? I wrote the check.
Send it to the FBI.
They kept it, didn't they? In order to... Just listen to this. I wrote the check. They have to dishonor to me. If they don't send it back to me, it's acceptance. That means my warrant cleared. I have not gotten the first one back yet. Why can't they send it back? Because I have a standing criminal conversion complaint on Norwest Bank with the sheriff in Silver Bowl County, and if they sent one back, I'd have not just prima facie evidence of conversion, I'd have them for conversion. I own Norwest Bank for almost $1 billion. It's my credit.
If I go to your bank, will they give me a good rating?
That's right.
What do you charge our credit card? What do you charge our credit card?
Okay, next page. Here's another form. And I just threw a few in for variance here. This is the one we use quite a bit. And you have this on the disc. Now you'll notice down here where this, thus done and presented in the city of Jordan, in the presence of 2 witnesses. In the old books it says you don't need a notary. Just get 2 reputable characters in the county and use them. Does the Bible say, and I have 2 or 3 witnesses shall the matter be settled? The old books say the same thing. But since the system's a little bit depraved right now, don't worry about it. If you don't have 2 witnesses, leave them off. If you do, use them. But go ahead and do the common law notary. Either way you win. You can't hardly mess this up. Just copy the form and then insert what's relevant there, the bank's name, and did he accept or did he give any lawful reasons. And when they come back with this gobbledygook and say, well, you sent us a non-negotiable instrument, you still owe the debt, you realize that's all true. How can you pay the debt with a bill of exchange? You still owe the debt, that's right. But you can't pay. They caused you not to, so you're discharged. But you didn't accept the implied consent, limited liability, benefit. See, you forced the estoppel yourself, and so you can't be held to a benefit. Equity has some good rules too, called clean hands. He who enters equity must do so with clean hands. Okay, that's the one we use. Not that one's any better than the other. Just 3 different samples tell you how to do it. Now remember this, you don't protest. Your witness, your public court, the notary, does it for you. Because you can't, a man can't judge his own cause. Otherwise you become an island to yourself. You must deal with the witness, with your neighbor. It's part of the biblical concept. Okay, out of the book I told you about, this thick book with all the codes. This is where we got it, 1934 edition. I didn't write that on there. But here you've got section 131, protest of notes. It says, whenever any national banking association fails to redeem in the lawful money of the United States any of its circulating notes upon demand during the usual business hours, that's about all you have to read there. Now let's go down to section 133. It says, if from such protest and the report so made, the comptroller is satisfied that such association has refused to pay its circulating notes and is in default, he shall, within 30 days after he has received notice of such failure, declare the bonds deposited by such association forfeited to the United States, and they shall thereupon be so forfeited. What you've done here is created an involuntary bankruptcy on the corrupt corporation in relation to the organic states. Bankers call it hostile takeover. And in common law, you get to do it with a party of one. In statute, you have to have 3 parties to bring it in. To bring it in. That such association has refused to pay its circulating notes and is in default, he shall, within 30 days after he has received notice of such failure, declare the bonds deposited by such association forfeited to the United States, and they shall thereupon be so forfeited. What you've done here is created an involuntary bankruptcy on the corrupt corporation in relation to the organic states. Bankers call it hostile takeover. And in common law, you get to do it with a party of one. In statute, you have to have 3 parties to bring it in. To bring in an involuntary bankruptcy, common law, you can do it by yourself. This is tumble down banks. I used to fly airplanes for a living. Now I've been forced into being a banker. Oh, when he's trying to trash the bank. Okay, next section comes out of the banker's handbook. Let's see if somebody, I think somebody took my banker's handbook in the other room. But anyway, I just usually hold it up so that you can see it. But anyway, this was copied right out of the banker's handbook. And the bold marking there, this is in the section on collection of instruments. It says, and furthermore, the collecting bank may accept credits in payments. I told you yesterday that we had a lawyer, we called him the Snake, but he used to pretend he was on our side. He was feeding us with some information. He told us that he paid his IRS bills with his deadbeat clients. Accounts receivable, isn't it? Yes, it can. That's right. That's all that's out there. It's either credits or liabilities. Assets or liabilities, isn't it? The banking system operates on an imbalance. That's all. And their franchise is to not impede commerce, just move this stuff through. If you don't move it through, you impede commerce, you impair the obligation contract, and you're totally in default of the franchise. They're debtors in possession. What sticks them is when you have them a pay-to instrument, and it's not payable through a bank, it's payable at a bank. Then they become liable on the instrument because there's no gold and silver in the vault. See how it works?
Now, is there some way, considering with the Federal Reserve note scam, when they take the gold certificates they're paid the face value of the notes on and trade them overseas, they're penalized in 187% surtax. That 187% surtax we can use because they're going over state lines and into a foreign jurisdiction.
Okay, this is the method that we've created here is kind of, instead of calling your congressman and demanding an audit, isn't this an ongoing audit? Yeah. Party of one. Don't worry about the things you can't control. Worry about the things you can control.
A lot of slush money.
Can you lean the Federal Reserve?
We did.
What? You mean there's no money left?
They said there's no money. There's a lot of credit. See, we're taxing the strangers.
Like kind.
That's right. Okay, now let's read this part that they admit to, and their duties of the bank for collection of interest. Section 2140 says here, when items for collection are sent directly to the drawee bank, the bank's under a dual capacity to act as agent for the owner to collect from itself and also to pay the instrument as it is the drawee or the person primarily liable on that instrument. See, pay two instruments and eliminate holder due course. You merely have a holder. So when you hand this little hot potato to the banker, say you're the banker, and I got that little tender here, when he touches it, he's liable. It don't go any further than that. He's stuck. By midnight in the banking day, he has to perform. And since there is no gold and silver, you've created a estoppel, and guess whose fault it was? And so if they don't honor it, then your next move is criminal conversion on the bank, because you caught them with the hand in the cookie jar and they can't come back with the gold. All the goods are gone.
Money back in the bank? Is that why they're starting to put some of the gold back in the bank?
What do you think? Okay, now, here's some more that they admit to. In the collection provision under the commercial code, the bank has until midnight of the day it receives the item to settle for it, and until midnight of the next business day to pay, to return it, or to send notice of dishonor. I've told the people there's three options for the bank. You're going to win on all three options, but here's how it works. Let's say you tender it to the bank and they accept it. You won. Let's say you tender it to the bank and they, what was their next choice? They return it. If you protest, you win. Let's say you tender it and they send notice of dishonor. And if you protest, you win. The secret is protest.
Do you have to call it a protest?
Pardon?
Do you have to call it a protest?
Yes. It has. It's a formal protest.
That's when you serve on the protest that you've written out.
That's right. That one, any of those forms, that's when the notary says, he's your witness, and says, here, I've got you a default. You didn't pay. I'm the public witness. We're looking to you for payment. It's summary judgment. That's all it is. Done by a notary. That's why they say in their records that they're liable for the full face amount. Right. There is nothing else out there, is there? So then if they don't redeem back to you in Federal Reserve notes, that's how much of that bank you own at midnight of that day.
I have a note down here, Rule 902.
Yeah.
Can you explain that?
That's common law notary in a foreign country. Okay, we're going to go one more here. I'll finish this, and it's lunchtime, and then we'll have to take a little time after lunch to finish. Now, the bank says, this is the best part I could find. Somebody was asking, how do we get the bank for dishonor? This is it. If the bank fails to act within this time, it's accountable for the amount of the item. If the instrument is properly presented for acceptance, failure to act within the time allowed for acceptance will make the bank accountable. Under the commercial code, refusal to pay or to return an instrument amounts to a conversion on the part of the bank, and it's liable for the amount of the instrument. In practice, the bank's duties are about the same under the commercial code as they were under the previous negotiable instruments law. They said it. Okay, we're going to take a break for lunch. It'll be about, let's say 40 minutes or so, for whatever it takes, I guess. And then I've got probably 20 more minutes of presentment before we get into the present matter. Okay? Bank name under Acme Amusement, you'll start to see the picture. I'm on this page, right behind that 20th century back side of it. That one there is very good evidence as to what the protest It's confusing at first. It's really scattered. It's done purposely that way so nobody can figure it out.
Where are you?
I'm on this sheet now, UCC. It's some definitions. And I just randomly picked a few that I like to use. If you knew these, and knew them pretty well, then it'll expand you out into more codes. Pretty quick you get the picture of what we're doing on our liens. That first one there, UCC 1105, that's what I call venue. And that's their definition right there. The 1103, we went through that pretty good on the UCC 4 form. That's the concepts of contract law that they are bound to, if you know how to pull it up. 1207 is reservation of rights. Most of you know that. The 12013 and 12011 are the difference between agreement and a contract. As you get well versed in the UCC, you're going to see that the Uniform Commercial Code operates under presumption. Everyone's in agreement. All the slaves agree, and the slaves can't disagree because they asked for public policy. Only the American nationals can disagree, and then we hit them with contracts. And so what we're saying is, wait a minute, you did not fulfill the elements of a contract. We're not going to abide by that agreement. Here's why it works that way. Contracts have three major parts to them. It's called the offer, the consideration, and the acceptance. Agreements have one of those major parts. It's called the offer. If you don't rebut the offer, then the presumption is you accept it, and therefore you haven't been injured. Go to contract law and you'll win. If you stick with agreements, you will lose. You must call in the consideration of a simple contract, otherwise you can't win. And the calling in the consideration, what we're doing here is the protest. What you're saying is, give me the gold, bring the gold and silver back, and then we'll have the completion of our contract. But they can't bring it back. So now you've been injured. Okay, then 121, 34, and 36, rights and remedies, they're synonymous in the code. It's an important concept to remember. 3103, that's their own definition. Article 3 is commercial paper. And it says there, we do not deal in documents of title or money. So what do they deal in? Bills of exchange. There are 4 types of bills of exchange. What are those? Notes, checks, drafts, and certificates of deposit. That's all that's out here. 3505 is presentments, and that's the formality of making a good presentment. 3415 is the accommodation, the surety. 3419 is criminal conversion by a bank. We'll get into more in the end of the packet here. 5105 is a letter of credit, and it says there no consideration needed to enlarge or otherwise modify a credit. Well, this is great once you become the creditor. See, because if they can't give you the substance for the credit, then they have to give you like for like. Whatever is circulating medium at that time, that's what they have to give you. If they can't produce the gold and silver, they would have to cash in your securities, your perfected securities, for Federal Reserve notes. That's instant at the midnight hour, if you know how to pull it up. 9501, any judicial process after default. That's after your 9 of that set, your summary judgment, your personal judgment. When they don't say, when they don't answer. 94031 is filing for public record or upon acceptance by the filing officer. We place too much emphasis on their filing officers filing these. It does not matter. The minute that you can prove that you paid the filing fee and that you mailed the instrument out, it's filed. They love presumptions. Feed them with presumptions. It's their own book. They said it. If they don't dishonor or rebut it, it's a done deal. 3601 is discharge. 3509 is protest, and 3604 is tender of payment. You can get just broaden the thing out, continue and continue. There's lots and lots of codes if you want to get the concept. Now the next section is a 3-page affidavit. This is fairly important to file when you file your default, because this one will keep you out of jail. It's the one that says, I know what I did, I know why I did it, here's the law I relied on to do what I did. And so you really get the first punch at them. So how can they prove criminal intent when you said, here's what your law says I can do? It's the best way to get in the door first. And so you file this with the clerk reporter when you file your default. Now, don't box yourself in a corner with this. Don't boilerplate the thing. And notice I put the Mayflower Compact in there. Have you read it? Do you know where to find it? Then don't quote it. Don't boilerplate it. Just write the things that you know about. You don't have to have all of it. But if you're interested, go get a copy of the Mayflower Compact and then put it in there. It works. Okay, on the second page there's quite a number of codes. Now there's one that I like and use a lot, and that's UCC section 120144D. It's right in the center of that first paragraph. I'm on the second page of that affidavit.
44D?
120144D. That's the one where they call in the consideration sufficient to support a simple contract. This is what the people are missing. If you don't call it in, you haven't been injured. This is where you're saying, I have to have a medium of exchange which is substance, not bills of exchange. You can't pay a bill with another bill. Bills are collection items. They're not pay items. Dollars of money are pay items. We don't have any dollars of money, they said. All we have is collection items. There are no pay items. You see the impossibility? The law does not require impossibilities. Force the issue. Then you get injured. If they come after you, then you go in for conversion. This is a catch-22, and they're caught. Now I quoted 3405, or no, 3407. I don't remember that one. I don't have it memorized. But if I got drug in front of one of their chancery judges, and he said, I noticed that you pulled up 3407. I said, yes, I did, and I got it out of Anderson. And since you're purportedly learned in law, you wouldn't mind bringing in Anderson so we can get it word for word, would you? Because you're going to set me free. See, never defend. Always attack, never defend.
What code is that?
3407. It's just all I'm doing is giving you an example how to, once you read this stuff, you don't have to have photographic memory. Just remember where you read it, did it fit back then, and can you pull it up again? Don't make it harder on yourself than you need to. This is an affidavit. Affidavits are true. If you found it was true one time, just hang on to the affidavit. If you got jerked into the court and it says, here, I want you to testify, you say, Bail, would you swear me in? I'm going to testify, and anybody that tries to deny me the right to testify, I'm going to declare a mistrial because I'm being denied the right to present evidence. See how quick it is? And then you read it, and then the attorney says, well, since you brought that up, I'm going to cross-examine you and say, what did you not understand on the affidavit? It's already in the record. Can't be cross-examined. It worked. Dan did it. He did it for Richard Clark, and that, when we did that and the judge ran out of the room, we understood something. Never banter with the judge. When you go into court, into their court, first thing you do is get sworn in and read your affidavit. Remember, affidavits are special proceedings. Special proceeding come under Rule 81. Rule 81 exempts you from the rules. Rule 81 ties into Rule 2 of Federal Rules, which is saving to suitors clause. You can't lose when you put affidavit because affidavits are true. And you've already prosecuted your case. This stuff is simple if you understand. And you get to do the affidavit when you're not all flustered and under pressure. So just take your time, sit there and read the affidavit for a day and a half if you read slow. It doesn't matter. It's court of record. Okay, let's go to the next page. This is a notice and entry of default by affidavit. Some people said, well, do you have any samples of default? Here's one. Real simple. Next page. Okay, I think I'm a little bit out of order here. There should be a notice of the contest entry of judgment. This is a little out of order on mine. I had a couple pages forward. This is the one that puts it in the form of res judicata. Notice for contest and entry of judgment. You would say to them, you got 72 hours to answer this. If you don't, judgment was perfected and you're forever barred from coming. It's laid to rest. Okay, now the next section that we're going to get into is the quiet title. When you pay your instruments, if I give you some credits here today, a warrant or a draft, and you go down and pay off so-and-so banker, and you do not file your quiet title, you're likely to lose. You have to do this along with the payoff. This is what, it's Muscle Shoals County Court, it's a 3-page affidavit, quiet title. Why does this work? Because it's the king's bench in the exclusive realm. Remember yesterday where I said matters of right of possession of private property, it's an exclusive hearing? No titles of nobility can enter. This is between you and God. You say, I own this, God gave it to me, and who is to question? All quiet title is, I own it, who else out there thinks that they do? And you see why they can't? Because the book says we have no documents of title, and you can't have documents of title with bills of exchange because you haven't exchanged substance. It's an impossibility to have a document of title with no money. So then possession is 9/10 of the law. Guess who wins and guess who loses? This is all ex parte. Non-adversarial. When we filed the quiet title here on Richard Clark Place, the room you're sitting in, I was the justice of the peace. We signed it up and put it up in Hill County, where I was born, up in Havre, because they wouldn't publish locally. And the caveat on that quiet title said this: anyone failing to answer this quiet title and then setting foot on this property will be charged with criminal trespass, and the order is shoot to kill. And that never hit the papers. And only 3 people have trespassed out here, and there's the camera. We let them off easy. You better be ready to back it up. Otherwise, don't even say it. Just go ahead and be a slave a little bit longer. Okay, this quiet title, a 3-page deal. You call it Muscle Shoals County Court, or whatever county you're in, that's your King's Bench. That's the Supreme Court, the county that you live. You call it the country of Montana, or the country of whatever state you're in. It's a common law venue. Call it Supreme Court, small s on the Supreme there. Sitting with the powers of a district and circuit court in and for said county. That makes it a national forum. What a lot of people think U.S. District Court's all about. And then call it original and exclusive jurisdiction. We held the hearing before our justices, pro tempore. That's whoever you pick. Say you pick 4 or 5 guys and you say, this guy's pretty well learned in law, he's going to be that's my justice, my justice, my justice. That's how easy that is. Then we put it in all these counties. That's because 5 of us did this at once, and we all owned some land and property in those counties. That's why how come there's so many. If you were doing it just in the county that you live or where your property's at. The docket number now, that CL stands for common law. The LMS is my initials. The 95 was the year, and the 0010 is a random number that you pick when you open up your case. You can have 007 if you like it better. Doesn't matter. Okay, then you address it to the office of the Supreme Court Clerk and the office of the Supreme Court Justices. That's your buddies, who you pick. And the clerk there is the one that keeps the record. Then you address it to the other jurisdiction. And there, this is just a sample. This is to all the delinquents. And if you forgot any, you call it United States citizens. Because that's the democracy. Now, if you know their names, Judge so-and-so and Attorney so-and-so and Banker so-and-so, put their name down. But see, this is just a sample of who you could go. I mean, there's way, way more in the alphabet soup group. But that's why it was done, just as a sample to get you to thinking that who are the dependents. Then you publish this in the newspaper, and the cheap way to do it is to take the picture of the first publication, run it off on your Xerox machine if you want to, and mail it out to the major delinquents. That's good service. Especially if you say, by affidavit, I served him a copy by affidavit. That's good service at common law.
Would the newspaper have any reason to refuse to publish this information?
Not good reasons.
Okay, what?
You see, yeah, a lot of them will refuse. But when they do, you've got a new customer. See, they contract with county commissioners in every county. How can they discriminate even if you were 14th Amendment? Isn't that discriminatory?
Sure.
Well, you have more rights than the 14th. Take them down. Prosecute. Quiet title by affidavit. So then we had all our names on there, the 5 of us that did this. We quoted common law venue, Article 5, Section 26. And remember that's the one that I said, well, we create the laws, we create the rules. The Legislative Assembly cannot. They can't come into our court. So this gives you any kind of format that you like. You set the rules. Self-governing.
Is that Article 5, Section 26 be
In
for all
Montana.
states?
No, it's not. You have to look up the intent in Montana and find it. Texas is 356, I believe.
Article 5?
It'd be Article 3, Section 56 in Texas. Don't quote me necessarily on that. I think that's what it is. I've learned a few of the states, but I don't have that many memorized. But you got to get the concept. The Legislative Assembly will make no local or special laws respecting us in these various manners. That's what that one means. See, those are inherent rights, unalienable rights that God gave you to protect your sovereignty. That's why the agent can't rise up and create franchise. One of them is they will not make a franchise against you. Democracy is. But see, that's only for 14th Amendment. See, 526 protects the Republican form of government. Okay, now on the bottom, the last 3 lines are what we call quiet titling the body. All corporal hereditaments, all corporeal hereditaments, and all hereditary succession. This takes care of all the things God gave you. The corporal hereditaments would be if you, let's say you're a laborer, you dug a ditch with a shovel, and you sold the labor to feed your family. That's corporal, done by the physical. Corporeal would be if you wrote a book and you sold it. More of what you do in your mind. And hereditary succession is your family. Your offspring, your children. Can't be taken away from you, can't be taxed. That's an unalienable gift. Alright, so next page, we put in a non-waiver of extradition. This was just to show the system that we knew there were 2 states. Our state, which they call the asylum state, and their state, the demo state, democracy. 2 separate jurisdictions. Totally different venue. But notice there on the bottom of that, in the italics and the bold where I double underline, it says that the proceeding is not being instituted to enforce a private claim. Even if they come after you, the Attorney General from their executive state cannot come against you unless you've committed a common law crime, that you've been found guilty and you're running at large. So all this hype about, well, I got to get rid of my Social Security, I got to get rid of my birth certificate, I got to get rid of my driver's license. That's so much bogus BS. I've done all that. I did it because we're ingrained in it so deep. But by their rules, they can't hold those presumptions against you. They printed it, I didn't.
In other words, you don't have to.
No, you do not have to. Otherwise, they would be compelling you into contract. And the Constitution said they will not impair the obligation of contract, and they will not choose your association, your freedom to choose to contract or not. You see the concept? You can't be held to an unconscionable bargain. That's the wording in the UCC. They know it. The lawyers wrote this up are very deceptive, cunning, evil, wicked, demented. Are there any other a few others.
Know that.
Okay. All right, now on the quiet title, the last page, I'll just read a little about the caveats. You can be as strong or as light as you want. All private parties attempting to trespass on said private property owned by the state, in fact, meaning you, in the future will be summarily arrested with appropriate punishment commensurate with the crime and circumstances. Just tell them no trespass, and then enforce it. Okay, so much for quiet title. Now we're into the last portion of the pamphlet. I'm going to hurry through this. You're going to have to study these out on your own. Well, the concept here, I've got pulled quite a few codes out of UCC, mostly on the 1103. And the reason I pulled that one out, that's the one that tells you here's the exceptions. If you want remedy, let's go outside the code. Let's not stay in the code. Let's look at pre-code law for the remedy. So I'll hit on a few of them. 1103.29. That's the right of suit by accommodation. It said the accommodation party against the accommodated party is not exclusive. The accommodation party may enforce any non-code remedy available against the accommodated party. In short, that's the principle over agent. That's how simple that gets. It's gobbledygook to read it, but once you understand what the difference between the two, you'll see why they put it in there. Okay, let's go on down. Estoppel, 1103.32. Rights under the code are governed by the common law rule of equitable estoppel, which places liability on the person who could have prevented a wrong. Hence, the defense of estoppel is available under the code. Could the banks have prevented the wrong? Sure. Yeah. When you make a due presentment, they have to accept. Otherwise, they could have prevented the wrong by accepting. If they don't accept, they could have prevented you see it? They don't have any options. They're just betting you don't know how to present.
For general purposes of an treaty, the ABA or bound to are guilty of criminal acts and civil rights violations if they fail to take steps necessary regardless of what they are.
An easy way to say it is constructive fraud. But constructive fraud it's good for you, the accuser, because you don't have to prove criminal intent.
Because when there's fraud, moral turpitude is always part of it.
That's right. And fraud goes back nunc pro tunc. Or, that's not necessarily the right word, but it goes back to the point of inception. The day you find out fraud, it goes back to the day you found it. Because you couldn't have known it was fraud until the day you found out.
The day you
see, common sense.
License.
So your fraud on the IRS could go back to the very first day that you ever paid in. For every wrong, there's a remedy. Okay, next page. Let's look at some more. Okay, summary judgment there, 1103.5. It said the code does not change the pre-code law as the form and verification of affidavits presented in support of or in opposition to a motion for summary judgment. Next one, jury function. No change has been made by the code to the function of the jury. Execution, 1103.57. The code has not altered the pre-code law governing execution judgments. Assignments are execution. So you can do the assignment at common law. All right, let's turn the page. Next one is a good one of the best ones in the book. UCC 1103.6, common law. The proper way to read this is read the last one first, and then you'll get around the lawyer's gobbledygook. That's why I double underlined it. Let's read that. The code cannot be read to preclude a common law action. That's all they would have had to say. Now let's look how they mess it around. A statute should be construed in harmony with the common law unless there's a clear legislative intent to abrogate the common law. How could there be legislative intent if you didn't let them get past Article 526, which says there can be no legislative? See? Lawyers throw that in there to get you off track. The principle of statutory construction that a statute will not be construed so as to overrule a principle of established common law. And then they put this, unless it's made explained by the act that says, forget the unless. It has nothing to do with it if you didn't give up the common law. Okay, let's go on to contracts, 103.24. The general principles of contract law continue under the code. The code does not set forth the rules governing the formation and interpretation of contracts, and pre-code rules continue in force. You see why we set our UCC 4 true bill under the law of the place? The tenor of the agreement, when it comes under the law of the place, we said this is set at common law, that's how it will be adjudicated, and since common law is not adversarial, you win, they lose, case closed, and you never step into their courts. God had a simple plan. He is the one that created common law. That's where you should be. Get out of statutes. Look at this ambiguous part. It says when the provision of the code is not clear, the established pre-code law should be followed. Quite a bit of the code is not clear. So I looked at pre-code law, which I made much more clear. I says, you jump, and this is how high you jump. And if you fail, I will own you for this much. It's about how simple it gets. Okay, the next page, mistake. Code expressly preserves the law governing mistake. Jurisdiction, the next one down. The code does not make any changes to the jurisdiction of any court. Remember justices' courts? Just us? Okay, fraud. The code expressly preserves the principles governing fraud and misrepresentation. Right under it says, principles of estoppel and good faith underlie the entire Uniform Commercial Code. How about that? So when they don't accept the presentment and they send it back, that's not good faith, and they lose and you win. This is all one-sided. All you have to do is know how to present. Don't take no for an answer. Now, you've heard of Rule 7C where they said demurrers are abolished. Here it says they're not. It says the code does not affect non-code law governing pleadings. The code does not change the non-code law as to the sufficiency of a pleading to withstand a demurrer. The code does not change the principle of pleading or the nature and function of a demurrer. Demurrers are insufficiency in law. You're saying, wait a minute, in relation to my character, you forgot some elements here. I'm not 14th Amendment, I'm American national, and you must have money. And you said you don't have money. Therefore, you can't have me in your contract court because you couldn't even bond the action. Your filing fee is not even according to common law. Remember Mahoney, Peace River Township, and that case of Mahoney was the JP, wasn't it? And he got killed shortly after. He kicked the case up because he didn't pay the filing fee in gold and silver.
That's a Jerome Baker case.
Yeah, that's right.
So what?
It's Peace River Township, something about Mahoney, I forget the whole thing, but it's about, he stood up for the common law and then he was killed. Okay, next page. Look on the tort there. The code does not change non-code law as to tort liability. Tort means wrong. Tort can get into criminal. Okay, next page on criminal conversion. UCC 3419. It's talking about how the non-acceptance of all that. People have asked, where does it say the non-acceptance? Right here. Let's turn the page. I'll get into more of it. What constitutes a conversion? It's on the bottom of your page should be 30. Just in handwriting. Is that what everybody's got? You don't have page 30?
It's not marked.
Oh, yours aren't marked? Okay, well anyway, it's a section on conversion general principles, and let's look down under 3419.17, under A. It says non-return. The instrument's converted when the drawee to whom it's delivered for acceptance refuses to return it on demand. Then look at non-payment. It said the instrument's converted if any person to whom it's delivered for payment refuses on demand to pay it or to return it. They're kind of like you are stuck. Then, let's turn the page and look at refusal to accept or return. 3419.20. There's a conversion of commercial paper within UCC section 3419. When a drawee to whom it's delivered for acceptance refuses to return it on demand, or any person to whom the paper is delivered for payment refuses on demand either to pay or to return it. Non-acceptance is acceptance.
Well, if they return it, what?
Protest. Remember? There's three.
What were you reading?
Well, I was next to the last page.
Refusal of drawing to accept the return paper?
That's right. It was, I forget. Yeah, that's right. That's a good section there.
Yes.
The whole concept gets down to this. Remember the three things I said they can do? The first one you win. The other two, if you protest, you win. All three ways you win. This is very simple when you see it. I think a lot of people miss it by thinking it's complicated. It is not. When you understand that simple contract supersedes the Constitution, didn't they take an oath to you? Then bind them down with the chains of the Constitution. Hold them to specific performance. If they don't, you're injured. Okay, here, let's see, the last page. It says, refusal of the drawee to accept or return the paper, 3419.30. In effect, this makes him liable as if he had accepted the instrument, in spite of the fact that his act is not otherwise given the legal consequences of the acceptance. Toss out the notwithstanding part there. That's lawyer gobbledygook to make you think something else happened. Just read the first part. See why lawyers throw that in there? Always read the exceptions. You do not know the law until you know the exceptions. Look at the damages recoverable there under 3419.29. The measure of the drawee's liability is the face amount of the instrument. 100 million tendered and not paid for or not honored by midnight makes the bank liable at midnight for 100 million. Okay, that's the presentment on the UCC. You should have a little concept of how this thing works. And now, my part, I'm going to go on the other road. We'll start from the back to the front, unless some of the people have to get out of here in a hurry. And sometimes they got an airline or something that last time they did. Then those people that have to get away here early should stand up and so the other people can see and they can go first. Otherwise, we start at the back of the room, go out to the desk where I sit, and we will write out your bills, limited to 5 each. Anything over that, there's a charge, and husband and wife get 10, 5 for each, and have your figures doubled already, so I don't have to sit there and do it, and keep your stories brief. Just show me some of the facts, and away we go.
I got a simple question here. I did a little research. What you were talking about is I found it under 3502.
What part?
3502.
On what? Yeah, but what was it? I missed it.
It's a revised. Where you said that the bank doesn't review the check at midnight?
Yep.
Then it's held accountable?
That's fine. There could be many revisions. And a lot of the states, one state will kick one section, another state will kick another. It still doesn't matter. You can find the concepts in there. They're still stuck under simple contract. They're just betting you don't know how to present it and stick to the contract.
I don't.
Okay, that's it. You can take about a 10-minute break if you want to. Otherwise, if you're not ready for the break, we'll just have Rod come out and start. His is about a half hour long or so. What would you rather do?
What is it pertaining to?
It's just some more common law concepts, how to set up the contract. That's the main thing that he gets into. If you want, I'll send you particular subject. This is general information that I feel that everyone ought to know.
Okay. For sure, they get to recover their costs, and if they don't, they'll use the goon squad and come and take everything you've got. But here's what it says down underneath number 6. It says in an action to foreclose a lien or pledge. Now, that's what we're doing, people. We're foreclosing on a lien. We put a lien against their fidelity bond that they don't have filed, and then we declare their office vacant, and you have to do this to establish your credit. If you don't follow the steps and you don't get it in your head, how come you're filing a lien against these people? You might as well not even do it, because you're going to go straight to their slammer. And it's all being funded by the International Monetary Fund. Okay, let's go to the next page. 2510-105 says cost of review other than by appeal. County courts are the court of first and last resort. An appellate court is a voluntary court created by an agency, and you can go ask them. When you start asking them for permission, then you've just lost this theory of being a principal. You are part of them. Does the king go ask the servant for permission? Never. Never, never. Okay, page 13. When you get involved in this stuff, you're going to have people down your neck constantly. If they drag you into one of their administrative courts, you better learn how to plead. It is plea and bar form non judice. Took this right out of Valentine's law. Says basically the same thing as Black's law. And it's telling them that they have no jurisdiction, and you can start using their rule, which is UCC 1-103, principal and agent, because they have to use the commercial code, Uniform Commercial Code, as their common law, and it is recognized worldwide. That's how you bring it in. If you should happen to be drug into one of their courts, and you have one of these JPs, because in Montana it says you'll be taken in front of the justice peace immediately. Well, a lot of times they wait for 7 or 8 days, but evidently that's what they mean immediately. But if the judge says, I'm going to enter a plea of not guilty for you, say, thank you. Let the record show that my counsel has just entered a plea for me, and now I want to know who's going to hear the matters in this case. How you take care of it. You got to learn how to do it. See how simple it is? The only ones that can enter a plea is your counsel, your attorney. Now, we just got done reading that it says justices and judges won't practice law. They're guilty of what? You've got to hold them in contempt of court, but you've got to have your personal friend, and it's advisable to take several of them as notaries and take a tape recorder. A lot of times they won't let you take your tape recorder, but you can sneak them in your courtroom, or better yet, hold a court ahead of time, have your friends hold a court for you outside of this one here, and then when they bring it in, then have your notary bring in the conclusion of law and fact that there was no crime committed. There has to be an injured party. Okay. Arrest, I got kind of a kick out of it. The taking, seizing, or detaining of a person of another accomplished by 1, 2, 3. You got a multiple choice. It says by the consent of the person to be arrested. Has anyone ever consented to be arrested?
It's presumed.
Well, this is coming out of their book, but see, what they're telling you is, hey, you dummies, establish law in your court, just like God says. Then, I like that, ignorance of law is no excuse because it can be used both in civil and criminal cases. Highway patrolman says you've committed the crime of speeding. It's going to cost you $5. Is that a criminal matter or civil matter? Civil matter. That's commerce, right? Ignorance of the law is no excuse. You better learn how to do that. Okay, go to the last page in that bunch. We have up at the top, this is taken out Valentine's. Lawful man says this, and it also says it's basically the same thing in Black's Law. A lawful man is a free man. Now this is coming out of their very own book that is printed by lawyers for their benefit to read. My question to them is this. If I'm classified as a freeman, then I'm a lawful man. True? What are they? So now you can decide whether you want to be unlawful or lawful. I'm hoping that you all came here to be lawful men. And we can all start getting on the same level. I took of a natural person's rights, of a free man and of a slave. This was taken out of John Bouvier's American Law. And then down at the bottom I had to throw in what lawful money really is. Comes right out of their book. And this is a good place to start doing a lot of your research. If you don't have any other time, pick up a law dictionary and a good dictionary, and don't just take one, take several, and do a comparison. Because if it has been copyrighted and it has been put out to the public to read, it is presumed correct. And you can stand on that. Anyway, we're going to break for lunch. We're going to try and get back here by 1 o'clock, people. I was running a little bit late today. Normally get done by about 1/4 after. But let's hurry up and try and get through the line and come back here. Okay. You got them right there. Take one and pass on. Somebody on the front line is pass. Oh, I thought they were all mine. Okay, on this part of the notary, this is just, well, it's not even a tip of the iceberg of what you can find on notary. And you can find it in about any kind of a book. On bookkeeping, on law, any time that it's printed in a book. What I do when I get an old book in here, first thing I do, if it pertains to bookkeeping or anything like that, I look under notary, and I do that in the dictionaries and everything. But I also look under protest, anything that pertains to that, and you can also find it in a lot of old church law, canon law. Canon law is the common law, and it is recognized worldwide. That's what an ambassador is. Okay, this first page here, this is copied out of an old 1895 Britannica Encyclopedia set. And this is what we were basing on notary or notary public. That word "or" in there means that there's two different ones, but it says that they all perform the same function, but you got to understand what a notary is. A notary is from the private side, and the notary public can be appointed by a corporation. And when you take and read the rules in your statutes on notaries, you'll see the difference. Because one will contradict the other one, but it says they can do this, this, and this. But then when you talk to the corporation, then they put out a little booklet of their own and say you shouldn't do this, this, and this, but yet it's in the book that you can do this, this, and this. So now you've got to separate the wheat from the chaff. And in that first sentence that I have underlined, or first paragraph, it says, in the canon law, the notary was a person of great importance, and it was maxim of that law that his evidence was worth that of 2 unskilled witnesses. My first question is this: how do you become a skilled witness? You either did it or you didn't. Or you either participated or you didn't, whatever it should be. But canon law, I didn't know what canon law meant. Canon law is common law, God's law. And it's recognized world round. Okay, let's go down to the middle of the page. It says the most important part of an English notary's duty at the present day is the noting and protest of foreign bills of exchange in case of non-acceptance or non-payment. If you ever had a notary ever protest a bill of exchange, I never had. But that's their duty. That's where you can bring in that Rule 44.1 that we were talking about earlier today. Foreign law. You can do whatever you want to, as long as you don't injure somebody. You've got to be responsible for your actions. And I think we can all agree on that, unless we're greedy and a bunch of Satan worshippers. 44.1. Yeah, that was in the rules in your previous set of pages. Okay, now down at the bottom of the page it says, in America the duties of a notary vary in different states. Notice that's a large case S, states. You can take that either way. But what they're talking about, it could be an organic state or in a corporation state. That's exactly what it's saying. And they are generally as follows. Protest bills of exchange, draw up acts of honor to authenticate certified copies of documents, to receive the affidavit of mariners, and draw up protests relating to the same, to attest deeds and other instruments, and to administer oaths. Now that bottom part of your page there kind of gets blotted out. It doesn't work. But that came out, that particular paragraph right there came out of Bouvier's Law Dictionary that was inserted into the Britannica. So we have law in an encyclopedia. A lot of encyclopedias, you take and read it. I'd read it for a long time. I didn't understand. They have law in there. You can get a lot of law out of a dictionary. And you can get a lot of religion out of the dictionary. And now, Congress has said that we are a Christian nation and the Bible will be used. When they have you take and raise your right hand and swear, you know what that used to be? Put your right hand on the Bible and raise your left hand. Everything's 180 off from what it used to be. They've slowly but surely perverted this thing. And we've got to learn how to unwind this and go back to what our founding fathers wanted us to have and what God really wanted us to have, our right of inheritance. It was a God-given right, not given by the government. I can't give myself something. I'm the government back. The only way I can give myself something is go work hard for it. Do I go out and steal it? If I go out and steal it, what happens? That's what these guys are doing. Don't you think it's time they get punished? Okay, let's go to the next page.
How do you become a notary? I know how you become a notary public. You're appointed. But how about a notary?
You appoint yourself. We're going to get into that. Don't ask any questions until we get done, and I'll take a one-on-one. We can do it afterwards. We're going to run into Leroy's time, and he's got a whole bunch of good stuff to show you. Okay. This 1895 revised codes of Montana, this was right after Montana became a state. Montana came into the Union in 1889. And this is what it said then about the duties of a notary underneath 5. It says to provide and keep an official seal on which must be engraved the name of this state and county. The words notarial seal with the surname of the notary and at least the initials of his Christian name. There's the first place we see his. And I'm going to show you that it still says it today. It doesn't say hers or theirs or anything like that. It always says his. His. Well, I'm not going to argue that because to me that fits in with the Bible, that the women were put here as the man's helper. Don't give them the job of getting themselves in something that they can't prosecute. We don't call it defend, we call it prosecute. Another thing I want to bring to your attention in this one here, they have deleted the word county in the more recent codes or statutes, but it's still there. If you study the history on this, you're going to find out that it goes right back to this 913. Another thing, they have notarial seal in small case letters. Nowadays, when you see a notary seal, it's always done in caps. Large case letters. The reason for that is that belongs to the corporation. And it says notary seal on a good majority of seals. They can have it either way, but it doesn't make any difference. I had mine done in the small cap notarial, and then the company chose to make seal in the large case seal letters, all capitalization. But I have my seal with the county, Petroleum County, Montana State. This is where I'm drawing my bases, and I'm going to show you why I did it that way. Because it says in the rules, and you got to separate all of these rules. Corporations only have state of Montana. They don't have Montana State. Right here it says that I can have it either way. Okay, 914 it says the protest of a notary under his hand, an official seal of a bill of exchange or promissory note for the non-payment or non-acceptance. What I'm trying to bring out there is that this here concurs with the 1895 Britannica. But then when it goes on down below, it says as prima facie evidence of facts contained therein. When you get to studying in this, when it has a notarial seal put on any document, it is gospel. Canon law. You don't lie. That's how simple it is. It says so right here in the Montana Code Annotated. Okay, and then at 915, it is the duty of every notary, blah, 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 and then it says, deposit all records kept by him in the office of the county clerk of the county in which he is a resident. I'm going to ask you this, how many times that you've had something notarized that the notary kept a copy of what he notarized? Never. You do that. It's still in the rules today. I have done all of this research on studying notary, and Leroy found a box the other day that somebody had brought into us. It came out of Anderson's. It's the same as this Anderson's Uniform Commercial Code, the same company. It's an Anderson's on notaries, notary public. And everything that I have researched in Montana, they have it right in there. Would have cut down a whole bunch of time. But it was a good experience for me. It was a lot of hard work trying to sort all of this out. But now, I've got it documented by a law company. And I presume that it's correct. I drew my own conclusion. We're going to get into that tomorrow in a workshop. I have a bunch of copies of that. Anybody that wants to participate tomorrow afternoon after Leroy gets done with You'll get done, and then Dale will give a little bit more, and Rod will give a little bit more, and then I'm going to kind of have a workshop. Anybody that wants to learn a little bit more about this, we can talk about it, and I've got some more handouts. Not everybody wants to do it, that's fine. But what we'll do then, we'll have Leroy take care of your personal matters, so some of you are going to miss out on it, so you might want to buddy up just a little bit. Okay? Let's go to the next page. Page 3. Part 4 up the top. This came out of the 1991 edition of the Montana Code Annotated at 15401. It says appointment. A governor may appoint and commission as many notary publics for the state of Montana, and notice the small case state of Montana, they're talking about the corporation as in his judgment may be deemed best. They're talking about the corporation there. And he's talking about notaries public. Now, I just showed you a little while ago where they're bound by common law and by statutes. This here's a statute. Now, the common law is the law that I bring out. And it says notary or notary public. So you can start drawing your own conclusion. Now they have changed this. In 1995, they went to the Secretary of State may appoint. We have a letter from a friend that's from our governor, Mark Roscoe, and he says, I am pro tem governor. Pro tem means he's holding a temporary position. The United States corporation has been divided up into 10 regions. That's where zip code came in, municipal law, corporation law took over, and they are trying to abandon all of the states as they have with the counties. They abandoned all of the counties in the state of Montana in the 1920s and 30s. The reason I can prove that is because in the Montana Code Annotated, they have two pay scales for the county commissioners. One is $25 a day and one's $80 a day. There's two sets of laws in your rule books, at least in Montana. You might want to go research it in yours. But if they're doing it in Montana, we can just about bet that they're doing it in every other state. Okay? 15403, it says term of office. This term of office of a notary public is 3 years from and after the date of his commission. Now, we talked about a little bit ago, that was an odd number. Notaries are always appointed. They have changed that now and went to 4 years, and I'm going to show you that. I think I have it in here where they've done that in 1995. They changed it to 4 years. They're eventually going to start trying to elect notaries so that they have full control over them. But I'm also going to show you that in notarial acts that they've started inserting in 1995, I just showed you a little bit ago, some of where they're starting to agree with us. They put in about 5 or 6 pages in 1995, now that we've been hammering on them, and the commission of a notary can be for life. They're agreeing with what we're doing. They're trying to cover their tail on a lot of this stuff because we've already charged all of these de facto corporation officers with treason. And they're going to be like Henry Plummer, the road agent, the sheriff down in southwest Montana that was stealing all the gold from the miners until they finally got tired of it. He begged to have his tongue cut out, to have his hands cut off. And it happened in January of, I think it was 1897. And he said, would you even take my clothes and let me go out in the cold? And then just before he hung, he said, you wouldn't hang a duly elected sheriff, would you? He didn't. That's what it's going to take here, guys. That's why we have this up here. It's for real. I don't care who knows it. Treason is punishable by death, by hanging in Montana. It's more severe than cattle rustling. They think this is a big joke. No, it's real, guys. I don't care whether they know it or not. If there's any informants in here that want to go tell, geez, don't let the door hit you and hurry up and get it done. I'm going to be the old boy that's going to be standing there. I'm waiting for that guy to say he wouldn't hang you, the elected county attorney now.
Yep.
Okay. 15407, certifying the official character of a notary. The Secretary of State may certify to the official character of such notary public. Now remember up here they were being appointed by the governor. Now the Secretary of State, he does the appointment and he also certifies to the official character of the notary. And then it says, any notary public may file a copy of his commission in the office of any county clerk of any county in the state, and thereafter said county clerk may certify to the official character of such notary public. Now here's the way I did mine, people. I certified into the county, the clerk and recorder's office first. I went exactly backwards of what they're telling you here. And the reason I did is because I'm on the notary side, not the notary public. I did it this way, and I deposited $500,000 off of my current credit, my default, with the clerk and recorder, and I used a $2 postal money order. And the reason I used a postal money order is a pay-to item, and they can't take that and go out and roll it. And besides that, I wanted to make sure that I was fulfilling a contract. If I would use a Federal Reserve note, I would still owe it. If I paid by a personal check, they could go out and roll it, and I would still owe it. It's paid to the order of. I was tired of their check kiting. I used a personal money order. So then what I did in there, I put a precipice, and it's all in this, but we're going to kind of go over it now. It's all in the paperwork here. But I put a precipice to the clerk and recorder, and I told her to send to the Secretary of State a copy with her file number on it, with the $500,000 that I deposited with them, and I also inserted a $2 postal money order to the Secretary of State in a self-addressed stamped envelope. Because here's what it said. Well, I already got done showing you where it says that the the notary public must deposit his records with the clerk and recorder after his death. Well, I keep the records. I keep the records at my place. All she has to do is take and put her file number up in the corner, wherever they want to do it, I don't care. Put the file number on here, on his, and the file number on hers, and then forward it on. All of this went on to the state of Montana.
Why did you give $500,000 instead of the $500,000?
Okay. The reason I did that is because I don't want to cheat anybody. They don't even recognize the $5,000. And besides that, it's not money, it's credit. I've got over $600 million on one lien, and I've got over $321 million on another one, and my wife just got $5 billion on another one, so I've got plenty of credit. And besides that, here's how I was going to help fund the corporation. What is the going interest rate today? 8.5%. Okay, but let's say 5. Okay? If I took 5% of that, I'd have what? 25,000? At both places, right? So the total 50,000? Okay? I'm a nice guy. You can see that. I was going to give them 1/2 of that interest because I told this clerk and recorder to make a deposit with that. It's a bond. And a bond has to be deposited in an interest-bearing account. What they have to do, showed you in that Rule 67, still works in everything else. I didn't tell her Rule 67 because I figured that she has a little mentality. She should know the law. Ignorance of the law is no excuse, you know. So I was going to take 12.5 for myself from the county and the state, and I was going to leave the rest in there to fund the schools. Now, on my private property over there, they've been sending me these bogus assessment deals, and it's been running about $2,300 a year for my bogus, I don't know what it is, it's just they're trying to steal some credit from me someplace. But see right there, if I deposited that, then I wouldn't owe this, right? Besides that, I could take care of, like my parents live there, and they've got property about an equal value with mine. So I'm assuming there's about that much, so I could take care of theirs. Then I could take care of maybe a couple more. But now let's use this. How about if the county commissioners would do the same thing? They're supposed to be reputable people. How about the county treasurer? How about the clerk and recorder that we're talking about? How about the secretary of state? And it's a requirement in the codes in Montana that they all shall be bonded. And if they had any concern for their country, don't you think that we could alleviate and get rid of all of these taxes? Now, I'm not a tax protester because I like nice roads and everything. But I'm damn tired. I can't pay for it, people. Can you? And see, that's what they're trying to do. They're trying to pit me against you or you against me, that I'm not paying my fair share. Man, I pay all kinds, and I've got a plan right now that's going to beat any one of theirs. They should love me. Because it says in Title 2, in Chapter 9 of the Montana Codes, and it starts out in Section 5, 6, 7, and 8, city and county, or city and towns, all appointed and elected shall be bonded. All county elected and appointed shall be bonded. All state elected and appointed shall be bonded. But guess what? Then when you get into Title 28, it's at, I think the number is 1737. All federal agencies have to be bonded. So, if they're not bonded, and then in Montana it says if they're not bonded, then their offices is declared vacant. But if nobody comes up and says, hey, you don't have your bond in there, they're going to continue on, aren't they? You've got to bring it to their attention. Are you the king or are you the servant? No, I'm the king. Another reason I sent it to the clerk and recorder is because I went to school with this gal. She knows my character better than the Secretary of State. I've been up to see him a couple of times, and I don't think he'd recommend me. But it doesn't make any difference. He's a corporation officer, and I'm not a part of the corporation. I appointed myself out of a matter of necessity to redeem the Republic of Montana. Because I'm guaranteed a republic, not a democracy. I've also got some stuff back there that we'll be handing out in a workshop. A friend of mine brought it over here a couple of weeks ago. It's What's Wrong with the Democracy? It's about 4 or 5 pages long. Good reading. For you beginners, it's something, a lot of you old-timers know the difference. But another place that you can really find out is to go to their law dictionary and look up the difference. Yep. Okay. 15408 in Montana shows that you got to pay $2 for your filing fee. Some states, in this Anderson's book that I've got, can go as much as $100. Now, for your bonds, there is a way that you can get your bond before you leave here. Thank you. I'm not here to solicit anything. I just wanted to find out who's going to catch on. Yes, you can get bonds from here. we will bond notaries. That is counted in one of your 5 free. Anything over 5, of course, you guys know, you pay $100 a piece for it. You do have a limitation on 5, so you might want to think about that. But we do put up the bonds. 5 checks. We don't give a dollar amount, but we bond everybody for $1 million. And the way we're doing it right now, we're just doing it at the county level. All we have to have is the name of your clerk and recorder, or your recorder of deeds, and the county. And we make it out to them, and all you do is submit your paperwork and give it to them. And do it with, you got to use the post office. Post office is a national site of banking, by the way. That's something else that you can go into. There's all kinds of little things that you can do for the beginning. A lot of you people that already know about it. Okay, let's go to page 5. Up the top, we have 1947, Revised Code of Montana. And this is what it has to say under powers and duties of a notary. Under 3, I've got it underlined, to take depositions and affidavits. And I have written out to the side Rule 28C, state and federal. It is in the state rules and it's in the federal rules of civil procedure on depositions. Now let's look at number 5. We have this underline and it says to provide and keep an official seal upon which must be engraved the name of the state of Montana. Remember what it said a little while ago? It said state and county. All right, then they changed that in 1895, and now it's still in the 47s. But then they have the words notarial seal, and they have the first letters in large case letters, and with the surname of the notary and at least the initials of his Christian name again. Of his Christian name.
Does that mean the same thing? What is the same thing?
Okay, in the 1991s it says his given name. Okay, you would have to go back to page 4. Maybe I jumped over the top of that. But his given name over there, it was still a Christian name, and my Christian name is done this way. You put a period and a comma. This indicates then my family name.
You also put a period on it if you spell out your name.
Period? Huh?
You also put a period behind
If you spell your name out, I don't have a full name. I choose not to use it anyway. Because there is no birth certificate on me. There better not be. I can change my name if I want to, too. If I'm the king, I can do anything I want to. Okay. Now, under that 56104, look under the cross references over on the right-hand side. It says, power of notary public to take affidavit as basis for warrant of arrest. Ever heard of a notary signing an arrest warrant? All right. And this old book, Murphy's Law, right here, Murphy's Justices. Justices of the peace and notaries are synonymous. Okay, 233003, deputy registers. Number 1, all deputy registers, or all notary publics are deputy registers in the county in which they reside. It says all of them.
What is the last part about the arrest and now you're...
What do you want?
Where you said the notary had the powers to arrest, what section of that on this?
It's under 56104, 1947 revised codes under the cross references. Did everybody find that? It's on page 5, on the right-hand side. It's underlined.
The third line is exactly right.
They were missing 5 on some of ours.
Yeah. Go to the next page.
These are missing page 5.
All right, go to the next page. There's 2 5s in there.
Well, maybe go to the next page, I don't know.
I don't have 5.
Okay, mine have 2 then. Yeah, I didn't have what
Well,
I...
we've had some problem with the collator. Anyway, you can get with some of the people in your party, or afterwards we can get them. But it's in there, people.
The last page, Mike.
Okay? Let's go to the next page. Next page up the top, we have the 1995 Montana Code Annotated. Proof and acknowledgement of instruments. We've already looked at this just a little bit ago. 15608 Foreign Notarial Acts. This is the section that they're inserting now in the Montana Code Annotated. After we chewed on them long enough, they're starting to put this stuff back in the books. A lot of times you'll find reserve. They've taken all of the venue statutes out of the revised codes too, and I think we're probably going to find the venue that are going to come out of the reserve. I went up and talked to the Secretary of State about this one time, and that's probably why I wouldn't certify my character. But I wanted a copy of all of the reserve codes. He told me it cost me 50 cents a page. And I said, well, I said, it's already been paid for. I just want it. Well, he didn't do it, so he got a wing. Okay, we'll go down to number 5. It says an official stamp or seal of an officer listed in subsection 1A or 1B is prima facie evidence that that person is entitled, with the indicated title, has authority to perform notarial acts. You understand what that's saying? An official seal, stamp or seal of an officer listed in subsection 1A or 1B. Now, if notary or notary public are appointed and you have a stamp and you stick it on a piece of paper, it's prima facie evidence that you have authority to do it. Again, then that would bring in Article 2, Section 2 of the Montana Constitution, where it says people reserve the right to govern themselves as a free, independent, sovereign state. See, now you can start tying the statutes that fit you, or the common law, you can fit them in into the Constitution. Fits right in with your rights.
Did the legislature pass a resolution here?
The what? It doesn't make any difference. I don't care what they do. It's what I do that counts. Okay, the 11th Amendment is just as important. In fact, it's more important. 15609, Certificate of Notarial Acts. The certificate must include identification of the jurisdiction. I use the common law jurisdiction in which the notarial act is performed in the title of the office of the notarial officer and must include the official seal of office. If the notary is a notary public, now, if the officer is a notary public, I'm going to tell you something. This is where it starts coming in. When you start researching, you'll find that another officer, such as a justice of peace, can be a notary. A counselor can be a notary. A vice counselor can be a notary. A charge d'affaires, an ambassador. You can go on and on and on. It's giving you a clue right here. It says the certificate must also indicate the date of expiration, comma, if any. I appointed myself for life. It says if any. Okay. Of the commission of office, but omission of that information may subsequently be corrected. They threw that crap in there for filler. Words of art. That's what the lawyers call it. Words of art. Okay. Let's go Go to the next page. Up the top, we have Rule 28. Persons before whom depositions may be taken.
Now, is that MCA?
This is Rule 28C.
Is that MCA?
Montana Code annotated, and that's also in the federal rules under Rule 28. In the Anderson's Law, it says Rule 28, and it brings all of this in, but Rule 28C locks out all lawyers and all judges.
That's both federal, what's the C?
State and federal. Look it up. It says, no deposition shall be taken before a person who is a relative or employee or attorney or counsel of any of the parties, or is a relative or employee of such attorney or counsel, or is financially interested in the action. That just eliminates them. And I have shut down banks that have called people in to take depositions and reminded the lawyer of this. Then they take and drop all charges for about a year and a half, and then they come back and slam dunking the guy as if we forgot. No, we didn't forget. It's already been established. But see, in this game of the corporation law, folks, there is no rules under the Emergency War Powers Act that Dr. Gene Schroeder is talking about. So all of this stuff that we're doing ties into what he's doing. And we've got to take a look at everything that is going on in America today. Because there is a lot of interesting stuff. There's probably a lot of knowledge sitting in this room. I know one man sitting here at the corner that has brought us some interesting stuff today, people. It's another piece of the puzzle. We don't have the silver bullet, but we're closer than anybody else. We are getting refunds and we have proof. It doesn't happen every time, but it's fun. It's fun to watch the other side run. Okay, under the 1937 American Jurisprudence book, at 707 it says, officer or person making protest. In case protest is made by a notary, it must be made by a notary from a county in which a bill or note is payable. A protest made by a notary from another county has been held void. The reason I have this one in here is to show you that that backs up on my seal. It says county. And that there's a difference between a notary and a notary public. But they can still be one and the same. But a good majority of the corporation people that are notaries would not go out and do a protest because they might lose their appointment. You know, well, anybody that is a corporation notary right now, what they ought to do, they got an inside track, and that is appoint themselves and go ahead and stay on the corporation side, but appoint themselves on the common law side too. That would really throw a twist in their rider. Okay, go to the next page. Next page is starting out. This is some of the forms that I use, and I've learned a lot since I've done this, but up at the top now I've got the country of Montana and Court of Common Law Supreme Court. What you might want to put there is Counselor's Court. Just a suggestion. We have this book here. It's the 1934 edition of the Code of Laws for the United States of America. And they have the Counselor's Courts in there, which today is called International Court of Trade, we think. We have a friend here who is going to do some research for me. I hope I can get him talked into doing it. And, but that would be a good research, and if you can do it, I would appreciate the knowledge. Because I'm quite positive that the Court of International Trade right now is going to be the counselor's court. The Court of International Trade, when you get to reading that, and that's in Title 28, is the exclusive court, and everybody thinks the Court of International Trade would be over in Japan or something like this. No, it's between the organic state and the compact party state. You got to really read that thing over and really research it out, but that's where it lies.
Now, Dan, go over that one more time. You believe the International Court of Trade will be the counselor's court?
Was originally the counselor's court. Yeah.
We've heard it both ways. We've heard International Court of Trade and Court of International Trade.
Okay.
Are they both the same?
They're both the same.
Okay.
Okay, I put in all of the rules that I was relying on and all of the codes. And I also put in the Bible, Acts 5:29, Magna Carta. So you can put in anything that you want. If you can find something better, do it. When you learn to govern yourself, you can do anything you want to. And this here really binds it. Then, in my oath of office, I done it a little bit different than anybody else. I know that you're not supposed to take an oath, but I'm not going to argue with them. I did mine different. It's always bugged me that these public servants, at the end of their oath, they say, "So help me God." I started mine out with "So help me God," because He's my creator. And so help me God, I, Daniel E. Peterson, declare under the laws of God that I will protect and defend the rules of man and the laws consistent with the Holy Scripture. And I was going to put, so help me God at the end, because God says He's the Alpha and the Omega, and I believe that He is. So you can do anything that you really want. But then I put a stipulation on them too. Under my signature, I put this affidavit, oath, and special bond of self-appointment for notary public shall not be open for objections to anyone of any character whatsoever. Any objections? Thank you. We've had probably about 1,500 people come through this class, and I have asked for an objection. Nobody has objected yet. So now when it goes out on these video camcorders and whatnot, now it's public knowledge. And nobody said that I couldn't do it, so I'm going to continue on. I also had Leroy, Rod, and Dale witness this, but I did provide them with a copy of the seal. I sent it to both the clerk and recorder and the Secretary of State, I sent everything to the clerk and recorder, but told her to forward it on to the Secretary of State. But also, in the precipice on page 9, I also told the clerk and recorder to post that at the post office. I doubt if she did it, but I really don't care. If she doesn't follow instructions, she could be liable for 3 times this amount, $3 million. Because if clerk and recorders in Montana don't do what they're told to do, it's triple the damages to their aggrieved party. So as you can see, if she didn't do it, now this rate just went up and I can take care of a whole bunch of people. Okay. We'll explain that writ of precipice. In the old days, it used to be a writ of precipice in chief. That meant that it's coming from the boss, the king. It's, in the later form, it's writ of precipice in capite. Everybody's probably heard that, the Latin word. But in chief, that meant that that was coming from the boss. And then I have my docket number. My docket number, the CL stands for Common Law. DEP, of course, is my initials. It was done in the year 95, and it was docket number 25, 0025. So when you start doing this notary stuff, get yourself any kind of a book and write down what you've notarized. Kind of keep a record of it. It says you're supposed to keep a record of everything you notarize. I do. Because then I take it and I take it over to Rod Skirdahl, who is the clerk and recorder of Justice Township. I've always got the original copy right in my hands. I don't want to die and not get it done properly, so I followed all of the rules. Okay, go to the next page. This is a copy of the old certified money orders that we used to put out. And this was drawn on Norwest Bank of Anaconda, Butte, Montana. Since that time, we had a friend that was posing as Leroy's counsel who talked to Bruce Parker, the president of Norwest Bank in Butte. And Bruce Parker said that, informed this feller that that account had been sent to the authorities. What authority? The comptroller of the currency. Thank you. So that's why we have comptroller's warrant on it now. We don't know whether he's lying then or not. Another thing that I have available for you that'll be with this notary packet, we got a lot of people that are calling in here. They're kind of skeptical as to whether that account was ever opened the way that we said it was opened. It was opened by Paul Hatfield for Leroy in U.S. District Court in Butte, Montana on a traffic deal of $100 Federal Reserve note. Paul Hatfield ordered a bank deposit interest-bearing account open. He done it. Now the papers have been shredded. But we're going to have a copy of this. Anybody that wants it, and take copies of it and spread it across the United States of America, because what they're doing right now, they're saying, this is all a bunch of crap. We're just dreaming stuff up. Through their own demise, they're going down the tube. What I did with my certified money orders at that particular time, too, Rod Skirdahl is a notary, self-appointed the same way that I am, and he done my protest right on the check. He gave them all, in fact, that was a court hearing right there, if you want to look at it that way. That was a deposition that told them where it was, everything about it. When you get to studying, you'll see it. On page 11, I knew that possibly this clerk and recorder, she's a little bit reluctant to do anything for me anymore. So I published it then in the Lewistown newspaper, which is about 50 miles west of where my mailing location and my domicile's at. And I ran it for 1 week, but the publisher screwed up and he spelled rules, Riles. Whenever that happens, you want to read everything over carefully, and then you get on the phone and give them a call and tell them to publish it again at their nickel. So I had it done 2 weeks.
But did you feel like 1 week is sufficient?
Yeah. Just make it public knowledge. Or you can go nail it on a post or do anything you want. On this next page is recorder office products out of Billings, Montana. Up until about 1 week or 2 weeks ago, they were making stamps for people in other states. Now they claim they're only doing it for people in Montana and Wyoming. The reason I had this in was because a lot of the people were saying, well, they won't do it for me in my state. My suggestion is anybody that impedes commerce and says they won't make you a seal, and if they have a shingle saying, we make seals, lean them up. Tell them, you'll either make me a seal for $28.80 or I'll own you for $100 million of current credit money. heating ponds. If you have any friend that makes seals or works at a foundry, it might be a good business for one of you guys to get in. One of you that feel like you don't have anything to do. Because if somebody will get it and start doing it right, and you let me know about it, all the people that come through the class, all we do is take your name and address and phone number, and I'll get it on. I might even do it, hell, I don't know. But I just got a milk cow the other day.
What have they been charging on it then? $28.80. See, because I don't know if anybody's checked, I called down in Utah, and I said, look, I'm interested in how much it costs to get another seal. What do I have to do? Well, you have to get a certificate, and they require a certificate from the state or the county before they'll do it. So, I called all around town.
But now I just showed you the law, that there's no appointment in Utah in any of those places.
No, I understand that.
Okay, now you can really have some fun.
Well, see, what I'll do is I'll get a copy of that sheet and take that back with me, and then I'll take it into one of those, one or more of those companies.
Yeah. See, there's all kinds of interesting things that we can do, but if we sit back and don't do anything, we get run over. Okay, that's all I've got. Leroy will probably be with you in about 10 minutes. I want to thank you people, and anyone that is interested tomorrow in a little bit of notary and whatnot, you can set in. It's just going to be kind of a wide open session, and we can do a lot of answering questions and whatnot then.
Shut that off.
Do I want to? Oh, I was just going to walk up there.
Get the one that embosses that they say, well, you can't use codes. The only reason we're using the UCC code is to show that we are not under the code.